the version that you gave us was a version that was unsigned, and then we asked if you had a signed version, and as we understood it from your representative, Ms. Mbanjwa, you didn't have a signed copy to hand, is that right?
That's correct.
So we managed to get a signed copy from the DTI, so I would like to just beg leave to hand that up if I may. Chair, I suggest that we market exhibit DD 33.22 because that will be the new numbering. And then if I could also ask if we could just hand one to the legal representatives and Ms. Kwinana. Thank you so much. Ms. Kwinana, please feel free to take a moment just to take a look at this. This you'll see on the last page of the document.
Just 1 second, Ms. Hofmeyer, you were asking me to admit this as exhibit BB 33.2?
Sorry, point 22, apologies.
22?
Yes.
Okay. The Memorandum of Understanding between the Department of Trade and Industry and the South African Airways.
Chair, we might want to say signed on 18 May 2015, because that's the signature date. Sorry, it's on the last page.
I'm looking for the date here. Signed by, did they sign on the same date?
There isn't a date filled in by Ms. Mieni, but there is actually later correspondence that refers to the 18th of May, so I'm fairly confident.
I say the Memorandum of Understanding between the Department of Trade and Industry and the South African Airways, SAAT Ltd, signed by Mr. Mzwandile Masina, Deputy Minister, on the 18th of May 2015, and signed by Ms. Dudumieni, Chairperson of the SAA Board, is admitted as Exhibit BB 33.22.
Thank you, Chair. I'm indebted. Ms. Kwinana, have you had a chance to look at this version?
Yes, Chair.
Thank you. So if you could just tell us what role this Memorandum of Understanding on your version played in the 30% set aside.
This memorandum, if you read in the record...
Maybe shall we start with getting clarification whether it's exactly the same as the unsigned one that she provided, or are there differences?
There are some differences, yes.
Yes, material?
Yes.
Oh, okay, all right. No, I just wanted
So why don't you give me both of them then?
I said where the other one was. It's your annexure to your affidavit. It's tab 2 at page 11.
I interrupted while Ms. Kwinana was trying to answer a question. I'm sorry. So you can continue, Ms. Kwinana, with your answer.
Chair, considering the fact that Ms. Hofmeyer is saying there are material differences between the two, can she point it to me, those differences, so that I can be able to respond?
Okay, no, that's fine. She will do that.
So you see, the challenge we had when the unsigned version was provided as an annexure to your affidavit was that on its face, it appeared to be incomplete. And I'll give you an example. If you go to page 15 of your bundle, DD 33, and you look at clause 4 there, 4.1.
Sorry, the reference again?
Page 15 of Exhibit DD 33, which is within the Memorandum of Understanding that Ms. Kwinana provided to the Commission. Admittedly, she confirmed she didn't have the signed version. But this version, do you see on page 15, at clause 4.1.5, there's a question mark.
Page 15, 4.1.15.
Do you see that there's a question mark there?
Yes.
And then also further down on the page, you'll see at clause 4.2.6, it's open, it's left blank. So when the Commission received this from you, our impression was that this was unlikely to be the final version. Would you share that impression?
Yes, Chair.
Yes. So when I say there are material differences, they're differences because this, I think we can all accept, is a less than complete version, and then the signed version that we were able to obtain is the completed version. Do you see that?
Yes,
If you'll
Chair.
just say yes, thank you. So if I could then return to my question, what role...
Sorry, before you go to the question, are you saying those are the only differences between this signed version and the unsigned version?
Yes, the clauses that seem to have been not completed on the version that you provided to the Commission are then filled out in the signed version.
I see, those are the two differences.
Yes.
Okay.
Thank you. So if we can return to the question, what role did the MOU, in your understanding, play in the 30% set-aside policy?
Maybe
Then I
before-
will stick to the unsigned version, which I saw. Can I quickly read it?
Oh, well, that's what I wanted to find out, whether you ever saw the signed one.
No, Chair. I will stick to the unsigned version that I submitted.
Yeah, but did you never see the signed one before? Is
No.
it the first time you see it?
Yes, Chair.
Oh, okay. I just
Ms.
wanted
Kwinana?
to clear that.
Are you sure that you didn't see the signed version? Because if you're not sure, you may want to say you're not sure.
Yes.
But if you are sure, please do tell us. You're
Yeah.
absolutely sure you didn't see the signed version.
I'm sure I didn't see the signed version.
Okay.
I'm sorry, what was that last sentence? You did not?
Chair, I didn't see the signed version.
Okay,
I
all
will
right.
stick to the unsigned version.
Okay, all right. Do you want Ms. Hofmeyer to repeat the question? Or you still
Can
remember
she
it?
allow me to read the unsigned version first? Because I was reading the signed version, Chair. So can she allow me to read the unsigned version, and then she repeats the question after I have read the unsigned version?
But you would have read the unsigned version when you attach it to your affidavit.
Yes, Chair, I want to read it again.
Sorry?
I want to read it again, Chair.
Was the question, Ms. Hofmeyer, how the MOU influenced her decision or the court's
It
decision?
influenced the 30% set-aside
Yes.
policy because I understood her affidavit to say it did.
Okay, have a look then, Ms. Kwinana.
Thanks, Chair. In fact, Chair, all this recordial from number 1 to number 7
On the unsigned MOU.
on the unsigned MOU
Uh-huh. What about it?
supports the black economic empowerment, basically. Now, as I said in my affidavit, the 30% set aside is intended to make sure that it bridges the gap between the blacks and the whites, so to say.
Yes, but I'm focusing in on the 30% set aside. Where in this memorandum of understanding is the 30% set aside identified?
It's not going to talk about the 30% set aside, as the other companies implement 51%, the others would implement 30%, the others would implement. So basically what this means is the guideline and then the implementation. Therefore, the 30% that we were talking about at SAA is the implementation of this MOU.
Ms. Kwinana, is it your evidence that when in other SOEs there was a focus on providing opportunities to bidders or suppliers who were 51% or more, let's call it broadly black owned, That was the same as the 30% set-aside policy that SAA adopted.
It may not be implemented exactly the same, but the end result, I would think that it is intended to achieve the same objectives.
Yes, but the implementation is quite important because as I understand, and it's reflected in the name, set aside. The idea, and we've had evidence on jet fuel and how it played out in jet fuel, and we've had evidence on how it was playing out in Swissport, was that 30% of contracts would be directed to those who qualified for being BEE partners of the main contractor. Have I described it accurately?
How we intended to implement it, if we were successful in implementing it. Remember that we were not successful in implementing this 30% set aside. And therefore, if we were successful, this is how we would like it to be implemented.
Yes.
We would say, for instance, cleaning has been done by a white-only company previously. And then we would say 30% of that cleaning, when the tender comes, 30% of that cleaning should be set aside so that black people can participate in the 30% set aside. That is how we intended to implement it, had it not been met with resistance.
Right, and it was met with resistance. We'll come to that in a moment. But do I have your evidence to be the MOU itself doesn't speak to the 30% set aside? Is that correct?
The MOU talks about the promotion of economic opportunities to previously disadvantaged South Africans, which basically would be implemented by putting aside the 30%.
Yes.
So basically, much as it does not talk exactly about the 30% here, but the whole aim is exactly the same.
But you faced resistance both from National Treasury and from the DTI when you tried to implement the 30% because they said that would be unlawful, didn't they?
Yes.
Yes.
Yes, sir.
And part of the reason I suggest that they would have said it was unlawful was because of a term of the MOU that was signed. So let me take you to that, if I may. It's the one that we've handed in this morning, and that's been marked as Exhibit DD 33.22. You see those clauses that weren't complete on the unsigned version that you gave us are completed on the signed version, and you'll find them at Clause 5, which is headed Obligations of the Parties.
Sorry, 33 point?
Ms. Kwinana, it's the document handed up this morning, so it won't be in your file.
The signed one,
Yes.
the signed one, yeah,
The
clause
signed
5.
one, and you need to find Clause 5 in that agreement. Do you have it?
Yes, Chair.
It begins at Clause 5.1 with the DTI's obligations, and then at 5.2, it sets out SAA's obligations. Do you see that?
Yes, Chair.
And if you go over the page to Clause 5.2.3, could you read for us what is recorded there as SAA's obligation?
Engage with suppliers who have expressed an interest in supplying goods and services to SAA within the selected product categories to gain insight into challenges experienced and to expedite resolution to such challenges. All such engagements remain subject to SAA's supply chain management policy and due procurement processes.
So it's based on that clause that I say the DTI and National Treasury regarded the 30% set aside as unlawful. Because what SAA was obliged to do here was to comply with supply chain management and due procurement process. And as I understand the advice that SAA received from National Treasury and the DTI, the Section 30% set aside policy would not be in line with those requirements. Is that your understanding as well?
Yes, Chair.
Yes.
1
So,
second, Ms. Mbandra.
I just wanted, thank you, Chair. If Ms. Hofmeyer could also read for the witness paragraph 5.24 of the document. Thank you.
paragraph 5.2.4 reads, review existing contracts of SAA in order to develop a transformation roadmaps for selected procurement categories. Do you have a comment on that?
No, Chair.
Thank you. So we have the same understanding of National Treasury's basis for resisting the 30% set-aside policy. If that is...
1 second, Ms. Hofmeyer. Ms. Mbandra, with regard to that, when you re-examine, you could say, when Ms. Hofmeyer read to you, this is what she read, but read this section and then see what the witness has to say. So it could easily go into re-examination. Okay, all right. Let's continue.
So we both have the same understanding that National Treasury and the DTI regarded the set-aside policy as unlawful because it was inconsistent with existing procurement policy framework and legislation. And so I wanted to ask you, why then did you persist in implementing it or seeking to implement it?
Chair, we wrote to National Treasury and requested for guidance in respect of this implementation of the set-aside. It should still be noted, or maybe again be noted, that we could not implement the 30% set-aside. We wrote a letter to National Treasury to say we need guidance. Yes.
They responded and said it is unlawful. So why did you persist in trying to implement it?
We wrote it, we did not implement the 30% set-aside. We did not implement the 30% set-aside. We wrote to National Treasury and said we needed guidance on how to implement this 30% set-aside.
Yes.
We did not implement
No,
the
I didn't
30%
ask whether you
set-aside.
implemented it. I said, after National Treasury said to you it is unlawful, why did you try to implement it?
No. We tried to implement it before we were reprimanded by National Treasury.
Okay, well, let's look at that. Let's go to the letter from National Treasury, and for that purpose, you'll need to go to Exhibit DD 1919A.
DD 19. Sorry, where do I get DD 19?
It's just on your left-hand side, Ms. Kwinana. They were put there in anticipation this morning.
19?
19, and then where we'll need to go in 19 is page 132.16. So 132.16. Yes. Before we look at the letter, I'd just like to spend a moment on the evidence of Dr. Dawa before this commission. Did you follow that evidence?
Yes, sir.
You did. Dr. Dawa gave evidence to the commission that he had concerns about the unlawfulness of the 30% set-aside policy. Were you aware that he had those concerns?
No, Chair, he did not say that when we were trying to implement the 30% set-aside.
He didn't.
The concerns, I had the concerns in this commission because Dr. Dawa was going with us in respect of this whole empowerment, and we were not aware that he was concerned. And in fact, if he was concerned, he would tell us why and then correct and guide us so that we could successfully implement the 30% set aside.
Well, his version before the commission is that he had a lengthy engagement with you and Ms. Mieni on Friday, the 2nd of October, in which he made it clear to you that he could not, in his conscience, sign letters that would facilitate the 30% set aside. Are you saying that none of that evidence was true?
That's not true, Chair. Where would be the letters? The letters that he would sign, where would they be coming from? I'm not aware of those letters that he would sign.
Okay, because he said in his evidence that one of the reasons he was concerned about the set-aside policy were these very letters that we're going to go to, the National Treasury letter and the BBEE Commissioner's letter from the DTI. You said that you didn't continue to seek to implement the 30% set-aside policy after receiving the National Treasury letter, and I said to you that we would go and see whether that was indeed the case. Because you'll see at page 132.16, that's the National Treasury letter. Can you tell us what it is dated?
Chair, before that, can I get copies of those letters that Dr. Dawa did not want to sign?
Well, for now, you are not being asked about them. Just read the date of that letter, and then if and when it's important to deal with those letters, we'll take it from there. Ms. Mbanjwa?
Thank you, Chair. Chair, I would like us to get an undertaking that we would receive those letters. I don't want to hold the
Wait, those letters might not really be important for now. So let's see if and when they are important.
Yes, but Chair, they go to the probity of the evidence of Dr. Dawa.
Yes, but just wait. For now, the question is about something else, about what date this letter is. Ms. Kwinana, do you want to read the date of that letter from National Treasury?
Is 28 September 2015, Chair.
Yes.
That's the date we were focused on yesterday, because I said that there was a fateful week at the end of September, early October 2015. 28 September is the date on which the board of SAA met, and you made that decision to cancel the LSG Sky Chefs award and give it to Air Chefs. Do you recall that?
Yes, Chair.
So that was the Monday of the week. This letter comes from National Treasury. Could you tell us who at National Treasury writes this letter?
Ms. Mshe?
No, it's written by somebody from the National Treasury. Who is that?
Oh, Kenneth Brown, Chief Procurement Officer.
And he's addressing it to,
To Ms. Mshe?
who was the acting Chief Executive Officer of SAA at the time, correct?
Yes, Chair.
And what I'd like to just focus on there is it's the response to the letter. That's the letter where you sought guidance. Is that correct?
No, Chair. This is not the letter that we sought guidance. In fact, how it happened was when we were trying to implement the 30% set aside, in the newspapers, Bidvest was complaining that they are forced to 30% set aside and so on and so on.
Was complaining?
Bidvest.
Okay.
Bidvest. Yes, Chair. And then we received the letters from National Treasury and from DTI, and saying that they've been informed about this 30% set aside. And then we responded as the board. So basically, this is not the letter that we responded to. We responded to, as the board, to Kenneth Brown, because he wrote us a letter, not this one, but he wrote us a letter and then we responded.
I think you might be confusing this with the letter of the BEE Commissioner, but we'll come back to that. This one says in the 3, the third paragraph, Decisions that are taken by the board to encourage transformation in procurement are commendable. However, the SAA board must not operate outside the procurement legal framework. The resolution of the board to set aside the 30% in its current form is not supported by any procurement legal framework and must be stopped with immediate effect. Let's just stop there for a moment. The board had already taken, by this stage, a resolution to implement the 30% set aside, had it not?
Yes, Chair.
Yes. As I have it, that was on around the 25th of August 2015. Does that accord with your recollection?
Yes, Chair.
Yes. So you decided you were implementing it. Then there was this issue that was taken up. And now Treasury, as I have it, unless you disagree with me, is writing here to SAA, addressed to their acting chief executive officer, saying that the resolution of the board to set aside the 30% in its current form is not supported by any procurement legal framework and must be stopped with immediate effect. You are kindly requested to advise the board not to take procurement decisions that bring the name of SAA and National Treasury into disrepute. And then he concludes by saying, kindly update me on the development around the 30% set aside of key procurement transactions. So both Ms. Mshe and Dr. Dawa indicated that this letter was brought to the board's attention. And despite that, on the Friday of that same week, there was an interaction with Dr. Dawa, which we'll get into in a moment. Do you confirm that you met with him on Friday, the 2nd of October, 2015?
I cannot confirm, Chair, but as I said, if you can give me the minutes of that meeting with Dr. Dawa, I may be able to remember.
As I understand it, there were no minutes. He was called up to, I think it was the 6th floor of the Airways Park building on SMS from you. Do you recall that?
An SMS from me.
Yes.
What did the SMS say?
His evidence was that he was called to a meeting on the 6th floor of Airways Park building.
What did the SMS say, Chair?
No, I'm telling you his evidence. His evidence is that he was called to a meeting on the 6th floor of the Airways Park building.
By an SMS message?
Yes, from you.
How do I call him by an SMS message, Chair?
That's not my question. I'm asking whether you sent it, whether you have any recollection of sending it.
No, I can't call him by an SMS message. Definitely.
Right. And his evidence is that he began the meeting with you and then you were joined by Ms. Mieni. Do you recall that?
No.
So did this meeting take place at all on your recollection?
Well, maybe, Ms.
Maybe you can give me the minutes of the meeting so that I can remember that, yes, the meeting did take place and this is what was discussed.
Ms. Kwinana, I've just said it. My understanding is there aren't any minutes of that meeting.
I thought maybe if you remind her what the issues were that were discussed at the meeting, that might help her to remember.
I'll do that.
If she remembers the meeting.
Well, she certainly has indicated already, Chair, that she did observe the evidence of Dr. Dawa.
Yes.
So this was set out there. But let me do so for completeness purposes. And I'll summarize now. And for the record, it appears in Dr. Dawa's transcript on the 28th of June 2019, and it commences at page 168 of that transcript. Dr. Dawa's version of that day is broadly the following: that you sent him an SMS calling him to a meeting on the 6th floor of Airways Park building, that you asked him how far he had got with implementing the 30% set-aside policy. You asked in particular about Swissport. Ms. Mieni walked into the meeting at a point and asked you for an update, and you said that Dr. Dawa was not doing enough to implement the strategy. Ms. Mieni then said she wanted to advertise Dr. Dawa's job. He was then told to go back to his office to draft awards for the set-asides for Swissport and for NGen. Swissport was the particular contract that would have involved an entity called Jamicron in the ground handling that was to be concluded with Swissport. And so he went and he drafted letters of award, but he refused to sign them because he said it was against his conscience to do so. And the chair then suggested, that's Ms. Mieni, that it should be drafted for the acting CEO, Ms. Mshe, to sign. At that point, Ms. Mshe joined the meeting. You, Ms. Mieni, and Ms. Mieni, as Dr. Dawa's evidence goes, tried to convince her to sign on the basis of telling her that Swissport was in favor of this arrangement. And she refused to sign it and eventually said that she had to leave because by now the meeting was getting late in the day. On Dr. Dawa's version, it had started in the morning and we were now towards the end of the day. And his evidence is that when Ms. Mshe was leaving, she said the following to him. Well, I'm going to quote from Dr. Dawa's transcript, but he talks about what Ms. Mshe says, but I'll try and make that clear in how I convey it.
Yeah.
So Dr. Dawa says this in his evidence before the commission. But before Ms. Mshe left, Chair, I need to confirm, she said to me in front of the two board members that, Dr. Dawa, you will be alone in court should this thing come back. And if you know this is wrong, you do not do it. Yeah, she insisted. And the chair tried to sweet talk her and say, no, but you know, if anything is to come back, it will come back to me as the chair. Then Ms. Mshe still insisted that, Dr. Dawa, with all your qualifications, experience, and credentials, you will have to answer to this one day. And in my view, if you contend, and if you are quite satisfied that it is the wrong thing to do, please do not do it. And off she went. That was his evidence. He described the day as involving psychological games. He went on to give evidence to the commission that he was told by Ms. Mieni that the EFF would be there on the Monday at SAA and that they wanted to get rid of people like Dr. Dawa who were anti-transformation and that they wanted to get rid of Zimbabweans. And he also testified that you, Ms. Kwinana, said to him that he and Ms. Mshe were going to suffer and that he would be disciplined. So that is his version of what happened on that day. What is your response?
I think that's the day where he says the meeting started around about 10 in the morning.
Correct.
And by 4 o'clock,
Yes.
the meeting was still continuing.
It was still continuing and went on probably to 6 because that is when Ms. Mshe said she had to leave to go home.
Yes.
So we calculated a total of 8 hours on his
Yes,
version.
And if I'm not mistaken, he said at some stage, I think he was asked to go to his office and he cried or something.
He certainly spoke about being distressed,
About
Chair.
being distressed.
Yes.
Maybe he didn't cry,
Yes,
but
yes.
was very distressed
Yes.
about the demands that he said were being made on him
Yes.
by Ms. Kwinana and Ms. Mieni.
Correct.
I think, yeah, that's the day here. Ms. Kwinana, do you remember that meeting?
I don't remember the meeting at all, Chair. That's why I was saying, I'm sure for such a long meeting that would start at 10 o'clock and end at 4 o'clock, there would be minutes that would be approved by the people who are in that
Ms.
meeting.
Kwinana,
Chair.
if what Dr. Dawa says you and Ms. Mieni were doing in that meeting to her, that was wrong. And if you were doing something wrong, you were not going to have minutes for that meeting, obviously. So not every meeting has got minutes. And certainly meetings where illegal things are being done, wrong things are being done, people don't keep minutes generally.
Definitely, Chair, in this meeting, I was not there.
You say you were not there.
I was not there.
Are you sure that you have a clear recollection that you were not at that meeting? Or is the position that you can't remember, maybe you were in that meeting, maybe you were not?
Definitely, Chair, I was not in the meeting. If I was in the meeting, I would remember such events.
So you don't have any recollection of him saying to you that his conscience would not let you do what you were demanding of him?
Definitely no.
But not on, as I understand your evidence, you are not saying you can't recall. You are saying that did not happen because you were not in that meeting.
That did not happen, Chair.
And did you ever come to learn that he was resisting signing letters of award to facilitate the 30% set-aside policy because his conscience would not allow him to do that?
Chair, I don't even understand these letters of awards that Dr. Dawa is talking about, because the letter of award would emanate from a due procurement process. So that's why I wanted to see these letters that Dr. Dawa was refusing to sign.
Ms. Kwinana, they wouldn't emerge from a due procurement process because one of the contractors that you wanted to implement the 30% set-aside policy was Swissport. And as we traversed at length yesterday, in 2015 and 2016, no procurement process was followed at all for Swissport. So there would be no procurement process. What there was on the evidence that we looked at yesterday and in the lead up to this meeting was a decision by the board of SAA on the 25th of August to implement a 30% set-aside policy, communication from National Treasury on the 28th of September 2015 that must be stopped with immediate effect, a meeting on Friday that week on Dr. Dawa's version where he was pressurized into doing so and implementing it, and your response saying that he was going to be disciplined and that he would suffer, and then thereafter, shortly thereafter, he is disciplined, he is removed, and he is replaced. Ms. Kwinana, who replaced him? Who replaced Dr. Dawa?
1 second, Ms. Mbanjwa.
Thank you, Chair. I just want you to give us a chance, Chair, to re-examine on this point. The evidence leader, Ms. Hofmeyer, has the evidence of yesterday incorrectly. There was a procurement process for Swissport, but we'll leave that for re-examination. She is wrong on evidence.
Okay, all right.
Thank you, Chair.
Okay, thank you.
Who replaced Dr. Dawa?
Lester Peter, I acted in his position.
Yes. So when Dr. Dawa was suspended for the disciplinary charges that were brought against him, Mr. Lester Peter took his position, correct?
Yes.
And Mr. Lester Peter is the person who sent on the 15th of December, we looked at yesterday, the 15th of December 2015, that tripartite agreement that was going to be concluded that you said you hadn't seen before between Swissport, SAA, and a yet to be selected BEE supplier who was going to get 30% of the contract. Do you remember seeing that for the first time yesterday?
Yes, Chair.
Right. So where we are at the moment is you, I understand, couldn't understand how a letter of award could arise in this circumstance, and I'm putting to you that set of facts makes it clear to me at least how it could arise. It was a board decision that this policy would be implemented, and now you were checking up on whether it was being implemented. Do you have a response to that?
Chair, at SAA, the letter of awards arise from a due procurement process. That's why I am surprised about these letters of awards that Dr. Dawa is saying he refused to sign, because the award letters would come from a due procurement process.
So when Mr. Lester Peter sent the draft contract facilitating the 30% set-aside policy of the board on the 15th of December 2015, was he acting irregularly?
Was that signed, Chair?
That's not my question.
In fact, before we can say he was acting irregularly or not, we need to take the process up to the time that he has to sign. Now, the process would be, was there a tender? Was it advertised? Was the procurement process followed? Was the award given? Was the contract awarded? Was the contract signed? So all of these. And therefore we would say, if for instance there is a draft that does not talk to that whole process, then that is irregular.
What's your knowledge, Ms. Kwinana? Did a procurement process precede the 15 December 2015 draft agreement that was sent to Swissport by the acting procurement officer of SAA?
Chair, that agreement, draft agreement, I saw it for the first time here.
That was not my question. To your knowledge, was there a procurement process followed before that agreement, which I accept your evidence yesterday was you saw for the first time yesterday?
I don't know, Chair.
Right. But you would have wanted to check before any agreement was entered into with Swissport because you're concerned to ensure that procurement is properly followed. Is that correct?
Yes, Chair.
So let's go back to your evidence that you have no recollection of that meeting. You say it didn't happen. Is that your version?
Yes, Chair.
You say it was not communicated then or since then that Dr. Dawa could not, in good conscience, do what you were asking him to do. Is that correct?
I'm saying, Chair, I definitely was not in that meeting.
No, I'm asking a separate question. Did it ever come to your knowledge that Dr. Dawa was saying he could not, in good conscience, do what you were requiring of him to do?
When he was testifying here, yes, Chair.
Yeah, that's the first time it came to your knowledge. Is that
Chair.
correct?
Yes.
Okay, let's go to an email that you wrote to Ms. Mieni a few days after your 2nd of October meeting. You will find that in Dr. Dawa's bundle. I don't think you've had that before, so if we could just have assistance. That is Exhibit DD 16, and we'll pick it up at page 240. Let's maybe start at page 239, actually, if we may. So on Dr. Dawa's version, the meeting that lasted for 8 hours or thereabouts, and he described as having involved psychological games being played with him, was on Friday, the 2nd of October. Now, what you find at page 239, Ms. Kwinana, is an email that you sent to Ms. Mieni on the 12th of October 2015. Do you see that?
Yes, Chair.
And you say, its subject is complaint letter, and you say, "Dear Chairperson, please find my letter of complaint, which is self-explanatory for your action. Best regards, Yakhe Kwinana." And then if you go over the page is the attachment to that email. Do you see that?
Yes, Chair.
Do you recall this letter of complaint?
Yes, Chair.
You do. Well, the letter of complaint suggests that some of the evidence you've given this morning, Ms. Kwinana, is false. The first thing that indicates that your evidence is false is because you begin the letter with, "Dear Chairperson, May 18, 2015 was a historic day for South African Airways, where you signed a memorandum of understanding on behalf of SAA with the Department of Trade and Industry, committing SAA to support DTI industrialization. Your evidence earlier was that you had not seen the 18 May 2015 MOU. Do you remember giving that evidence?
Yes, Chair.
You clearly had seen it, had you not?
Yes, Chair.
Yes. So that evidence was false. What you then go on to do is you talk about President Zuma's State of the Nation address and his reference to 30% set aside. And then I'd like to pick it up in the last paragraph of that page before the numbering starts, because this is where you start to lodge your complaints against Dr. Dawa. You wrote the following: having noted all this, it is sad for me to seek answers from you, Chairperson, where in particular I would like to report the following about Dr. Masimba Dawa. 1, he lied that the jet fuel tender is inclusive of 6 streams, whereas on further inquiry, the jet fuel tender is just supply of jet fuel. I used the above lies to communicate that this tender has 6 streams to SMMEs, to whom the board awarded the 15% tender of jet fuel. Chair, I'm just going to pause there. We did have evidence back in June of last year about how there were steps to implement the set-aside in the jet fuel context. I'm just reminding us that that is where that comes in the evidence of the Commission.
Yes, okay.
Ms. Kwinana, you go on at 3. These lies that I communicated to a room with more than 60 people has an effect on bringing my name, the chairperson's name, SAA and the government's name into disrepute, as there are now inquiries where service providers want to know the way forward in respect of logistics and other streams as communicated by myself as per the misleading information provided by Dr. Dawa. 4. He also lied and made the chairperson to believe that the award letters to tenderers were signed, whereas there were no letters. Those are the award letters that a moment ago you said you had no knowledge of and couldn't exist because procurement would have to be followed beforehand. Paragraph 5, when asked about the status of the board resolution's implementation, he lied and said that the delays are with legal. I subsequently asked legal, who informed me in the presence of Dr. Dawa that they are waiting for Dr. Dawa. 6, he travelled with us on transformational roadshows, and when we were communicating the board decisions, he also clapped hands, knowing very well that he would not write the award letters, which I later discovered that he would not write, as he said, quote, "My conscience does not allow me." Let me just pause there. A moment ago, Ms. Kwinana, you gave evidence that said you did not know that that was his issue with the award letters until you heard his evidence in this commission. I put it to you that your evidence earlier was false. What is your response?
Chair, I had forgotten about this letter that I wrote. In this regard, I have
Clearly,
in this regard, Chair, I stand by the letter that I wrote.
Sorry,
don't
what?
really
You stand
understand
by?
The letter.
By the letter that I wrote.
I don't know what that means. What does
Okay.
it mean that you stand by?
Does that
Because it's a
mean-
completely different version.
Does that mean you now remember the meeting that you said you did not attend?
I still do not think that was the meeting. I think all these things transpired through the road shows, not through the meetings.
Okay, let me try this. Previously, at my request, Ms. Hofmeyer read Dr. Dawa's evidence, a substantial part, to indicate what, according to him, happened at that meeting. The idea behind that was that could help you remember whether you were part of that meeting. You said you definitely were not part of that meeting. So now Ms. Hofmeyer has referred us to a letter or email that you sent to Mr. Dumieni, in which you refer to Dr. Dawa and the award letters. And of course, his evidence was that he refused to sign 2 award letters. And here you refer to him having said his conscience did not allow him. That seems to, what's written here, seems to tie up with what Dr. Dawa says, according to the evidence that was read by Ms. Hofmeyer, about a meeting where he says he was required by you and Ms. Mieni to sign 2 letters of award letters, and his conscience would not allow him to do that, and he was distressed and so on. But at least there are references here which suggest that you seem to, or you may have known about some of these things. What do you say?
Chair, I would remember one of, I don't know whether to say the award letter or the agreement. Maybe it would not be the award letter. The reason why I'm saying it would not be the award letter is because I remember very well the one for the jet fuel, where basically Engine agreed that from the supply that they are giving to SAA, they are willing to dispose of 15% of that supplies and give it to the smaller companies. So which means therefore that the agreement between SAA and Engine, where the tender process was followed, would still continue as it is. And therefore, that's why I'm saying maybe it's not an award, it's an agreement between now Engine and the BEE companies. Then that one, our understanding, and Dr. Dawa made us to believe that he is going to lead it. And please, Ms. Hofmeyer, understand that the award followed a procurement process from the beginning up to the time that Engine was awarded that tender. And then now we negotiated with Engine to say, can you please, from the remaining tender, from the remaining period that is remaining to the expiry of your contract, can you give 15% to these black companies? In fact, I remember that there were about 60-odd black companies that were knocking on SAA's doors to get the tender. And therefore, Dr. Dawa...
But does all of this, are you saying all of this to say you remember the meeting and you did attend it, or are you saying all of this to say you did not attend the meeting?
No, Chair, I did not attend the meeting. It was not the meetings.
Yeah.
We were doing the road shows throughout the country. And then now we would in fact discuss, like with a hall full of people, to say, this is how this thing is going to happen. So basically, I wouldn't say there was a meeting, especially the meeting that Ms. Hofmeyer was talking about. So basically, what I was talking about, what was Dr. Dawa promised that now that we have negotiated with Engine now can give the 15% out of their own will. Remember that this is about negotiations because the company that has got the tender with SAA is Engine, and therefore we cannot enforce anything. That's why we were negotiating with Engine and the other companies and Bidvest. So basically, Dr. Masimba Dawa was supposed to say he does not want to do that. And in fact, if he said he does not want to do that, remember that the procurement process is not tampered with in this exercise that we were doing.
Ms. Hofmeyer, before that, Ms. Mbanjwa.
Thank you, Chair. Chair, I just want to put on record that on my own evaluation, I do not believe that this letter, this email that has been written by Ms. Kwinana, is a confirmation of the fact that there was that meeting.
No, Ms. Mbanjwa, that you can deal with in re-examination. Now it's like you are telling the witness how to respond to questions on this
I was
letter.
going to ask, Chair, that if we can be given
Reserve it for
opportunity-
re-examination.
Thank you, Chair.
Yeah, you don't have to ask for it. I've told you I will allow you to re-examine when the witness when Ms. Hofmeyer has finished. So you don't have to ask for it each time. I will give you the opportunity. What I don't know is whether it will be today or it will have to be some other day, depending on when we finish. Okay. So you just make a note of all the issues that you want to clarify during re-examination. Okay, all right.
Ms. Kwinana, I do want to just spend a little bit more time on this meeting because, you see, it's not a meeting, if it occurred, that I want to suggest to you could easily be forgotten by the people involved. And the reason I say that is if Dr. Dawa's version is correct, and I might add, the part of the meeting where he says Ms. Mshe joined him, Ms. Mshe confirmed in her evidence, right? But that type of meeting that caused such psychological distress to one of the participants is not a meeting that people easily forget. I want to put that to you. Would you accept that if somebody in a meeting experiences severe psychological distress by it and it lasts for 8 hours, it's not the type of meeting that people easily forget having been part of?
Chair, I also would not forget that meeting.
Right, right. That type of meeting would be in your memory, would it not?
Yes, Chair.
And your evidence today is, despite having seen this email that was written 7 days later on the following Friday, you still maintain that you did not attend that meeting with him. Is that correct?
Yes, Chair.
Right. And do you also maintain that he was not told at that meeting that the EFF were going to be coming to SAA that next Monday and that he must be fearful because they were there to act against people who were anti-transformation and foreigners, Zimbabweans like him? Did that not occur?
Chair, I was not at that meeting.
Did that not occur?
I was not at that meeting. I don't know if it did occur or not. I was not at the meeting.
Right. You see, Dr. Dawa was so distressed by that threat that he did not go to work the next Monday. And instead, he wrote an email to his line manager, Mr. Wolfmeyer. He copied it to Ms. Mshe, who had attended the meeting with you on the 2nd, the previous Friday, and he referenced that meeting and he referenced the fact that he was too afraid to come to work. Does that not jog your memory at all?
Not at all, Chair.
Right, so your evidence today is, despite your own email on its face referencing the things that he said took place in that letter, in that meeting, and a subsequent email I'll take you to now in which he talks about the very threat and the fact that he met with 2 board members the previous Friday, you still maintain to this commission you did not participate in that meeting?
Yes, Chair.
Right, let's go to the email. It's a few pages back in the witness bundle of Mr. Dawa, which is DD 16, and you'll pick it up at page 236.
236.
Yes. (236), the same one, DD 16.
The Dr. Dawa one.
So contemporaneous evidence at the time, this email, written at 7:47 in the morning on Monday, the 5th of October, by Dr. Dawa to Mr. Wolfmeyer and Ms. Tuli Mshe, says the following: Dear Sir, following the meeting between the 2 board members and I on Friday, 2 October 2015, I was advised that EFF was coming to Airways Park today, Monday, 5 October, to demonstrate. I was advised that they will be demonstrating that there is no transformation at SAA because of people like me in senior positions, as there is no South Africans holding such positions in Zimbabwe. Seeing the recent violence against foreign nationals, I feel endangered. As you are aware of these demonstrations by EFF and that they are targeting, quote, people like me who are non-South Africans yet holding senior positions at SAA, end quote, question mark. I do not find it safe to proceed to the office this morning against the advice I was given by the 2 board members I met on Friday. I await your advice and direction. Do you still persist that you didn't attend that meeting, Ms.
Yes.
Kwinana?
Yes, Chair.
I need to put it to you that you have been dishonest with this commission.
Well, before that, Ms. Kwinana,
Chair.
just reflect properly. Here is a situation where a senior member of the management of SAA, Dr. Dawa, has given evidence along the lines that Ms. Hofmeyer read to you earlier on about a meeting where he says you and Ms. Mieni demanded and pressurized him to sign letters of awards that he considered to be wrong, to be illegal. He said his conscience would not allow him. He said he was very distressed. And he says Ms. Mshe came in at some stage at the meeting, and Ms. Mshe has come before this commission and under oath confirmed that she came and into the meeting, and you and Ms. Mieni were there with Dr. Dawa. And she has confirmed that part of the meeting that happened when she was there. Now, Ms. Hofmeyer has referred you to an email dated 5 October 2015 from Dr. Dawa to his supervisor or whoever, Mr. Wolf Meyer. Monday the 5th October was the Monday. The meeting that he's talking about, he says, happened on the Friday, about 3 days before that. So everything is fresh in his mind. He's writing to his senior, and he talks about having had a meeting with 2 board members on that Friday. In the email, it doesn't mention who they are, but he has mentioned in the evidence who they are. And he says that you told him that the EFS was going to have a demonstration against people like him, holding senior positions in SAA, who were anti-transformation and foreigners. And why would this man fabricate all of this against you? What did he have against you to fabricate all of this? Because if you were not in that meeting, it means he is fabricating all of this. So I just want you to reflect properly whether really you are saying, you're sticking to your evidence that you were not in that meeting, or whether when you reflect properly, you may have been in that meeting or you were in that meeting.
Chair, there is no way that I would forget such a meeting. I was not in that meeting.
So Dr. Dawa is just falsely implicating you in what happened, in what he says you and Ms. Mieni did or said to him in that meeting.
He is falsely implicating me, Chair.
And Ms. Mshe, to the extent that she confirms at least some of those things that happened while she was at that meeting, she is also falsely implicating you.
Yes, Chair.
Ms. Hofmeyer, you had asked a question. I'm sorry. I just
No.
wanted to give,
course.
I wanted to give Ms. Kwinana really an opportunity to reflect and decide whether she sticks with her evidence that she was not at this meeting. But
And I was simply going to follow that, Chair, by indicating to Ms. Kwinana that we will likely argue in due course that you have been dishonest in the evidence you have given, in resisting against all this overwhelming evidence pointing to the fact that you were there. You nonetheless doggedly insist you weren't, and that is false and dishonest. What is your response to that?
I said, Chair, I was not in that meeting. So if you want to say what I am saying is false and dishonest, it's your own prerogative, Chair.
Let's then go, you said you stand by the letter that you wrote on the 9th of October that you've been shown now, is that correct?
Yes, Chair.
That letter, as I read it, and I want to check if we have the same understanding, expresses a level of animosity towards Dr. Dawa that I would describe as extreme coming from you. Do you agree with that assessment?
No, Chair,
It's not extreme animosity.
not at all.
Not at all. Okay. Let's read what you said. Let's go to page 241. It's in the same bundle. We're in DD 16, and it's just the second page of the letter that you wrote to Ms. Mieni on the 9th of October, 2015. Can I just, before we go to what you wrote, you say it doesn't express extreme animosity to Dr. Dawa. How would you describe your feelings to Dr. Dawa at that stage?
No feelings at all, Chair.
None at all?
No.
No. He was just the head of procurement and you were just dealing with him like you would deal with any manager. Is that correct?
Yes, Chair.
Okay, let's see what you said to Ms. Mieni. We'll pick it up at the bottom of page 241. Under the bullet points, you say, from the foregoing, it is clear that there's no commitment on the part of Dr. Dawa to the resolutions of the Durban Roadshow.
Sorry, Chair, where is
Apologies. So we're at 241. You'll see some bullets sort of 2/3 of the way down, and I'm reading from the paragraph below that, from the foregoing. From the foregoing, it's clear that there's no commitment on the part of Dr. Dawa to the resolutions of the Durban Roadshow. No positive outcome has eventuated since we went on a roadshow, judging by numerous inquiries from would-be service providers that have gone unanswered. The situation as it presents itself amply demonstrates that Dr. Dawa is hell-bent on sabotaging and derailing the transformational agenda of the present government in general and that of SAA in particular. While the SAA board is doing all in its power to translate government's intent of economic empowerment into concrete reality, to extricate the African majority from the quagmire of poverty, Dr. Dawa is equally doing his best to keep the same people in economic bondage. He is part of a sinister, retrogressive agenda which is aimed at reversing the transformation agenda of the present government. His behaviour smacks of insubordination and conspiracy against the SAA board. His purulent attitude may be located in the fact that he does not share the agony of the people of South Africa, who have emerged from centuries of economic deprivation and whose freedom was born of struggle. It is actually ironic that he's sabotaging SAA that appointed him to such a senior position, essentially biting the hands that feeds him. This leaves me with no other option except to recommend that the strongest possible action be taken against him. Ms. Kwinana, I put it to you that that is not written about somebody in respect of whom you had an indifferent attitude, as your evidence a few moments ago suggested. Do you want to comment on that?
I still take it, Chair, as indifferent in the sense that there will always be some disagreements between the junior and his or her senior, but that doesn't mean that there is a, what words did you use in animosity? No.
So these are
Miss-
just
Miss
average.
Kwinana, I'm sorry, Ms. Mayor. Are you saying to me, you want me to believe that you had no strong feelings against Dr. Dawa when you wrote an email in such strong negative terms? This email is written in very strong negative terms about and against Dr. Dawa. You want to tell me that you did not have any strong negative feelings towards him?
Chair, from time to time, there will be disagreements between the senior and the junior.
No, I know that, Ms. Kwinana. Don't tell me that. My question is, are you saying to me that the strong words you used here, negative words about and against Dr. Dawa, don't reflect that you had strong negative feelings against him? Is that what you want me to believe?
Yes, Chair.
Continue, Ms. Hofmeyer. Well, before
Apologies.
you proceed,
Yes.
let me ask this question. I mean, Ms. Kwinana, you say in this paragraph that Ms. Hofmeyer read, you say in part, while the SAA, you say, from the foregoing, it is clear that there is no commitment on the part of Dr. Dawa to the resolutions of the Durban Roadshow. No positive outcome has eventuated since we went on a roadshow, judging by numerous inquiries from would-be service providers that have gone unanswered. The situation as it presents itself amply demonstrates that Dr. Dawa is hell-bent on sabotaging and derailing the transformational agenda of the present government in general and that of SAA in particular. While the SAA board is doing all in its power to translate government's intent of economic empowerment into concrete reality, to extricate the African majority from the quagmire of poverty, Dr. Dawa is equally doing his best to keep the same people, that is the African people, in economic bondage. This is an African person that you're talking about. This is a person from Zimbabwe. Brothers and sisters who have suffered under colonialism, who have suffered under the white rule. This is an African person that you are talking about, Ms. Kwinana. You are saying, while you are trying to empower economically black people in South Africa, you are saying he is doing his best to keep African people in economic bondage. You say he is part of a sinister, retrogressive agenda which is aimed at reversing the transformation agenda of the present government. His behavior, you say, smacks of insubordination and conspiracy against the SAA board. You say his attitude may be located in the fact that he does not share the agony of the people of South Africa. He's from Zimbabwe. He has suffered, just like the African people in South Africa. Sure. Anyway, let's go to page 241. Bullet point number 3. You say that you recommend that the chairperson should charge Dr. Dawa with, and I go to bullet point 3, a refusal or failure to carry out lawful and reasonable instruction. What are you talking about there?
Chair, this lawful and reasonable instruction would relate in this previous tender that I talked about, the jet fuel specifically, where basically we managed to negotiate 15% from engine to be shared by 60 odd black fuel suppliers. So basically what I was saying here, a refusal or failure to carry out lawful and reasonable instructions.
Who had given this instruction that you're talking about to him?
He was given by the board.
Who in the board conveyed the instruction to him? Or was he called to a board meeting and the board told him the instruction?
No, Chair, as I said, there were road shows. And in the road shows, there would be commitments. And in those commitments, like for instance, we would go and speak to this example, engine or shell. And
No, I don't want that whole history, Ms. Kwinana. What I want is, you said here the chairperson should charge him with a refusal or failure to carry out a lawful and reasonable instruction. I'm asking the question, who conveyed to him this instruction that you say he failed or refused to carry out?
It's the members of the board, Chair.
Which members of the board?
The board takes a collective decision, Chair.
Sorry?
The board takes a collective decision.
Did they
So-
all convey this instruction to him
Yes, Chair.
at a meeting?
No, not in the meeting, in the road shows that we were attending.
So there was a roadshow where all the board members were present and they all gave him this instruction.
They may not necessarily be all present, but most of them would be there. And in fact, Chair, when these road shows happened, the board members who were in the road shows had a mandate from the other board members. That's why I am saying this instruction basically was from the board, because even if it was 2 or 3 or 4 board members that attended.
Were you
carry-
one of those board members?
Yes, Chair.
Was Ms. Mieni another one?
Yes, Chair.
And what was the instruction again? Just tell me in clear terms.
The instruction was that, considering that the board has gone to negotiate with Engine, and Engine has agreed from their contract to put aside 15%, that means if they were supplying 100% of the jet fuel, they would supply 85%, and 15% would be supplied by the 60 odd black companies. So basically, Engine, with their procurement process, they had agreed. So basically, what Dr. Dawa was supposed to do, Dr. Dawa was supposed to make sure that the 15% that has been agreed by Engine, remember that other companies did not agree, that's fine, but at least those companies that agreed that, okay, then we can supply 85% and then 15% you can take. So Dr. Dawa was supposed to carry out that mandate, the mandate of going to Engine and say, Engine, you agreed on 85%, Here are the companies.
Which law said you could do this, Ms. Kwinana? Which law said award an entity business without that entity taking part in a procurement process?
Chair, the procurement process was done, and then now we negotiated with Engine.
No. What you have said to me is you instructed Dr. Dawa to award a certain entity 15%
No, Chair.
of business that was supposed to go to,
No,
to another one.
Dr. Dawa would not be in a position to do that.
What did you want him to do?
That's what I'm explaining, Chair.
Yeah, I'm
saying
asking, what did you instruct him to do?
We wanted Dr. Dawa to carry forward from the negotiations that we made with Engine, where Engine was saying we are giving away 15% so that SAA you can be supplied by black people.
Do you mean carry forward? What in practical terms was he supposed to do?
To carry forward, Chair.
What was he supposed to do?
What I mean by carrying forward is because negotiations had happened with Engine, and Engine agreed that 15% will be supplied by the black firms, by the black companies. And therefore, Dr. Dawa needed to make sure that the agreement between Engine and the other companies do happen.
What was he supposed to do?
He was supposed to call a meeting, if I can be like, say, line by line, what he was supposed to do.
Mm-hmm.
He was supposed to call a meeting with Engine as a follow-up of what they agreed previously.
Mm-hmm.
Call a meeting with Engine, call a meeting with all the 6 companies, put all of them together in the room and say, Engine, as you agreed, here are the companies that are going to supply the 15% of the jet fuel that you are giving away.
Why did he have to do that?
That was part of pushing the transformational agenda from the side of SAA.
Which law said he could do that?
Even if there is no law, Chair, but that is how we were pushing the black economic empowerment in SAA.
You see, that might be the problem, that you don't care whether there is a legal framework within which you are acting. You say, even if there is no law, we'll do it. That might be the problem. Ms. Hofmeyer, continue.
Chair, I would actually, if I may, just like to pick up on one final point arising from your question. You see, what troubles me, Ms. Kwinana, you articulate the charge as being his failure to follow lawful and reasonable instructions in line with the set-aside policy. But you see, you wrote that letter to Ms. Mieni on the 9th of October 2015, and on the 28th of September 2015, SAA had been told by National Treasury's Chief Procurement Officer that this whole set-aside policy was unlawful and had to stop with immediate effect. So how could Dr. Dawa, in good conscience, if he was concerned about acting lawfully at all, ever have acted on that instruction?
You know, National Treasury here was talking about what was supposed to be implemented by SAA. This one that I am talking about the 15%, remember that it's not supposed to be implemented by SAA like the procurement process of SAA, because we have already negotiated with Engine, and therefore that does not have anything to do with the 30% set aside. The 30% set aside that we were talking about, that was never implemented. is the 30% set aside by SAA. Remember that this 15% was not going to be set aside by SAA. It was going to be set aside by Engine.
Chair, we're at 11 and we did start earlier this morning. I wonder if it's convenient to take the break now, or I'm happy to go on. It's entirely up to you, Chair.
I think let's go on it. Let's take the break at 15:15.
Thank you, Chair.
Yeah, okay.
Ms.
Can
Quinn-
I have a comfort break, Chair?
Yes, sorry?
Comfort break, Chair.
Oh, okay, all right, no. Then we will have, when a witness says comfort break, we will have a comfort break. Okay, we'll just take the tea break. We'll resume at 11:15.
Thank you, Chair.
We adjourn.
the first session before our break, we were looking at that letter that you'd written to the chairperson on the 9th of October. And in that letter, you called for Dr. Dawa to be charged with those various charges that you'd set out. Do you know what then happened? Was he disciplined? Oh, if you'll just turn on. Sorry, just if you'll repeat your answer again.
Yes, he was disciplined, Chair.
And did you note from his evidence before the commission that in the process of his disciplining, he entered into a settlement with SAA? Were you aware of that?
No, Chair.
And were you aware of his evidence where he indicated that pursuant to all of those events, he ended up losing his house that he'd bought with his family in order to be able to settle here when he was employed as procurement manager?
I'm not aware of that, Chair.
And were you also aware of his evidence? Because I did understand you previously to say that you had watched it. He also gave evidence that he, as at the date of his evidence, which was June of last year, had great difficulty back in Zimbabwe seeking employment. Were you aware of that?
No, Chair.
Ms. Kwinana, I picked up on a point earlier, which was the point about who was Dr. Dawa replaced by, and you confirmed for us that was Mr. Lester Peter, and I indicated to you one of the first things that Lester Peter did was to circulate the 30% set-aside agreement to Swissport to facilitate the policy there. And you then have meetings with Swissport in early 2016 about that. Were you not concerned that pushing the 30% set-aside line was unlawful and you shouldn't be persisting with it by that stage?
Chair, we did not implement the 30% set-aside.
Ms. Kwinana, again, remember, I absolutely take it for today's evidence that you weren't ultimately successful in implementing it. I'm asking about when you're in the throes of trying to implement it. That's why I said, weren't you concerned that you were pushing for the implementation of the 30% set aside at a time when National Treasury had told you it was unlawful?
Chair, we pushed the 30% set aside before the National Treasury said it was unlawful. When National Treasury said it is unlawful, then we stopped immediately and we said to the National Treasury, give us guidance.
You didn't stop immediately because on the 15th of December 2015, Mr. Lester Peter, the person who replaced Dr. Dawa, sent an agreement that Swissport was required to sign, setting aside 30% of that contract. Your comment?
The 30% set aside by Swissport is not the 30% set aside by SAA. We have got nothing to do with the 30% set aside by Swissport. We are nothing at Swissport, or let me say, I am nothing at Swissport, and therefore I wouldn't push the 30% aside to be implemented by Swissport. However, I would push the 30% set aside to be implemented by SAA if it was not allowed. But we couldn't push it because National Treasury and DTI did not allow for us to do that.
No, but Ms. Kwinana, we looked at that agreement yesterday. It said they must set aside 30% and SAA is going to retain the revenue of the 30% and give it to the BEE partner of its choice. How can that not be pushing for the implementation of the 30% set aside?
Chair, the 30% set aside that we are talking about is the 30% aside that would be implemented by SAA. If Swissport wanted to push their 30% set aside, we as SAA did not feature anywhere in their policies of pushing aside the 30%.
Ms. Kwinana, it was a tripartite agreement. That means there are 3 parties to it. SAA, Swissport, and the yet-to-be-named 30% BEE partner that SAA was going to select. Ms. Kwinana, how could SAA not have been involved in that?
Chair, I'm not going to comment on the tripartite agreement that you showed me yesterday. I was not aware of that until you showed me yesterday. And therefore, I will talk about the SAA trying to push the 30% set aside as SAA, not Swissport doing their 30% set aside.
So you weren't,
Well, you can't not comment when you said SAA was not involved, and Ms. Hofmeyer says to you, but SAA was party to an agreement that sought to put aside 30% that it wanted to give to another entity that was yet to be named. So don't you agree that if SAA was involved in such a party, such an agreement was a party to such an agreement, that was involvement by SAA?
Chair, the tripartite agreement, I was not aware of the tripartite agreement.
You were not aware of it
Yes,
as
and
an individual.
Yes, and I said yesterday, it was my first time to see the draft agreement that Advocate Hofmeyer showed me.
But you agree that the fact that SAA was party to such an agreement means that it was involved in setting aside, or it sought to set aside the 30%. All you might say is you were not aware of it, but that was involvement.
My knowledge, Chair, of the 30% set aside, I have tried to explain it that the 30% set aside that SAA was trying to implement was never implemented. The tripartite agreement.
No, Ms. Hofmeyer has explained more than twice that she accepts that the actual implementation might not have happened, but there were efforts to try and implement the 30% set aside, and that's what she's talking about when she refers to this agreement. So the question is, do you not agree that if SAA was party to such an agreement, then SAA was involved in attempts to set aside, to implement the 30% set aside?
Chair, I don't even want to comment about the tripartite agreement.
Well,
The agreement that I can talk about is the agreement that we would envision where this 30% set aside would happen.
Ms. Kwinana, when you are asked a question and you don't answer it, or you don't want to answer it, it doesn't speak well of you as a witness. It's the kinds of things that Ms. Hofmeyer may in due course rely on to say you were evasive as a witness, to say you were dishonest when you were being asked a question and you knew the answer, but the answer would be inconvenient. You then you would decide to say, I'm not commenting, instead of being honest and say, this is the answer, even if it is inconvenient, even if it doesn't put you in a good light. But because you are an honest person, you give the answer. When you say, I'm not going to comment, and you start giving an answer to a question that has not been asked, it doesn't say, doesn't speak well about you as a witness. So I'm going to ask you the question again. Would you not agree that if SAA was party to such an agreement, then it was involved in attempts to implement the 30% set aside?
For the sake of progress, Chair, let me say yes.
Sorry?
For the sake of progress, let me say yes.
You mustn't say for the sake of progress. You must say, give an answer that you honestly believe is the correct answer. If you say for the sake of progress, it gives me the impression that you don't believe honestly that that's the correct answer. And I'm not asking you to give me answers that you don't believe to be true. All I want from you is honest answers. If you truly believe that that was not involvement or in efforts by SAA to implement the 30% set aside, you say so.
Chair, as I said, that tripartite agreement, it was the first time for me to see it. And therefore, for me to comment and say it was an effort for the involvement of SAA, I really do not think that I would be in a position to confidently say so, considering that I was not even aware that there is a tripartite agreement.
Ms. Hofmeyer?
So can I just get clear, if we move away from the tripartite agreement, is your evidence that you yourself did not take any steps after, let's call it late September 2015, to advance the 30% set-aside policy of SAA?
No, Chair. After we received the letter from DTI and we responded, then we never tried to push for the 30% set aside.
I want to be very specific because you've answered with we, and I want to focus particularly on you.
Okay.
Right. Did you ever, after the National Treasury letter of 28 September 2015, try and push the 30% set aside?
No, Chair.
You did not. You did not hold any meetings with Swissport, and let me just step back for a moment. We discussed the 10 February 2016 encounter yesterday, but can I just have your evidence as to whether you were involved in any other meetings to facilitate a 30% set aside between Swissport and a BEE partner for Swissport?
No, Chair.
You did not.
No.
You're absolutely certain about that, Ms. Kwinana?
Yes, Chair.
Right, we were talking about Mr. Lester Peter.
Maybe just in case the transcript doesn't catch that last answer was yes, yes, yes. Is that right?
Correct.
Ms. Kwinana, your last answer was yes.
I did not have any other meeting with Swissport.
You did not take part in pushing for the 30% set aside after the National Treasury had sent its letter saying the 30% set aside was unlawful.
Yes, Chair.
Yeah, okay.
And convene no meetings with Swissport and a prospective BEE partner? Your answer was no, you did not. Thank you.
1 second, Ms. Hofmeyer. Ms. Mbandwa?
Thank you, Chair. I just want clarification from Ms. Hofmeyer. Please, if I heard you incorrectly, just correct me. The document which you are referring the witness to, is it that Swissport agreement that appears in DD 19, 132.45?
I'm not referring her to any document.
No, not now. I think you were talking about a document where you said that there was an agreement which you referred her to yesterday.
It's the tripartite agreement.
I just want to make sure that I've got the same.
Sure. Let me find it for you.
It's not the IATA standard ground handling.
No, it's not that one.
Okay, can I please get a reference to that? I will allow her to continue, Chair. I just want to get the reference correctly. Thank you for that.
Okay.
Should I maybe provide it at the break?
Yes,
Sorry, it's
yeah,
just
that's
not
fine,
at the top
yeah.
of my mind. Or would you like it now?
Okay. No, it's fine after break. I will just ask for the document you are referring to.
Certainly. Oh, sorry, no, I can do it quite swiftly. I think I have the right one in front of me.
And then the
You'll
second
find it in the Ms. Mamela's bundle, which is DD 25A, and you'll find it at page 291.
And then the second thing which I just want to confirm, were you saying that in that 30% set aside, it was said that SAA would choose the BEE partner?
Chair, I'm happy to give a reference,
Yeah.
but Ms. Mbanjwa must please pay attention
Yeah.
to the questions that are asked.
Yes.
I'm not here to clarify for Ms. Mbanjwa.
Yes.
Chair, can I please respond to that?
Yeah.
Because it's one of those things which I just simply cannot accept. I have a right, if I do not hear a question. I've been instructed by the chair, whom I respect, not to make interruptions. If I don't understand a question, I have to ask for the question to be repeated. It does not matter, Ms. Hofmeyer, how irritated you become. It's a right I have. Thank you, Chair.
Just to bring this to finality, yes, there was a reference that SAA said they were going to choose the BEE partner.
Thank you, Chair.
Okay. Okay, let's continue.
Right. So we were talking about the replacement of Mr. Lester Peter taking the position of Dr. Dawa. Are you aware that Ms. Mshe was also disciplined?
Yes, Chair.
And who was she replaced by?
By Ms. Musazwane.
And what
By Mr. Who?
Musa Zwani, Chair.
Okay, Ms. Kwinana, please remember to look this side as you answer so I can hear. Okay, Mr. Musa Zwane. Okay, all right.
And that was towards the end of 2015, is that right? Maybe early 2016, I think it was. So what position did Musa Zwani hold then?
He was the CEO of South African Airways Technical.
Musa Zwani?
Yes.
No, but he was replacing Ms. Mshe. Ms. Mshe was the acting CEO of SAA, correct?
Yes.
So he took her position, which is acting CEO of SAA. Is that not correct?
That's correct.
Sorry, you referred to SAA Technical. So
No, she was saying before Mr. Zwane took Ms. Mshe's acting
Apologies.
position, he was CEO of SAA Technical.
sorry, I did misunderstand it. Can I make sure that I understand? So Ms. Mshe was acting CEO of SAA, right?
Yes.
At the time that she was in that position, did Mr. Musa Zwani hold a position anywhere?
Yes, Chair.
And what was that?
He was the CEO of SAAT.
Right, thank you, Chair. And then Ms. Mshe is suspended for disciplinary processes to run, and then Mr. Musa Zwani takes over her position. Is that correct?
Yes, Chair.
So then he becomes acting CEO of SAA. Is that right?
Yes, Chair.
And who was going to fill the CEO position at SAAT, albeit on an acting basis?
The acting position was taken by Mr. Malola.
Malola Piri, yes. We've heard some evidence from him previously and about him. So towards the end of 2015, early 2016, we've got Mr. Malola Piri as acting CEO of SAA Technical, and we've got Mr. Musa Zwani as acting CEO of SAA. Have I got that correct?
Yes, Chair.
Thank you. Now, Mr. Musa Zwani was the person who signed the Swissport agreement, the IATA one that Ms. Mbanjwa was asking about earlier and that we saw yesterday. Do you recall that?
No, Chair.
You don't. Well, in his position of acting CEO, I assume it wouldn't surprise you that he would be the signatory to that agreement, correct?
That's fine.
Yes. And that was the agreement that was the culmination of the efforts with Swissport to pursue the 30% set aside. Is that correct?
I don't know where does the 30% set aside feature within the Swissport agreement.
You'll remember that I took you to two clauses yesterday. I agree with you, it doesn't talk about 30%, because on Mr. Cole's evidence, they would not accept that. But eventually, by March 2016, what they would accept are those clauses 8.1 and 8.2 that require them to partner with 51% black-owned companies in certain of the performance under the contract. And then you'll recall that important clause 8.2, which was the one that required them to buy the SAAT GPUs. Do you recall that?
Yes, Chair.
Right. So that's why I say that is, in a sense, the culmination of as far as the 30% set aside got at its implementation. Do you accept that?
I don't know if that was the culmination of the 30% set aside. My knowledge of Swissport on its own is that they are BE compliant. So now, if you are talking about Swissport and the 30% set aside, then that's where I am not understanding it.
They were already BEE compliant, weren't they?
Yes, that's what
Yes.
they said.
So it wouldn't make sense for them additionally to have to part with 30% of their revenues to a pre-selected supplier, would it?
Yes.
And then,
Sorry, Ms.
oh,
Mbalu.
sorry.
Chair, I'm sorry to launch an objection. We have paragraph 8.1 and 8.2 here in this page 132.49. There is absolutely nothing about it, the 30% set aside.
That's for re-examination,
That
Ms.
is a
Mbalu.
wrong question to put to the witness.
The record will show, Chair, that I said in exact terms that I was aware it didn't refer to the 30%, and then I went on. The record will show that. Let's then go, are you aware that 3 days after Mr. Zwane was put into the acting CEO position at SAA, after Ms. Mshe had left, that he signed a Section 54 application to National Treasury that Ms. Mieni had tried to change the structure of the Airbus SWAT transaction with?
No, I'm not aware of that, Chair.
Okay. You see, the reason why I'm focusing just a little bit on these positions that involved replacements of persons, Ms. Kwinana, is because the Commission over the last 2 years has heard a lot of evidence about people who within state-owned entities tried to resist efforts of unlawful conduct taking place, then being required or pushed out by various means, and then replaced by others who were either more compliant or participating in those unlawful efforts. I would like to ask you whether you think that that occurred at all with the replacement of Dr. Dawa with Mr. Lester Peter and the replacement of Ms. Mshe with Mr. Musa Zwane.
Definitely no, Chair.
And can I ask you, was there any corruption and fraud, to your knowledge, that took place at SAA and SAA Technical while you were on the boards?
Except for the ones that are appearing in the open water reports.
Not beyond that. And that, as I recall, it was, the one you referenced yesterday was the spare parts investigation. Is that right?
Yes.
So on the components tender, you say, if I understand your evidence, there was no corruption involved.
Not as far as I know.
Not as far as you know. Thank you. I'd like to go to that tender, if we may. That's the components tender that ends up being awarded in May of 2016 to the joint venture of AAR and JM Aviation. Now, there are allegations, and we've heard evidence before this commission, so it's even, in a sense, more than allegations at this point. The commission has received evidence that there was corruption involved in the appointment of JM Aviation and AAR as the ultimately successful bidders in that tender. Are you aware of that evidence?
No, Chair.
You're not aware of it. Can you tell us who Ms. Cheryl Jackson is?
First, can I have this evidence where fraud and corruption happened?
Chair, I'm certainly going to come to that.
Ms. Kwinana, the question, or what you are being asked is to tell us who Ms. Jackson is. Do you know her?
I think it's the director of AAR.
Of AAR.
I'm sorry, I can't hear you.
Director of AAR.
Oh, okay.
And who is Ms. Cookie Mdlulwa?
Kukim Dlula was one of the consultants of SAA, legal consultants of SAA.
Thank you. Sorry, I just need to make a note there. Now, you, I think, mentioned yesterday that you were aware of the evidence that Ms. Sambo gave before the Commission. Is that correct?
Yes, sir.
And you received a Rule 33 notice in advance of her evidence.
Yes, sir.
And at that point, you sent in a response that was just a statement. It wasn't an affidavit. As I understand it, you weren't legally represented at that point. Is that correct?
Yes, sir.
Okay, you said in that statement, sorry, let me go back first, because you asked me where are the allegations of corruption and fraud. Now, Ms. Sambo's evidence was that in a meeting that you had with her, you said to her you wanted to get your hands on 3 big contracts before you left SAA. Are you aware that she gave that evidence?
Yes.
And she also said that she had a second meeting with you at which you introduced her to someone whom you called Ihashi. That person was Ms. Mdlulwa, who we've just discussed. And Ms. Sambo's evidence was that at that meeting, you said that you were going to demand a payment from AAR for yourself, for Ms. Mamela and Mr. Zwane. Do you recall that evidence?
Yes, sir.
Chair, just for record purposes, that can be found in Exhibit DD 18, page 19, paragraphs 60 and 64. We don't need to go there. Now, you did deny those allegations in your statement that you provided to the Commission. I can take you there if you'd like me to, but the part of it that I'd like to pick up on is you said that Ms. Sambo is a, quote, pathological liar. And it was she who was the Ihashi for AAR. Do you remember saying that in your statement?
Yes, sir.
Can you just expand on that a bit? Why is she a psychological liar? And why is it she who was the Ihashi?
The reason why I'm saying she is a pathological liar is because all the things that she said were untrue or were false. If you think about it, Chair, Ms. Sambo was dumped by AAR 2014, if I think, was dumped in 2014. And then now, it's my first time to meet with her. I call a meeting and Ms. Sambo is saying, Ms. Mamela said, I want to be introduced to Ms. Cheryl Jackson. And then she is saying that is in the last quarter of 2015. My understanding of the last quarter in 2015 is October, November, December 2015. And now in May, few months before that, we went to Chicago. Our host was Ms. Cheryl Jackson. And then now I go to Ms. Sambo and say, I need to be introduced to Cheryl Jackson. That is the blatant lie. Now I call her and then I get to her house and say, and stay for about 10 minutes and say, I want to get my hands on this tender and this tender and this tender. And then I go and then I arrange a meeting. That's the first time for me to meet with her. And then I arrange a meeting at Protea Hotel. And then at Protea Hotel, the meeting is between Dr. Dambi, who is the board member of SAA, myself, Ms. Mdluli, and Ms. Sambo. And then I say in this meeting, I want to lay my hands on 3 contracts. I want to get 100 million from AAR. And the people who are going to benefit for this is myself, Ms. Swane, and Ms. Memel. Now, a reasonable person would ask a question as to why was Ms. Mdluli here? Why was she there, herself, Ms. Sambo? Why was Dr. Dambi there? If I am saying I need this, I will get this money from AAR. Now, that is blatant lies. And Ms. Sambo, in her affidavit, she had literally about 40 statements where she is saying she can't remember, she can't remember, she can't remember. And all of a sudden, she remembers that in the last quarter of 2015, I wanted to meet with her. So basically, that's why I am saying Ms. Sambo is such a pathological liar. And in fact, I did say she is so spoiled that she wants things, she wants to be spoon-fed. She doesn't understand the procurement processes. She doesn't know that if she did not put in the tender, she has 0 chances of winning the bid. And another thing, she knows that she was dished in 2014. Now, if I wanted to get my hands on the tender, why would I go to her? For God's sake, how would I go to her and say, I want 100 million? And the reason why I am saying he is the one, and in fact, she said when she came to us to complain about her relationship with AAR, which basically was the reason why she called us, I said, let me arrange a meeting with Dr. Dambi because I will be going anyway. So if you have an issue with SAA Technical, then let me arrange a meeting. And that was the reason for the meeting, basically. And then now, so basically, I really do not know why I would literally go to her, and knowing that she no longer has a relationship with AAR, and we met with AAR in May. And therefore, if I wanted 100 million from AAR, I would simply go to AAR and get that 100 million. Why would I go to her? That's why I am saying Sibongile is such a pathological liar. And in fact, she did not even tender in that components tender. I don't know why is she disgruntled like that. And I understand that Ms. Memela tried to assist her, but because she is such a spoiled brat, maybe she is used to getting things her way. But now, if you don't even put your tender, how was she expected to win the tender? So basically, that's the reason why basically I did not even put an effort to answer her affidavit, because it is clear that she is a blatant liar. Thank you, Chair.
What was the meaning that you were attaching to the word Iashi? I think she may have explained when she was giving evidence, but I've forgotten. But obviously, I know what the literal meaning of Iashi is. And so, if that is isiZulu or isiXhosa, that's a horse. But there may have been a particular meaning that was attached to it. What was that?
What Sibongile said in our meeting when she was complaining about AAR, she said her relationship with AAR started as early as 2012. And she has been running around trying to get AAR people. She got them to meet the think Department of Public Enterprises tried to meet with this person, and this person tried to meet with people at SAA. And therefore, she has been running since 2011. And then now she is being dumped. And therefore, she has been a runner for all these years. So basically, Yakhe is a runner. So when she was telling me about this, I said, oh, and in fact, I said to her, oh, that means Mosi, you were Yakhe labo ubaleka ngapha nangapha, running left, right, and center, up and down for them. So,
Okay.
yes.
Okay, Ms. Hofmeyer.
Thank you, Chair. As I understand Ms. Sambo's allegations against you, Ms. Kwinana, it's really that you were endeavoring to solicit a bribe from AAR. Do you understand her allegation similarly?
I understand her allegations, but what she needed to do, she needed to prove that
No.
I wanted to solicit a bribe. That is number one. And then number two, she needed to tell me, why should I go to her if I wanted to solicit a bribe from AAR? Because at that time, there was no longer a relationship between her and AAR. And if I wanted a bribe at AAR, I would have gone to AAR. And Chair, I hope your investigators did go to AAR to check if I did solicit that bribe.
Ms. Kwinana, my question was just whether you understood her evidence in the same way as I did, that she was accusing you of having tried to solicit a bribe. I understand you to agree with me. That is her claim against you,
Yes,
correct?
that is her claim.
And I understand your evidence to deny that. You did not at any point solicit a bribe in
Yes,
relation to the components tender. Is that correct?
Yes, Chair.
Right. Do you believe that Ms. Mamela is a pathological liar too?
I don't know.
Okay. Could she be from your interactions with her?
There was never an indication to me that she is lying or not.
You see, she engaged in some WhatsApp communications with Ms. Sambo in around 2017, in which she makes reference to your effort to solicit a bribe. So I'd like to take you to those WhatsApp communications so that we can have your comment on them. You'll find them in Ms. Sambo's bundle. Now, that is DD 1818, and we will open it at page 540. Well, actually, could we start at 539, just a page earlier? So the page is 539 of Exhibit DD 18. So this was a set of WhatsApp communications that Ms. Sambo provided to the Commission. They start quite a bit earlier in this bundle, but the one that I'm interested in is the one that starts right at the foot of page 539. It's the last dated entry there. You'll see it says 2017-10-16, and the time is 2100 hours, 47 minutes and 10 seconds. And then identified as the communicator on the WhatsApp there is Nonsasa SAAT Mamela. Do you see that, Ms. Kwinana?
Yes, Chair.
Right. So This is a response that Ms. Mamela sends to Ms. Sambo, referencing an email that she got in the morning. I think I am going to read it all to the part that I'm interested in, Chair, just because it's helpful to get context for what's happening, if I may. So what it says there is, this is Ms. Mamela writing to Ms. Sambo. She says, Sibongile, I'm really trying to analyze your email this morning. I'm not sure what your intentions are, but let me remind you of something. When you came to my office, I advised you to write a background of what work you did with them and what agreement you guys had in place and how you feel they owe you for introducing them to South Africa. I went as far as saying, make sure you break down everything you did for them and send them an email where you copy us, so that based on that, we will intervene and schedule a meeting. But the email you sent today was intended for something else, and it was nothing of what we discussed. So I'm really not sure what you were trying to achieve by that one-liner. You came with your partners for a meeting in 2014, and you asked for help first from the CEO, who refused to give you the prices for the tender. And this is the part I'd like to draw your attention to. Ms. Mamela goes on and says the following, and in 2015, you came to me as a friend and asked for information for the short tender, which you wanted to give to your partner, but looks like you ended up not giving it to them, since you wanted money up front. They tendered anyway with your company name and that of Ndizani. You guys, in brackets yourself, Cookie Mdluli, and Chair, were negotiating with Cheryl where there was an agreement of what amount was going to be paid out to you guys if there was success. Unfortunately, Cheryl changed her mind, claiming it was illegal in her country to pay out bribes. But anyway, they didn't succeed in that tender. Air France did. Do you see that?
Yes, Chair.
So as I read that, and you tell me if you read it differently, Ms. Mamela is talking about an occasion in the past where you, Ms. Mdluli, and Ms. Sambo were trying to solicit a bribe from Cheryl Jackson of AAR. Do you read it in the same way as me?
I read it in the same way, Chair, and I consider this as nonsense.
Nonsense.
Yes.
You say you never ever solicited a bribe in relation to the components tender. Is that correct?
Definitely.
So why would Ms. Mamela just make this up in her private communications with Ms. Sambo?
I don't know, Chair, and I don't even know the people that she is talking about here, and Ndizani and okay, Bongani, maybe we met at Air France, but Ndizani, I don't know, and I don't know Rafik, so I really do not know why would she write that.
Thank you. I'd then like to move to the actual tender process for AAR. Well, let's call it the components tender. They're ultimately successful on the last one, but there's a lot that happens in between. Were you aware that there were numerous tenders prior to the last one in which they were successful?
Yes, Chair.
Yes. And the final decision-making body on those tenders would have been the board of SAA Technical, correct?
Yes, Chair.
It was a contract valued at certainly more than R1 billion, correct?
Yes, Chair.
And so it would fall within the delegation of the board, is that right?
Yes, Chair.
And on the 9th of May, as I have it, that final decision was taken on the last of those tenders to award it to the joint venture of AAR and JM Aviation. Do you recall that?
Yes, Chair.
Now, while some of the other tenders that preceded it were still open, you traveled to America to visit AAR's offices. Is that correct?
Yes, Chair.
And because yesterday, sorry, I sort of hesitated in asking that question, because yesterday in your evidence, at a point when we were trying to engage with you about the limits on communications between decision makers and bidders, I thought I heard you say, but it was okay when you went to America because the tender was not open at that stage.
Yes, Chair.
Yes, so can I just get clarity now? When you went to America to visit AAR, was there a tender open in which AAR was a bidder?
I'm not aware of, Chair.
You're not aware of. So when you said yesterday it wasn't open, you're not certain now whether it was or it wasn't.
But definitely it was not the tender between AAR, that was won by AAR and JM Aviation.
That we would agree on. So AAR in the, let me just get it right, had bid in the 29 October 2014 tender, not with JM Aviation. And that is the one that was still open, if you can believe it, in May of when did you go? May of 2015. So it took really some time and it was still open. Do you accept that it was still open when you traveled to AAR?
Yes, Chair.
You do. And in that encounter with AAR, Ms. Mamela's evidence was that you went on private jets facilitated by AAR, you had limousine rides from time to time, and dined at expensive restaurants. Do you confirm that evidence of Ms. Mamela's?
Yeah, I wouldn't know about the expensive restaurants.
Oh,
But of course,
they might have just been restaurants,
Yeah.
ordinary. Okay, but you don't deny the private jets and the limousines?
yes.
Right. And I want to go back to where we were yesterday then, because you're a member of the board of SAAT that was going to decide that tender that was open at the time that you traveled to the US, correct?
Yes, Chair.
And and AAR was a bidder in that tender, correct?
I can't remember, but I would think that they would be the bidders.
They were. I mean, if it's necessary, I'll take you to the letter, but can we proceed on the basis that they were, right? So you, as the chairperson of the decision-making body, go on this trip to the US, interact with a bidder while a tender is still open. Do you not regard that as irregular, Ms. Kwinana?
Chair, if I can quickly tell you about the summary of the tendering process. The reason why I would not even know that there
Well,
is...
let's start your answer with saying whether you regard that as irregular. If you say you don't regard it as irregular, then you can say why you don't regard it as irregular.
I don't regard it as irregular, Chair.
Okay, all right.
The reason why I don't regard it as irregular is because for the board to know, the only time that the board knows about the tender that is going on is when it is at the final stage, at the final approval, only if the delegation of authority requires that it be approved at the board. And therefore, if there was a tender that was going on at the time we were in Chicago, I would not know if there is a tender going on if it hasn't been brought to the board.
Do you not think that that is something that you should have been advised about?
No, I don't think so, Chair. As I said, the tendering process starts from identification of the need, and then it goes to bid specification, and then it goes to bid evaluation. And all these people are different people. Maybe there's one or two people who are common. And then there is a bid adjudication. And then there is ex-committing. And then there is the board. So basically, at no stage was I advised that there is now a tender going on until the tender gets to the board. So I find it quite normal that I wouldn't know about it until it gets into the board.
Ms. Mamela, who was the head of procurement at the time, joined you on that trip, correct?
Yes.
So you don't regard it as concerning that the head of procurement, who would have known that the tender was open, didn't alert you to that fact before you took this trip?
No, Chair, no, not at all.
And why would she not be required to alert you, given that you'd be the ultimate decision maker on the tender that was open?
As I said, Chair, there are many processes that would go up to there. You may find out that she may not even be aware that there was also a tender going on,
As the head of procurement, she wouldn't know that
most probably.
for a contract worth more than R1 billion.
She may not be aware because those contracts would happen. I don't know at what stage would she get involved. But what I am saying is, at no stage did she tell me, with not a single tender, that there is a tender going on. The only time that I would see that there was a tender is when it gets to the board.
So you have no knowledge that the company of which you are the chair of the board is out on tender to try and get component services. You don't know that at any point in time until you're asked to make a decision on it. Is that your evidence?
Until I'm asked to make a decision, but maybe let me go back to before the bid specification. Then there would be a board submission that would say the components tender will be up for renewal, it's expiring on this date. And then we say, okay, then start with the process. When they start with the process, sometimes they would report that 6 months before the expiry of the contract, because the tender processes take longer. So basically, when exactly the tender process is starting, as long as we know in the beginning, and then the tender specification and everything. And basically, that one is just for noting to say that there is a big contract that is going to expire, that if it doesn't happen, it could have an impact on the operations of the business.
So you are given forewarning when tendering will take place on big contracts, correct?
Yes.
And in relation to this one in particular, the one that was advertised in October of 2014 and was still open in May of 2015, the board became quite involved in that tender, didn't they? Because you took a decision to retract it at a point, didn't you?
Not necessarily quite involved. The retraction also came as a submission to the board. And all the reasons by management would have been stated until it gets to the board. So when you say quite involved, I tend to disagree with you on that.
You're involved at the beginning, you know it's going out to tender, and you're involved when you're asked to take a decision on it, correct?
Yes.
Right. So in between, it would be fair to assume it's still open, correct?
Yes, Chair.
So you did know that it was still open when you went to the US?
You know, Chair, there are so many tenders at SAA and SAA Technical. And as a result, me as the member of the board, I do not have a book where I write that on this date there was a notification that a tender is coming. And then on that date, the tender is advertised, and on that date, no, I don't have that. If they say, we note that the components tender is going to expire in the next 6 months, and therefore we will go out to tender, we say, yes, that is fine.
So there are just too many tenders open at any point to keep your finger on one of them, correct?
Exactly.
Exactly. And so when you're going to go overseas to the premises...
I'm sorry, Ms. Hofmeyer. Can we take a 5 minutes break?
Of course.
And then we'll come back.
Thank you, Chair.
We adjourn.
Oh, Lindy, khawuzamele uba kugqitywe mani namhlanje. Ingathi akuzugqitywa, khawuzamele uba kugqitywe singaphinde sibuye. Kutheni? Kutheni? Sizambirane, ne? Yo, so.
Okay, let's proceed.
Ms. Kwinana, do you accept that being flown in private jets and driven around in limousines are benefits?
Our requirements. So it happens all the time.
And I accept that if you are embarking on a partnership with an entity, you'd like to know quite a bit about them. And is that what the due diligence was designed to achieve for SAA Technical?
Yes, Chair.
Right. The challenge I have with that is that you took the trip before the MOU was entered into and while a tender was still open in which AAR was a bidder. Now, you've said previously there were just too many tenders open at any point in time to keep track of them. Is that correct?
Yes, Chair.
Do you not think, though, as the chairperson of the board of SAAT that was ultimately going to make a decision on that tender, that it would have been required of you to find out? Just make sure that before you go and visit AAR in the US, there isn't a tender that's open in respect of which you will later be a decision maker.
We were not going there, Chair, for the purposes of the tender. We were going there for the purposes of the partnership. And therefore, I didn't see any need for me. In fact, it never even rang a bell that I need to go and check if there's a tender going on and if AAR has tendered. No, I didn't. And in fact, as I am sitting here, I really do not see any relevance in respect of that.
So just to go back to the point that the chair put to you yesterday, I want to suggest what the relevance might be. You see, AAR was competing with other tenderers in that very tender that was still open. And as the chair put it to you yesterday, but if you go and have dinner at a restaurant with one of the representatives of a bidder, and one of their competitors sees you there, they would be, I would suggest, quite fairly concerned about the fact that the decision maker is meeting with their competitor. And so I'd like to put it to you that similarly, if the other tenderers found out that you were taking a trip overseas, aspects of which would be covered, the expenses of which would be covered by their competitor bidder, they would regard that as unfair in the process. Do you accept that that would be unfair?
That would be unfair if SAA Technical did not do that to other tenderers. SAA Technical had been to Air France. SAA Technical had been to Lufthansa. SAA Technical had been to basically almost all the big suppliers of SAA Technical. So basically that was not abnormal.
But in a particular open tender, Ms. Kwinana, I would put it to you that if only one of the bidders gets this opportunity to get close to you, to spend days with you while you're at their premises, to drive you around in limousines and put you on private jets, the other tenderers could fairly say, but we don't have that access to the decision maker, and that's inherently unfair in this process.
Chair, as I said, SA Technical has been to all these bidders.
Yes, but Ms. Kwinana, do you know that they went to those other bidders when tenders were open, in respect of which there were other competitors?
Then that would be tested, Chair.
No, do you know? Do you know whether those visits took place at a time when there were open tenders in respect of which there were other competitive bidders?
I would not know, Chair, much as I didn't know that there was an open tender at that time.
That's
you
the problem.
See, Ms. Kwinana, you said that you going to AAR would be unfair if you didn't do the same to others. And you said you had done the same, or the board had done the same with others. But the two cases can't be the same unless you say, in regard to the others, the trips also occurred in circumstances where they were bidders in a tender that was still open. So if you don't have that information, then you can't use the other trips through the other service providers to justify, to say it was not unfair to go to AAR at a time when the tender was still open. It's one thing to say whether you were aware, you are not aware that they were party to a tender that was open.
I was not aware, Chair, much as I was not aware if there was a tender open where AAR had bidded.
But if, let us say, for argument's sake, you were aware, would you agree that it would have been wrong to embark on such a trip at a time when the tender was still open, if you were aware?
Chair, even if I was aware, I really wouldn't see anything wrong in us undertaking that trip. The reason being that there are rigorous processes that need to happen for up to the stage where we get the recommendation. And therefore, that wouldn't affect my decision whether I did go there or not. And in fact, maybe the tender that you were talking about, much as we went to AAR. AAR did not win that tender because they had some deficiencies in terms of the tendering process.
No,
So
that-
basically what I'm saying is that would not impair my independence and thinking.
Ms. Kwinana,
Chair.
do you really seriously mean what you are telling me?
Yes, Chair.
That in your judgment, there would have been absolutely nothing wrong for you as a member of the board that would make a decision on a tender in regard to which AAR had put in a bid, for you to go on a trip overseas to their premises without the knowledge of other bidders and let them wine you and dine you over there? You say there would have been nothing wrong with that?
Chair, the procurement processes are so rigorous such that
Sure.
even if I went to Chicago, if the bidder does not qualify, the bidder does not qualify.
I think, Ms. Kwinana, quite frankly, processes that, in terms of which people are appointed as board members to SOEs must be reviewed. If that is what you think, and you are a board member, you are a chartered accountant, you think there would have been completely nothing wrong with that, then there is something wrong in the appointment process. Ms. Hofmeyer.
Ms. Kwinana, I want to pick up on a point. You recently said that it was okay to be there because AAR didn't win that tender. They ended up not qualifying, correct?
No, Chair. I'm not saying it would be okay because AAR did not win that tender. I'm saying as part of the due diligence, we had to go there.
Why did-
Whether AAR had bidded or not, our visit to AAR was not informed by whether AAR had bidded or not.
No, but you-
Our visit was informed by the partnership agreement that we wanted to enter into at that stage. So it was not informed by the tender. Even if AAR did not tender, we would still have to go to Chicago.
No, of course. If AAR didn't tender, there'd be no problem with you going. On that, Ms. Kwinana, you and I agree completely. The problem is that you go with one of the bidders, right? You are wined and dined by them, and then they weren't disqualified in this tender. Do you remember what happened with this tender?
I read in the documents. I may remember the facts maybe incorrectly, but it seems as if there was some move to disqualify them.
No, I think you might be confusing it. You see, because what happens is you go to America, you get wined and dined by AAR, you come back, and the board decides to retract that tender in respect of which there were other competitors who might have been service providers to SAA Technical, and you decide to embark on the MOU with AAR. So your closeness with AAR led to a retraction of a tender in respect of which there were competitors to now form a partnership with AAR. Do you not regard that as problematic either?
Chair, it's not problematic at all.
Right. And if other competitors thought that the fact that you were in the US and being wined and dined by one of the bidders led you to cutting them out of potential supply to SAA Technical and forging a partnership with the entity that had wined and dined you, they wouldn't have any complaints of unfairness. Is that your approach?
I don't know, Chair.
Okay.
You don't know what your approach is.
I don't know if they would complain or not.
No, I'm asking whether if they complained, they would legitimately do so.
That would depend, Chair. That would be proved in the court of law as it has happened with AAR and France, whether it is legitimate or not.
We'll come back to the
And if you
litigation.
don't get to a court of law,
Yes, Chair.
it's fine.
Chair,
If you don't get to a court of law, it's not a problem.
it's not fine, Chair, but as SAA technical at the time, we consider that was the best decision that we did. And in fact, as I am still sitting
Which
here,
decision now?
the decision to form a partnership with AAR, because the process, the partnership process was embarked into, and it was agreed that we needed to form a partnership, hence the birth of the MOU.
Did you get persuaded while you were overseas at being wined and dined by AAR that the way to go would be to retract the tender and enter into an MOU with AAR? Is it something you got persuaded of when you were
No, Chair.
overseas?
I
Or when you
cannot
came
be-
back?
I cannot be persuaded by whining and dining of AAR, Chair, because
But at what
I would
point
be in a
did you-
position to wine and dine myself if I wanted to.
At what point did you see this point that the right way to go would be to retract the tender and enter into an MOU with AAR? Was it while you were visiting AAR overseas, or was it after you had returned?
Of course, the MOU, I don't know the date, but I would think the MOU would be entered after we have been there and seen the premises and seen what value can they add to SAA Technical.
So what you saw on the trip would have influenced you to say, we must go the MOU route.
Yes, Chair.
So which means it was while you were overseas on this trip that you got persuaded that you must go the MOU route?
We did not get persuaded, Chair. The purpose of our trip was to make sure that we confirm the resources that they said they had in the paper, which we liked, that this is the company that we can form a partnership with. So basically, our trip there was to make sure to confirm what was in the paper. It was not for them to persuade us. We acted in the best interest of SAA Technical to enter into that MOU, which expired after 6 months after all.
I'll let Ms. Hofmeyer ask her next question, but before that, I want to go back to the question of communication with a bidder while a tender is open. The basis on which you have now, today, said there would have been nothing wrong for you to go on this trip, even if you were aware that AAR was one of the bidders on the tender that was still open, is that the company, that is SAA Technical, had a rigorous procurement process. So, as I understand it, you were not going to be influenced by anything because there is a rigorous procurement process. I don't remember you advancing that as the reason yesterday for saying communication between a decision maker could take place. Communication could take place between a decision maker in regard to a tender and a director of a company that has put in a bid. I thought you advanced a different basis. Am I right? Am I right in understanding that?
I may not have remembered, Chair, what basis did I advance. However, I remember me saying that there are processes including combined assurance providers, and I mentioned internal audit, external audit, risk management, and management as a whole, which basically would also form part of the chain within the procurement process.
I seem to think that at least at one stage, the basis you advanced was that as long as the communication did not include discussing the tender, there would be nothing wrong with the decision maker having communication or even having dinner or lunch with the director of a company that had put in a bid in regard to a tender that was still open. At least that was either the basis you advanced or one of them. Is that your recollection as well?
Yes, Chair. And in addition to that, there are these rigorous processes that I told you about today. And more importantly, at SAA, there is a cross-functional team, yes, which basically is responsible to make sure that the process is thorough. And in fact, you can even see their minutes that there was a process that was, the process that was followed. So in addition to that cross-functional team, there is also the bid adjudication committee, and then there is EXCO. And all of these people basically are the gatekeepers of making sure that procurement processes are followed to the letter.
But we saw yesterday from your evidence how this board, of which you were a member at SAA at least, could override a decision by other people in regard to the HF's contract. You didn't even want to look at the motivation put up by the acting CEO because you had decided you were going to override them, you were going to reverse the decision. That can happen when people know they've got power. They might disregard whatever other people have said.
Chair, I said yesterday, the air chef's retraction of that tender was, the circumstances were different.
Yeah, you don't have to
went
repeat them.
further to
I
say-
remember the circumstances you gave. I was just saying, but whatever you said, what was quite clear from your evidence was that at least the SAA board of which you are a member, would not hesitate to reverse a decision made by other people within the company, and in your case would not even bother to look at the motivation for the decision that they wanted to reverse. Ms. Hoffman?
Thank you, Chair. Ms. Kwinana, I understood you yesterday to accept in your evidence that, as a general principle, boards of state-owned enterprises shouldn't get involved in operational matters. Do you accept that?
Yes, Chair.
That's left to the management of the SOE, correct?
Yes, Chair.
So then can you just help me why it was at all necessary for non-executive board members of SAA Technical to go on this due diligence trip at all? Shouldn't that have been left to management?
Just one sec before she answers, Ms. Mbandwa.
Thank you, Chair. It was actually a response to what the Chair had put to the witness.
Yes,
And I just want, Chair, to remind you what the evidence of the witness was.
yes.
The evidence of the witness was this. The reason why the air chef's tender, that is the award to LSG, was reversed by the board was because of application of a section in the Public Finance Management Act and the fact that that is a tender that ought not to have gone out.
Oh, that's what I
advice.
told her not to remind me because I remember what her evidence was.
Yes, so
Yeah.
I was
Okay.
just correcting the impression that they can override. They don't
No,
override.
no, no.
They apply.
No. I remembered what evidence she gave.
Thank you, Chair.
Ms. Hofmeyer, I think you had asked a
Yes,
question.
I'd asked why, if board members are not supposed to involve themselves in operational matters, it was necessary for non-executive members of the board to go on this trip to do a due diligence. Shouldn't that have been left to management?
It has been at SAA Technical. It has been a practice that the board and management do undertake this trip. And it also did happen at AAR. Both board and management did go to this trip.
Why only some board members then?
Of course, it would depend on the meeting who would be selected to go. And it also would apply with management. Not everybody would go because that would mean that all management, it depends who is nominated to go and represent SAA Technical.
I can understand that for management. I can't really understand it for non-executive board members. Why should some of you have the benefit of this and not others?
Chair, it has been the case. People have been nominated in board meetings. Like for instance, when SAA team went to Lufthansa and when SAA team went to Air France, I was a board member at SAA Technical and I didn't go to these trips. So it depends who is nominated in a meeting to go.
So you did it because it was a practice, is that correct?
Yes.
Did you ever look at whether the practice made sense?
For me, it made sense because SAA Technical is involved in high value contracts. And therefore, also as the members of the board, then they needed to go. I really did not see anything wrong.
Why would they need to go?
The previous chairpersons did go, and I also do not see the reason why they would not go.
Well, because
considering that they have a fiduciary responsibility to make sure that the companies that SAA Technical enters into are genuine companies, are the companies that have got capacity. So I really did not see anything wrong in the board members going, in the previous board members going, in me remaining behind. I really did not see anything wrong.
Well, let me put to you what might be wrong. You see, on your version, you went so a due diligence could be done.
Yes.
You have a full management team with no doubt the expertise
Yes.
to evaluate the proposed partner. They would go, they would do the necessary, and they would report to you. Your evidence yesterday is that these SOEs were populated by highly qualified people. And the reason for separation, Ms. Kwinana, is precisely because as the ultimate accounting authority, you must make the final call on these decisions. So you don't want to be influenced along the way. You leave your managers to do operational stuff, to do the nitty-gritty of the due diligence. They feed it into you, you assess it, you can go back, you can say it's not good enough, but you don't get on a plane and go and be wined and dined by somebody who is a bidder in a process. Do you accept that that might be a better way to do it?
Chair, this has been the practice, and I do not doubt the intelligence of the people who made those decisions, including my own intelligence, Chair.
Ms. Kwinana, you come back, right? You retract the tender and you enter into the MOU. And I heard you a moment ago, I think, say entering into that MOU was one of the best decisions that SAA Technical took. Is that correct?
That was the best decision that SAA Technical entered into. The reason being that AAR is providing parts, components in almost all the airlines, and therefore the reason why SAA Technical has been incurring losses, or one of the reasons, is because we have been using the middleman to get to the spare parts that AAR is supporting. So that's why I'm saying and in fact, AAR has got a network all over the world, which SAA Technical would also tap into. So that's why I'm saying it was one of the best decisions that we made. And in fact, Chair, I said I don't regret a single decision that I made when I was a board member at SAA and SAA Technical, but some of the decisions are definitely better than the others, and this one was one of those.
I just want to be sure that we're on the same page, because what you've given now, as I understand your evidence, is a justification for choosing AAR ultimately to be the component supplier. But your evidence earlier was that deciding to embark on the MOU, the Memorandum of Understanding with AAR, was one of the best decisions that the
Yes,
board
Chair.
has taken. Do you
Yes.
stand by that?
Yes, Chair.
Why was it abandoned a month later then?
It's because the terms and conditions was that after, I think it was 6 months, it was a 6 months MOU. The terms and conditions required that after 6 months, if no relationship happens, then it needed to be cancelled.
No, that would explain why 6 months later it didn't continue. It was reversed a month after it was entered into. How could that be a good decision?
I may not remember about the reversal a month after. My recollection is that that MOU was a 6 months contract, 6 months MOU, and after 6 months it expired. So the 1 month, I really do not remember.
Okay, but in your mind, even from as early as that trip, I understand your evidence to be you had identified AAR as an excellent supplier of component parts. Is that correct?
Yes, Chair.
And you believe that for SAA Technical to partner with AAR would be one of the best things that it could do. Is that correct?
Yes, Chair.
Right. Mr. Parsons, who was your co-board member around this time, had some concerns about that MOU. Are you aware of them?
You know, I don't even want to talk about Mr. Parsons, the reason being that he was not even supposed to be in that board because he was an illegal immigrant. Anyway,
Are you aware that he had concerns? That's the question.
I'm aware that he had concerns, and I even wrote him an email to say, Barry, let us meet so that I can hear your concerns. And to be honest, Chair, that email that Barry wrote, I did not even understand what he was complaining about. What I know is that he was very, very disgruntled
Yeah,
that
no,
he didn't
you
go
have not
to
been
Chicago.
asked about that email as yet. Ms. Hofmeyer?
So you said he was disgruntled that he didn't get to go on the trip.
Yes.
Oh, all right. So did you surmise that he writes this letter because he didn't get on the trip with you to the US?
Yes, Chair.
Do you have any facts to back that up?
The reason is that he was doing the walkabout with AAR people at SAA Technical, and he supported this thing, the partnership, and he was very supportive, and he liked it. And then all of a sudden, now he turns around and writes that email and subsequently resigns.
So that trip was really something that mattered to the board members, correct?
Yes, the trip mattered to the board members. Yes.
And he'd been excluded, so he felt left out. Is that your version?
He was part of that meeting that decided who should go.
But he held some discomfort or frustration maybe about the fact that he wasn't selected, correct?
Everybody in the board meeting needs to decide. It's not only one person who decides, everybody decides.
No, indeed.
He also had an opportunity of deciding and make a recommendation as to who should go.
Yeah, Ms. Kwinana, it's not about that. I mean, Ms. Hofmeyer is really asking, is following up on your evidence that he was disgruntled. Did he ever say, I want to go at the board meeting?
I don't remember him saying he wants to go, because if he wanted to go, obviously that would be discussed, and then a decision would have been made to say, yes, you can go, or you can't go with some reasons.
Do you know of any reason why, if he wanted to go, he would not have expressed that wish at the board meeting?
I later came to understand.
No, Ms. Kwinana. Do you know of any reason why, if he wanted to go on the trip, he would not have expressed that wish at the meeting?
Yes, Chair, it's because
What is the reason that you know?
I know that his stay in South Africa was illegal at the time, and therefore it would be difficult for him to get out of the country.
So why would he be disgruntled about not being nominated to go on a trip on which he could not go anyway, even if he wanted to? Where's the logic in that?
But basically, Chair, that's the only reason why I would think that all of a sudden, after the trip, he resigns. Otherwise, that's
No, but
also my speculation.
Let's talk about your evidence that he was disgruntled because he was not allowed to go on the trip. He was not nominated. If on your evidence, he knew that he couldn't go out of the country, how could he be disgruntled about not being nominated? Because even if he had been nominated, he would have been bound to decline. Doesn't make sense, does it?
That is the speculation, Chair, because as I am sitting here and...
But your speculation has no basis. It doesn't make sense. You are saying he could not leave the country because he was illegal and he knew it in the country. And then you say he was disgruntled because he was not nominated to go on the trip. But if he knew that he was illegal and therefore could not get out of the country, logically, he could not be disgruntled about something that he could not take advantage of.
Maybe, Chair, he was disgruntled because he could not go to
Is that
Chicago.
another speculation?
Not being nominated, but he could not go.
Is that another speculation?
It's a speculation, Chair, because I don't understand his email.
Ms. Hofmeyer?
And
You see, his letter is very clear about his reasons, right? His letter, which you will find in your bundle, Ms. Kwinana, at DD 33, page 22. So we're at Exhibit DD 33, page 22.
Do I need to go there?
No, Chair,
Yeah,
I'm just
okay.
going to read the
Yeah,
two
okay.
points that he makes that I'd like to pick up on, because Ms. Kwinana has said that she doesn't understand from this letter, as I have it, why he was leaving. Is that your evidence, Ms. Kwinana?
yes, Chair.
Right. He says, please accept my resignation with immediate effect from the Board of Directors of SAA Technical. I feel I've made a strong contribution to the board, finding governance in the business weak after what happened, what appeared years of neglect. Unfortunately, the value I can add seems no longer wanted, as it is quite clearly due to the AAR Corporation strategic partnership. There is clearly a hidden agenda somewhere in this relationship, and it requires urgent independent investigation. So as I read that, he's communicating that he's concerned that there's something hidden in this relationship that SAA Technical is forging with AAR. Do you understand it in the same way?
Yes, Chair.
Yes. What is not clear about that reason?
What is not clear is that this person was very excited about this relationship, and he was the person who was walking the AAR team about. And then now, all of a sudden, he writes this letter. So basically, I just do not understand.
But
Well,
that
he-
might be precisely because he has realized that there's something hidden that he doesn't agree with. That's why his attitude changes. That's logic.
Maybe, Chair, that's what he should have written, that hidden agenda. He could have said, I think there's a hidden agenda, the hidden agenda being A, B, C, D, and E.
Yes, he does do that. So you see, he
let's
goes
go
on.
further.
He explains precisely what his concerns are. He talks about the irregular way in which the MOU was concluded. He'd raised a series of concerns about it,
So
not
where
least
are
of
these
which...
concerns, Chair? Can you take us
Ms.
to these
Kwinana,
concerns?
wait until Ms. Hofmeyer has finished what she has to say.
Ms. Kwinana, I'm trying to summarize. We can read every word of this letter if it's necessary. It was in your bundle, so I assume you've taken some time to look at it beforehand. I'm summarizing now, but if you would like to go through it yourself, you must let us know. He, in essence, says the following. He had reservations about the conclusion of the MOU. He raises the concern about when it was entered into because there were certain time periods that were supposed to run and it was unclear when it was entered into. That appears in much more detail before this letter, but here he is summarizing it. And then importantly, in the penultimate paragraph on page 23, he says, my other specific concern is the identification and selection of the triple BEE partners, if any, for the proposed joint venture, a process that needs to be highly transparent in a business that already has an uncompetitive cost base. The copy of the MOU received includes an implementation timetable that suggests this process may already be significantly advanced, and there's no visibility of this to either the SAA technical or SAA boards or National Treasury. He concludes, I hope the company shares my concerns and appreciate that I have no confidence in the integrity of the SAA technical board, and my membership of that board has become a reputational matter, and it is a simple decision to submit my resignation. What did you not understand about that, Ms. Kwinana?
I still do not understand when he talks about the identification and the selection of the BE partners. I also do not understand the MOU, what is not clear about the MOU. And another thing, for him being a board member, he should have raised these issues in a meeting. And then now, he just resigns without raising the issues and get them properly attended to. So basically, I really do not understand. And if, for instance, he's talking about the AAR and the identification and the selection of the BE partners, and in fact, all other companies, we do not, of course, we have got a list of the BEE companies that would want would want to do business with SAA. But now the selection of the BEE partners also do follow a rigorous process to be included in the database of the BEEs. So basically, if Barry, Mr. Parsons, had a problem with that, he was a board member. He had the platform to raise his issues and made sure that they are properly communicated. As I said, I needed to have a meeting with him and then we decide what needs to happen. And instead of us meeting, he just resigned. So basically, I don't understand a person at his level who has the platform to put together what his concerns are, is unable to do that, and he simply resigns.
Okay, it's about lunchtime, but Ms. Mbandra had a hand up. Ms. Mbandra
Thank you, Chair, for the opportunity, but Mrs. Kwinana has already...
has taken care of it.
Yes,
Okay, all right. Ms. Hofmeyer, shall we take the lunch break now?
Indeed, Chair.
Okay, it's 1:05. We will resume at 2:05. We adjourn. Ms. Hoffman, I see the witness is not here.
No, Chair.
Ms. Mbanjwa is not here.
No,
And I did say 5 past, isn't it?
I think so. I might have even heard 2, but it might have been 5 past. We can try and take steps to contact them. I think we might have a cell phone number for Ms. Mbanjwa. I don't know about their location.
Yes. I definitely did say 5 past. And on my watch, it's 10 past now.
Yes.
I'm going to adjourn for another 5 minutes.
Thank you, Chair. We will update you.
Yeah, thank you. We adjourn.
she had received communications from JM Aviation, the joint venture partner of AAR, while the bids were open, and she was asked to comment on the bid submission of JM Aviation, as well as to give input on their JV agreement. And what we showed her was that that was in breach of the RFB of the bid. So I'd like to take you to it. You will find it in actually Mr. Human's bundle, which is DD22, and it is, there are many files for Mr. Human. So this is DD22E, and you'll need to pick it up at page 2052, 2052. Oh, so the page is 2052, 2052. And just for the record, while everyone's turning up that page, I don't suggest we go there, just so that you know, the request for bid commences in Exhibit DD22E at page 2043, but what I'm wanting us to look at is 2052. So that is within the request for bid, and it includes a clause 1.6 on that page. Do you see that, Ms. Kwinana?
Yes, Chair.
And what that says is clause 1.6.1, all queries or information relating to this document or surrounding the bid must be addressed to the project manager as stipulated on page 1 of this RFB in writing. And then clause 1.6.2, any queries addressed to individuals other than as stipulated, whether verbal, telephonic, and written or in any other form, will eliminate the bidder from this process. Do you see that?
Yes, Chair.
So it was put to Ms. Mamela that her communications with Ms. Sokulu, who was representing JM Aviation at the time that the bid was open, were in breach of that clause. Do you agree that those communications would have been in breach of that clause?
Yes, Chair.
Yes. So now I'm drawing to your attention, because you didn't see Ms. Mamela's evidence on this previously, that JM Aviation and AAR could never have been awarded this tender. Do you accept that?
I don't want to say I accept or I don't accept. But as I said, if the procurement processes were not followed or were flawed in one way or another, then necessary steps would have been taken.
Well, no. What this says at clause 1.6.2 is that if you address any queries to anyone other than the project manager, you are eliminated from this process. What possible steps could then have been taken?
Maybe, Chair. You see, when you get me to read only this, and then the tender process as it is, starts from the beginning up to the end. And then now you are telling me about the people who communicated. I don't want to comment about the people who communicated because I don't know what they were communicating about, and I don't know if they communicated specifically with this.
Okay, so that's why I assisted with just a summary of the evidence that was presented. Would you like me to take you to the communications between JM Aviation and Ms. Mamela?
Yes, Chair.
Right, so let's go to the Sambo bundle, that's DD18, 18, and we'll need to go to page 339.
I think somebody will assist you, Ms. Kwinana. You can sit down. Somebody must get the file
Yes,
for you.
we do have assistance. Thank you so much. So we're looking for DD 18, and we're going to begin at page 339.
It was with her just now. I think it must be the one on top of the others.
That's-
It must be one of those, yeah.
Oh, 339 is the page. Okay, so Ms. Kwinana, what you see here is midway down the page. Do you see that there's a from Kosi Sokulu?
Yes,
Date 14 January 2016 at 4 in the afternoon to Nonsasa Mamela at an iCloud email address, and the subject is joint venture draft agreement. Do you see that?
yes, Chair.
So this is the communication between Ms. Sokulu. What was Ms. Sokulu's status at JM Aviation?
The director.
Right. So a director of JM Aviation sends to Ms. Mamela, who was the head of procurement at SAAT, the joint venture draft agreement that was going to be entered into between JM Aviation and AAR. And she says, "Hi, cousin. This is the first draft of the JV so far. Jules did a quick review and noticed the following." And then point 1 relates to the agreed participation. So JM Aviation was going to have 5% and AAR 95%. Then clause 6 said participation interest, the same, JM Aviation 5%, AAR 95%. And then over the page, as per the collaboration agreement, JM is to receive 5% of any amounts received by AAR from SAAT. This is linked to revenue, not profits. For example, if SAAT remits $100,000 to AAR, then JM is to receive $5,000. Did I say millions earlier? I might have, sorry.
I didn't hear.
$100,000, then JM Aviation gets $5,000. The way the participation interest clause is written states that JM will receive 5% of the profits. This is not correct. We need to determine what will 5% of revenue equate to as a percentage ownership of the joint venture for JM. Please let me know if there's anything else we might have overlooked, ? So this is a communication between a bidder and the head of procurement, who confirmed in her evidence fairly that she was not the project manager with whom the only communications could take place, asking for her input on the way that they were structuring the JV agreement and the look-through that JM Aviation would have to all revenue generated by AAR. The second communication you'll find at page 367. Now, 367 is an email of the same day. Again, you must go halfway down. It's from Ms. Sokulu again, 14th of January 2016, now at 13 minutes past 8 in the evening, to Ms. Mamela at her iCloud address. It says, subject forward South Africa draft proposal. Hi, cuz. So here is the latest proposal. Let me know if it is acceptable. Thanks. And then if you turn over 2 pages, you'll see there at page 369 what was attached. And that is the then draft of the AAR JM Aviation bid. So now, having seen those documents, are you then satisfied that JM Aviation and AAR should have been eliminated from this process?
I don't want to say, Chair, yes or no. That would also depend on the role that Ms. Mamela would play in respect of the joint venture.
No, it doesn't. You remember we saw the clause. The clause says any queries addressed to individuals other than as stipulated, i.e. the project manager, whether verbal, telephonic, and written or in any other form will eliminate the bidder from this process. Ms. Kwinana?
Well, I'm sorry, Ms. Hoffman. Let's just go back to that page where that clause is, just to make sure you know what, you are clear about what clause Ms. Hoffman is talking about. At page 2052 of DD 22E.
Thank you, Chair.
DD 22E at page 2052. Have you got it?
Yes, Chair.
Yeah. Clause 1.6 deals with communications surrounding the RFP. Clause 1.6.1, all queries or information relating to this document or surrounding the bid must be addressed to the project manager as stipulated on page 1 of this RFP in writing. 1.6.2, any queries addressed to individuals other than as stipulated, whether verbal, telephonic, and written, or in any other form, will eliminate the bidder from this process. You understand that?
Yes, sir.
Now, my understanding of this clause 1.6.2 is that if any bidder communicates in any way about the bid other than through the project manager, communicates with other people in the company, that bidder is eliminated. No discussion. That's it. Is your understanding the same or is it different?
My understanding, Chair, is the same in respect of this 1.62. However,
Yes,
however, as I said yesterday, there are many circumstances surrounding that.
There are many circumstances that what?
Surrounding that, and sometime yesterday I spoke about the situation where sometimes it is impractical.
But hang on, excuse me. This is a rule put into a bid, isn't it?
Yes, sir.
And you see that it doesn't provide for any exceptions. Do you not see that? You see
Yes,
that?
sir. Yes, sir.
So there are no exceptions provided for. So how are you going to create your own exceptions to the rule? Because if anybody thinks there are difficulties with the rule, then they must use internal processes to say, we mustn't have such a rule. We must change it, isn't it?
Yes, sir.
But you can't have a situation where the rule has no exceptions and anybody is free to make their own exceptions. Then the rule will not work. You accept that?
Yes, sir.
Yes. Okay, thank you. Ms. Mbanjwa?
Thank you, Chair. If I can take Chair back to 2052, the clause that has just been read,
Yeah.
clause 1.6.2. That clause has a heading, communications surrounding the RFP.
Well, what you immediately you say that it seems to me something that you should reserve for re-examination because it seems you want a certain qualification or meaning to be attached to it, which you can do at re-examination.
No, Chair, I don't want to be obstructive, but.
But you
based on
see,
that heading,
hang
I
on, Ms.
wanted-
Mbanjwa, you see, the danger of doing that now is that it will look like you are giving a tip to the witness.
No, I wanted.
But if you reserve it for later, then nobody will think that you are trying to give a tip to the witness.
No, Chair. I know I'm not giving a tip to the witness.
Yes.
Because actually, the question is addressed to Ms. Hofmeyer. What I want Ms. Hofmeyer to do, because she has referred us to this other bundle, that is bundle DD18, which speaks of a JV. So I want now Ms. Hofmeyer to show us what kind of communication is mentioned in the RFB, under which the JV falls.
Yeah, no, please leave Ms. Hofmeyer to do her job as she sees fit. You will come in at re-examination and either exploit whatever you believe is a weakness on how she did the job, but leave that for re-examination. Ms. Hofmeyer.
Thank you, Chair. So, Ms. Kwinana, I understand your evidence to be that you and the Chair agree on your understanding of that clause, that there's no exceptions, that the bidder will be eliminated from the process. And I actually do want to add clause 1.6.3, because I think if there was any debate, which I don't think there can be, 1.6.3 concludes the point, because it says no discussions will be entered into surrounding elimination through non-compliance in clause 1.6.1. So I would say what was already clear in 1.6.2 is emphasized again in 1.6. We're not even going to debate the issue. If you communicate, you will be eliminated. Now, Ms. Kwinana, if you as a board member, the chair of SAAT, had this brought to your attention when you decided to award this joint venture to AAR and JM Aviation, would you have said, they've been eliminated, I cannot award this to JM Aviation and AAR?
What the management would bring to the board, they would bring, say, a recommendation for the cancellation of the tender.
Please raise your voice.
Sorry, Chair.
Yeah.
So what I'm saying, Chair, what would come to the board would be a recommendation from management, from the CEO and his executives, to say there are flaws in respect of this tender, and therefore we recommend that the tender be cancelled. And then they would state whatever the reasons that they put to cancel the tender.
Ms. Kwinana, I'm sorry, please, there's no need to give a long answer to this. The question that Ms. Hofmeyer is putting to you is, if you knew this rule as it reads, and you have told me what your understanding is of it, and it is the same as my understanding, if you knew this rule and you knew what had happened with regard to this communication, would you have taken the attitude that therefore this bidder had been eliminated, or would you not have done that?
Chair, how basically we decide, I wouldn't just say eliminate the tender. Even if I knew, I would take it to the board and get the circumstances surrounding that before the board decides that the tender must be cancelled.
I mean, you have agreed that this rule doesn't make provision for exceptions. So what circumstances would you look for?
How we decide, Chair, at the board, even if I knew this information, there is no way that I would go in the passage and say, this bidder is eliminated, even if I knew about it.
No, it's not about the passage, it's about in your own mind, what would you understand the effect of a breach of this rule to be? Would you accept that the effect was that this bidder was eliminated, or would you say the bidder was not eliminated even though the bidder had acted in breach of this rule? Now, on your own, once you know that this is the rule, this is what it says, there are no exceptions that it provides for, this bidder has acted in breach of this rule.
Chair, I wouldn't be in a position to do that on my own.
You would have to take a view. I mean, that's what Ms. Hofmeyer wants to establish from you. What is the view that you would have? Would it be that a breach of this rule means the bidder is eliminated, or would you start saying, well, there must be some exceptions, or would you say, no, it's not eliminated? Because when you meet as a board, you must have thought about issues and taken a view yourself.
Of course, Chair, looking on the face of it, before considering the reasons why and circumstances, on the face of it, I would be of the view that the bidder should be eliminated. However, as I said, I would not be in a position to say eliminate on my own. I would gather some evidence and find out what happened and whether indeed that should be eliminated. And in fact, that would be decided not by me only as the chairperson, but also all the members of the board.
Well, you know, Ms. Hofmeyer drew your attention to clause 1.6.3. And I think she is right in saying, if you look at that clause, if there was any doubt that anybody had about the meaning of clause 1.6.2, that doubt is removed when you get to clause 1.6.3, because the message is clear. A breach of this rule is so serious that the company will not entertain any discussions with the bidder about the elimination. If you are eliminated because you have acted in breach of this rule, there will be no discussions, you are cut off. That's how serious the company took this issue of communication between a bidder and officials within the company other than the project manager. This says we have one person to talk to or communicate with about the bid. This is the project manager. So you can't say you don't have anybody to talk to. But if you then go and communicate with somebody else, you are in breach of this, you have been told this, you know about it because it's included here. There'll be no discussions. You are eliminated. Now, do you have any doubt that that's how emphatic the message underlying this clause is?
No, Chair, I have no doubt.
You have no doubt. Okay, all right. Thank you, Ms. Hofmeyer.
But then, Ms. Kwinana, in fairness to you, I don't really understand your resistance to saying, absolutely. If this came to my attention as the chair of the SAA Technical Board, that a bidder was being proposed to the board to be confirmed for this contract that ought to have been eliminated, you wouldn't resolutely say there's no way that they can be awarded this tender. Why do you resist saying clearly they should have been eliminated, they shouldn't have got this tender?
I'm not resisting, Chair, but I'm emphasizing the collective board decision, because definitely I wouldn't say this is eliminated. That's why I'm saying we would take it to the board and decide as a collective. So basically, that's not how we decide. I don't decide alone, Chair, in the board.
But Ms. Kwinana, I've told you what Ms. Hofmeyer is looking for is your own judgment of what is permitted and what is not permitted if there are rules that say A, B, C, D. You might not be the person in a particular case to make the decision, but you can have a view. And in this case, when you are chairperson of a board, you are the leader, and you should show the way. You should be clear about what the rules are. You should be clear about how the rules must be enforced, compliance with the rules. So if you say it's the collective might have to take a decision if the power to make the decision is given to the collective. But that doesn't mean you can't or shouldn't have your own view of what is permitted and what is not permitted in terms of the rules. You understand?
Yes, Chair.
Yes, okay, all right. Ms. Mbandra?
Chair, I know you are going to be frustrated with me, but I still feel the question that is put to the witness is incorrect. Because we were not referred to something in the RFP that says communication between two bidders about a JV is a violation of the provision of that RFP.
Yes, I'm going to say again, Ms. Mbandra, when you re-examine, you can get that clarified. Ms. Hofmeyer?
Thank you. So can I then take it to be your evidence that, Ms. Kwinana, you accept that AAR and JM Aviation should not have been awarded this tender because they should have been eliminated?
As I said, Chair, I wouldn't say they should have been eliminated or not, because the circumstances surrounding that. My lawyer wants to clarify something, and we are unable to do that. And therefore, what you are saying to me, you are saying I must agree that I should have said that, and therefore, I will not do that, Chair.
Hang on, Ms. Hofmeyer. You see, Ms. Mbandra, this is what I was talking about. That when the witness is still being asked questions and you raise the issues that you raise, this is what's going to happen. Now she is saying, because her lawyer is raising a certain issue, she's not going to answer that. It doesn't do her any good. She should be seen to be giving her evidence without assistance from anybody, you see. But if you do that, it gives rise to that perception, even if you might not intend it that way yourself. Okay, Ms. Hofmeyer, what was your answer, Ms. Kwinana? You said you will not give an answer, or what was your answer?
I was saying, Chair, I wouldn't with certainty say they should have been eliminated or not, because, as I said before, that would depend on the circumstances. And I have seen these clauses, but now they needed to be read together with the whole bid and together with what was discussed here. And therefore, there needs to be some alignment between what is discussed here and also with the RFP.
I'm not in any doubt that the communication with Ms. Memela and Ms. Sokulu was about the bid. Are you in any doubt about that?
It's the communication is about the JV, Chair.
The agreement.
The communication.
Yes, it relates to the draft agreement. That
Yes,
relates
there
to
are two. It's the draft agreement is the first email. The second email attaches the bid, and says, is it acceptable?
Yes.
That's what the second email says.
Okay,
That
this one is the JV. And then where is the email that attaches the bid?
367.
I'm sorry,
Oh, okay.
we moved from the.
Apologies, we did, Chair. So we're in DD 18 at 367.
At DD 20,
No, DD 18
yes,
at 367.
367.
Yes, because remember, there were two communications on the 14th of January. I took you to the first email, that's at 4 o'clock in the afternoon. There was a moment of some humor in Ms. Mamela's evidence because she had indicated that she would use her non-SAAT email address for communications after hours, and then I asked her, is 4 p.m. after hours? That's why that one stays in my memory quite clearly. And then there's the later one at 8 p.m. where it's now no longer the JV, it's the bid proposal, which you see attached at 369, and it's asking Ms. Sokulu, who addresses Ms. Mamela as Cuz, here is the latest proposal, please let me know if it is acceptable.
And I was told CAS is abbreviation for cousin. What I've just said might distract you from what you were looking for. I think what you were looking for was the communication, whether it was about the bid or not. I think Ms. Hofmeyer has referred you to page 368, communication. Is it 368 or 36?
367 is where it starts, Chair.
Yeah, that's where
That's
it
the
starts.
email, correct?
Yes.
And then if you go to 369, that is the bid.
Yes.
Yes, Chair.
So now you have established, we have established, Ms. Kwinana, that it was a question about whether the bid proposal was acceptable, and do you then accept that JM Aviation and AAR should have been eliminated?
Yes, Chair.
And then they shouldn't have been awarded this tender, correct?
Yes, Chair.
Right, so you don't anymore. You began yesterday and this morning to say you stand by all of these decisions. I take it that you don't stand by this one anymore.
I don't stand by which one?
The one in
award.
terms of which they got,
award.
yes, when they breached the tender rules and should have been
When they
eliminated.
breached the tender rules, yes, Chair.
That's the one that they finally got on the 9th of May when the board met and gave them the tender for 5 years with AAR and JM Aviation. It's in that process that they should have been eliminated. Do you accept that?
Yes, Chair.
Thank you. So and in fairness to you, given that concession, we don't need to spend time on the way in which the decision was motivated at the time, because this information was not brought to your attention at the time, was it?
No, Chair.
Do you regard it as an obligation on Ms. Mamela to have disclosed it to the board, that she had received this communication while the bid was still open from one of the bidders?
I think Mrs. Mamela, of course, if she received it, should have not even disclosed it to the board, but eliminate. So basically, it would not even come to the board.
That's true, and actually that's an important point, because earlier you said what would happen if this was discovered is that there'd be a recommendation that came to the board to cancel the tender. I want to suggest to you that's by no means what would happen. You don't cancel the tender, you just eliminate the bidder who's breached the rules, and you let the remaining bidders stay in the process, don't you?
Yes.
Yes, so that's what should have happened. It shouldn't have even been before the board to approve AAR and JM Aviation, should it?
Yes, Chair.
And it was Ms. Mamela who held information that she did not disclose to anyone, which, if she had disclosed it, would have eliminated the JV of AAR and JM Aviation, correct?
Yes, Chair.
Thank you.
And if, for whatever reason, she thought that AAR should not be eliminated because of the breach of this rule. At least she should have disclosed to say, there's been this communication, this is what the rule says, but I take the following view. She shouldn't have just not eliminated them and not have disclosed to some higher authority, isn't it?
Yes, Chair.
Okay.
And Ms. Kwinana, in the process that did lead up to the board's decision on the 9th of May 2016, you received submissions from the then acting CEO of SAAT, Mr. Malola Piri, correct?
In respect of the tenderers,
Yes. Because he made the recommendation to the board. Remember, they were recommending Air France, and at the board meeting on the 9th of May, you and your fellow board members decided not to go with management's recommendation, and you went for the joint venture of JM Aviation and AAR. Do you recall that?
yes, Chair.
And all I'm clarifying is the person who makes that submission to you was the then acting CEO, Mr. Malola Piri, correct?
Yes, Chair.
Thank you. Now, I want to just move to your communications at this time, because during this time, you were having a number of telephone conversations with Mr. Nzeku, weren't you?
I wouldn't know until you show me, and that's very possible.
It's possible. So while a tender is open, in respect of which JM Aviation and AAR are joint bidders, you were having communications with the director of JM Aviation, is that correct?
Yes, Chair.
Are you not concerned that that would not be appropriate in the circumstances?
Chair, I really would not be concerned. The reason being that, as I told you about the processes, and as I told you about the fact that basically the only time that we know is when the documentation is in front of us. And I also told you that there are many tenders at SAA Technical, including SAA. And I do not have a record where I would say the tender is starting now and then the tender is ending there. So with me not being involved in the tender process, I would communicate freely with Mr. Nzeku without knowing that there is a tender that is going on, or without registering that there is a tender going on.
Well, remember I asked you about Mr. Piri's submissions to the board. In your own affidavit, you explained that there were some earlier submissions where Lufthansa was first, and then you asked them to go back, and then there were later submissions, and then what came was Air France. Do you recall saying that in your affidavit?
Yes, and in fact, I also stated the reason why they were taken back
Correct.
is because there was a disagreement between management in front of the board, where the CFO was in disagreement in terms of, I think, the process, basically. And then I said, you cannot fight in front of us. Go back and make sure that you come with the same voice. So basically, they did go back and came with the same voice, and The process continued.
Yes, but that means you knew when you were speaking to Mr. Nzeku that he was a bidder in this open tender, because you'd already had that interaction where you'd asked him to go back, where they were privileging Lufthansa over AAR and Air France. They came back to you again. In all of that time, you knew full well, Ms. Kwinana, that JM Aviation was a bidder.
The date when we told them to go back and when they came back, I don't think there was much difference. That is point number one. Point number two, Mr. Nzeku is not operational. And I don't even think that he had even an input into this. Hence, I said yesterday, basically, in fact, I made a practical example where, like, if a person goes to the shopping center and then you come across a person, maybe you would even know that there is a tender here, and maybe the person doesn't know that there is a tender there. So basically, my interaction with Mr. Nzeku was not in any way about the tender that was happening there.
That's a different answer to the one you gave earlier. The earlier answer was it was okay for you to communicate with Mr. Nzeku because at the time you were communicating with him, you didn't know JM Aviation was a bidder. I've now shown you how that can't factually be so. So your answer is now, as I understand it, that it's okay for you to have been communicating with him because you weren't talking about the bid. Is that correct?
That's also what I said yesterday, Chair.
No, I'm saying how it differs from the evidence you've just given now. I'm not suggesting you didn't say that yesterday. What I'd then like to understand is how do you know he wasn't operational at JM Aviation? I thought you weren't talking to him about anything specific to JM Aviation.
Of course.
Of course. So how do you know he wasn't operational?
That's exactly the reason, because if he was operational at JM, he would basically talk about JM. Yes.
Kwinana.
Yes.
Ms. Kwinana.
Chair.
Are you sure that's the answer you are giving?
Yes, Chair.
Yes.
And in fact, that's the answer I am
The reason why you know that he was not operational is because he was not talking to you about operational matters.
Of course, yes, Chair.
Yes, Ms. Hofmeyer.
Thank you, Chair. Ms. Kwinana, you even spoke to Mr. Nzeku the day before the board took the decision. Do you remember that?
No, Chair, I don't remember.
You spoke to him at 7:12 in the evening. You don't have a memory of that?
No, Chair.
No. Okay, do you want me to take you to the cell phone records that show that, or will you accept that that took
I will
place?
accept it, Chair.
Thank you. Right, then I'd like to move to, well, in fairness to you, do you accept that it was highly irregular for you, the chairperson of the board of SAA Technical, to have numerous conversations with a director of a bidder while the bid was open in advance of you taking the decision to award it to him and his joint venture partner?
Chair, I don't take it as irregular. We were not talking about the bid. And in fact, also my talking about the bid would end in the boardroom. And I don't think Mr. Nzeku would talk about the bid anyway. And as I told you that we were talking about the whole lot of things. And therefore you can't assume that when we are talking at 7:10 in the morning or whatever time, we are talking about the bid.
We have only your word for that, don't we, Ms. Kwinana?
Yes, Chair.
Thank you.
What about that rule that we talked about earlier on? Would it not have applied to you?
Chair, we were not talking about the RFP here.
Yeah. Yes. So, in your view, how would the role be policed by the company if people who are going to be making decisions could have telephone conversations with whichever bidder they wanted to talk to, even the day before the decision is taken? How would the company police this to make sure that there is, that people within the company, whether board members or managers, to make sure that they don't discuss matters relating to bids with bidders? How would they police it? Who is there to police you and Mr. Nzegu when the day before you decide the bid, you are having a telephone conversation in the evening?
Chair, I said earlier yesterday, Mr. Nzegu is involved in many other businesses.
Yeah, that
And
doesn't
in
tell me
fact-
how the company would police this. Then my question is, if the position was that as a decision maker, if you are going to make a decision tomorrow on a bid, the evening before, you could phone one of the bidders and have an hour-long conversation with them. It's fine, as long as you don't talk about the bid. How will the company know that during that hour-long conversation, you didn't talk about the bid?
Maybe how the company would know, would tape the conversation, for instance, and bring it to the attention of the relevant authorities.
Well, if you don't phone it, if you don't talk on the phone, but you phone each other to make an appointment and meet at a restaurant and enjoy wine and dinner for 2 hours and then talk about the bid, how will the company know you talked about the bid? You do that the day before you make a decision on the bid, and this person comes from a company that has put in a bid for this. How will the
Chair-
company enforce this?
Chair, I wouldn't know about the controls surrounding that, but it also would depend on the integrity of the people involved.
So it would just depend on the people. Once you say it depends on the integrity of the people, it also means it depends on the lack of integrity on those who don't have integrity.
Yes, Chair.
And therefore,
I'm
the rule can't be enforced because everyone will. I mean, if you did talk about it, or any official or board member who talked about the bid with a bidder would not admit that they talked about it because they would know that then they would have acted in breach of the rule and that bidder would be eliminated. So they would not admit it. So in the end, the rule would not be enforceable, which is why you might have a situation where the company says there must just be an absolute prohibition, no communication whatsoever. Because if we are going to say you may have communication but don't talk about the bid, we will never be able to enforce that rule. So the best thing is to say no communication whatsoever between somebody who has decision-making powers on a particular tender and any one of the bidders while the tender is open. You understand that?
Yes, Chair.
Okay.
Then I'd just like to deal with the signing of the agreement between SAA on the one hand and AAR and JM Aviation on the other. Were you involved in that signing?
No, Chair.
You weren't. You don't remember a meeting at which you asked for the couriered copy of the agreement to go and be fetched?
The only thing, Chair, I remember regarding the contract, or maybe say regarding the agreement, is that I went to SAAT after I received a letter from the chairperson of SAA and also received a letter from National Treasurer saying they want, and then also I think the newspapers, we also had to respond to the newspapers about this tender. And then I went to SAA, and then SAA technical. And then I said, that was the acting CFO. I said,
Who was
National-
that? Sorry?
Asin Malol.
He was the acting CEO. Sorry, you said CFO, so I just wanted to check. You were speaking to Mr. Malola Piri, is that right?
Yes.
Acting
Yes.
CEO. Continue, please.
Yes. And then I said to them, I received this letter, which we needed to respond to. Can they please make sure that all the files, everything is taken to National Treasurer? Because also the chairperson of the board was saying, I think she received the letter from National Treasurer, and therefore the files were required at National Treasurer.
So that's the only meeting you recall, is that right? You don't recall being involved in a meeting when the signing of the contract took place?
Definitely no.
Definitely not.
Yes.
Ms. Kwinana, you always say it with such conviction, so I just want to check again. You have no recollection of being in that meeting when it was signed?
No, Chair.
No. So if Mr. Malola Piri had given an affidavit to this commission in which he'd set out in detail your presence at that meeting and what you said in it and your role in it, would you say he's made that up?
Let me see what he is saying, Chair.
Certainly. You'll find that in DD 25C. So that is also Ms. Mamela's bundle, and it's Exhibit DD 25C. And we'll go to page DD 25C at page 790.
Page 791.
Well, the one I want to start at is 790, but I do just want to orientate you. So this is an affidavit that Mr. Arsen Malola Piri provided to the State Capture Commission. It commences in DD 25C at page 773, but we are going to pick it up at page 790. Chair, I just want to ensure that Ms. Mbanjwa has the file and
Yes,
is
no, that's fine.
comfortable.
Thank you.
Ms. Mbanjwa, we are at page 790 within Mr. Piri's affidavit, and I'd like to start at the bottom at paragraph 105. Right, so what Mr. Piri says in this paragraph and some of the following ones, I'm just going to highlight a few features. He says, well, let's start at 104. I cannot recall who brought me the execution version of the contract for my signature, but I vaguely remember that the chairperson had called an impromptu, unscheduled meeting at the SAAT boardroom, which included Ms. Mamela. I cannot recall further details. However, as far as I can recall, Ms. Kwinana expressed with a firm voice that she would not leave the boardroom until the AAR contract was signed. Ms. Mamela then indicated that the contract was at the time in the process of being sent to her via courier for SAAT signature. It was at this point that Ms. Mamela gave an instruction to Ms. Kwinana gave an instruction to Ms. Mamela to get the airway bill, AWB number from AAR to track the parcel, the contract. Ms. Mamela then obtained the AWB number and subsequently traced the parcel to a warehouse in Johannesburg. Can I just stop there? Is this helping with your memory? Do you recall this interaction?
No, Chair.
No. He goes on, Ms. Kwinana's driver was then requested to collect the parcel/contract whilst we were all waiting in the boardroom for the driver to arrive. Ms. Kwinana requested that we respond comprehensively to the complaints raised by staff and labour unions against SAAT management. The complaints were addressed directly to the SAA board chairperson, Ms. Dudumieni, for her intervention. That's the part that you've just told us you do remember, is that right?
Yes, Chair, but it was not the complaint raised by staff and labour unions. I can't remember well, but the letter was coming from SAA chairperson.
Yes.
And from National Treasury.
Right, right. So that part you remember, but you have no recollection of saying, we're not leaving this room in a firm voice until this contract is signed, getting Ms. Mamela to go and track it, getting drivers to go and pick it up. You have no memory of that.
My understanding, Chair, was that the contract was already signed when I went there. And hence I was saying, make sure that the files that the National Treasury wants are in place, and then you take them together with the contract.
You see, Mr. Maolola Piri's version is that you played a much more active role in that meeting. If you go to paragraph 108, this is when the driver comes back with the contract or the parcel. The contract delivered was already signed by AAR's president. Ms. Kwinana then requested that I sign the contract as it was signed by the president of AAR, so it would be in alignment with that the contract be signed by the acting CEO on the SAAT side. At this point, I requested Ms. Mamela to go through the contract before I signed it, given that she was leading the team that negotiated the contract. Ms. Kwinana also went through the contract and was happy for me to sign. It was on Ms. Mamela and Ms. Kwinana's go-ahead that I signed the contract. And then he attaches a copy of the signed contract to his affidavit. And then if we just go on to 110, as far as I recall, Ms. Kwinana wanted the contract signed as a matter of urgency in order to ensure the SAAT could access cost savings within a matter of weeks. However, her behavior at the meeting was, he says, over the top, bordering on being aggressive. Do you deny his account of this meeting and your involvement in insisting that the contract be signed?
I would not insist that the contract be signed because, according to my recollection, when I got there to say we need to respond to this and we need to take the files to National Treasury because they want to audit them, then the contract was already signed. Of course, maybe I may have been aggressive in the sense that when the National Treasury wants something, National Treasury basically is our finance department, and therefore there is no way that when they say we want this information, I can take it lightly.
But why were you even getting involved in those things, Ms. Kwinana? That's for management.
Yes, Chair.
Why
That
were
is-
you?
that is
There was
for
a CEO or acting CEO or SA Technical. Why were you getting involved in which contract is being couriered from where? The driver
No,
must go
Chair.
and fetch
No,
it.
Chair, I was not involved in that. The reason why I went to SAAT is because I received a letter from the chairperson of SAA addressed to me and received a letter from Mr. Chitangano of National Treasury saying that they want to audit basically the process. And therefore, I had to go to SAAT and instruct management that this is what is required. Of course, I don't even know where the contracts are filed. I'm not involved, as I said before. But I would have to give direction and make sure that all the information that National Treasury wants is submitted to National Treasury.
Ms. Hofmeyr.
Thank you, Chair. Ms. Kwinana, I do want to pick up on a point that the Chair has just highlighted with you, and that's this question of the degree of your involvement in matters going on at SAAT and at SAA, quite frankly, in relation to procurement, because you've previously given evidence, both yesterday and you confirmed it today again, and I was really quite specific to be clear that I understood your evidence. You confirmed that other than that 10 February encounter in 2016 with Swissport, you didn't have any other meetings. You did not involve yourself in that contract process. That was to be left for management, correct?
Yes, Chair.
Yes. You see, I was reminded by my faithful team that there is an email suggesting something to the contrary. So we took efforts to have it copied over the lunch break. I'd like to ask an opportunity to hand it up. I am well aware that Ms. Mbanjwa and Ms. Kwinana may not have seen it recently, so they must please take the time they wish to consider it.
Yeah.
And Chair, if we could enter it as Exhibit 33.23.
Is that exhibit BB?
DD 33.
Point
23.
23. Is this a few emails or one email?
It's actually just 2 emails. It's an email you'll see at the bottom of the first page from Ms. Kwinana to Mr. Peter, and then it's Mr. Peter's response.
Okay, the document containing an email from Ms. Yakhe Kwinana dated 20 January 2016 to Mr. Lester Peter, as well as an email from Mr. Lester Peter to Ms. Yakhe Kwinana, which consists of 3 pages, is admitted and will be marked as Exhibit BB 33.23.
Thank you, Chair.
Okay.
So, Ms. Kwinana, it starts at the bottom of the page with an email that you sent to Mr. Peter on, as I have it there, the 20th of January 2016 at 7:37 in the evening. Have you had a chance to consider it?
Let me read it, Chair.
Certainly.
Yes, no, that's fine.
Chair, I just don't remember this.
See,
Yes.
what it appears to be, Ms. Kwinana, is an email that you sent to Mr. Lester Peter on the 20th of January 2016, and the subject is meeting with Swissport. And you address it, Dear A:CPO, which I take to be Acting Chief Procurement Officer, because remember, he's now replaced Dr. Dawa. And you say, yesterday I had a meeting with one of the shareholders of Swissport, Mr. Vuyo Nzegu, Mr. Peter Cole, in brackets CEO/CFO of Swissport, Mr. Dulakolo Peter, a BEE partner of Swissport. The purpose of the meeting was that the BEE partner was concerned about the status of the contract. And then you go over and you summarize the resolutions of those discussions that you'd had. And you say, I promised that I would get back to them after consulting as to what happened and if what they are suggesting is possible or not. So you have no recollection of this, do you?
Ms. Hoffman,
Apology, Chair.
I think it might be convenient if you just read that
You read the whole
last page, yeah.
Thank you.
For the benefit of those who are listening.
Of course,
Yeah,
I do occasionally forget about them with respect. So,
Yes.
all right, so what happens is you talk about the meeting, you say that the BEE partner was concerned about the status of the contract, and then you go on and you say, this is the summary or resolutions of yesterday's discussions. 1, Swissport wants the current contract, which includes ground power unit, crew transportation, and ground handling. The first 2 items are not part of the approved tender that needs to be signed. 2, Peter said in the event that the first 2 items cannot be added, they will pull out, as there will be no business motivation to continue with ground handling only. They will pull out of this contract. I promised that I will get back to them after consulting as to what happened and if what they are suggesting is possible or not. Thank you, Yakhe Kwinana. Do you not have any memory of this email?
Not at all, Chair. And the other thing that is strange here is that, okay, I don't know what email is Yakhe Kwinana 2.
It's the one that you often get emailed on at SAA. I can show you lots of them. There's a Yakhe Kwinana 2 and a Yakhe. I'll find one of the emails.
So that is the SAA email.
Let me find it for you. Well, no, hang on. I think it's your personal one, because if you go up to the response from Mr. Peter to you, you'll see Yakhe Kwinana 2 seems to be yakhe@kwinana.co.za. I've certainly seen that before, I can tell you, in some of the emails that you were sent. I think you were often sent emails at your Fly SAA one and at your Yakhe Kwinana one, which comes up as Yakhe Kwinana 2. I can try and look for some if that would help you. But does that resolve it for you?
I still do not remember this, Chair. And secondly, I don't know why the footer would be the SAA.
No, let me explain why. Because, you see, it's Mr. Lester Peters' email at the top, which is flysaa.com. So it takes his footer, because it's actually his email in which he responds to you that contains your email, right? So it's his flysaa.com email that contains the footer. It's your Yakhe Kwinana email in the middle. But we now, as I understand how these things come out, because we've seen many of them in our 2 years. But that aside, are you suggesting this is fabricated?
I think so, Chair.
You think it's fabricated?
Ms. Kwinana, you may be well advised to just reflect before you can say it's fabricated, to make sure that you don't say it's fabricated unless you
I'm
really
saying,
have
Chair, I
grounds.
think it is fabricated.
You think it's fabricated?
Yes, Chair.
Okay. Okay, Ms. Hoffman.
Oh, thank you.
Do you have an idea who may have fabricated it? Ms. Kwinana?
No, I don't know, Chair.
You don't know? Okay, all right.
Because if it's not fabricated, then it's inconsistent with quite a bit of evidence you've given at this commission, isn't it?
If it is not fabricated, it is inconsistent. What does that mean?
If it is authentic, if you did send such an email, that's what she means.
If I did send such an email,
If you did send such an email, she says it would mean that it is inconsistent with a lot of evidence you have given. That's what she is saying to you. If you did send it.
oh, okay.
Do you
would
accept that?
Yes, Chair.
Yes.
Okay.
And I'd just like to highlight what those are. First of all, you indicated to us yesterday that Mr. Dulaklolo Peter, to your understanding, was part of Swissport.
Yes,
This makes it clear he was not part of Swissport. He was the BEE partner who was going to join Swissport in relation to the Swissport agreement. On its terms, that's what it says, correct?
My understanding of Dalukolo's involvement, and in fact, the way he was introduced to us, I was thinking that he is part of Swissport. How he would be part of Swissport, basically, I wouldn't interrogate them as to how is he related to Swissport, but they had always been together.
No, but your own email draws a distinction between Swissport representatives and Mr. Peter. Your own email says the shareholder of Swissport was Mr. Vuyo Nzegu, the CEO/CFO of Swissport was Mr. Peter Cole, and Mr. Dulaklolo Peter was there as the BEE partner of Swissport. So that is separate on your own description of them, if this is an authentic email. Do you accept that?
If this is an authentic email,
Yes. So that is why your testimony yesterday would have been false. The second respect in which your testimony yesterday and repeated again this morning would have been false is because you repeatedly said you had no other meetings with Swissport in relation to this contract, barring the encounter on the 10th of February. Again, if this is authentic, that means that evidence was false, correct?
yes, Chair.
Yes. And it also shows a level of involvement in finalizing this contract that you previously accepted should not be a level of involvement from a member of the board of SAA, correct?
Finalizing which contract? Are you
The
talking about?
Swissport contract,
The Swissport contract.
in respect of which Jamicron, which is the entity that Mr. Dulaklolo Peter was representing, was going to be the BEE partner.
Chair, I'm not aware of the contract. As I said, I do not get involved in signing the contracts. We did talk about the tripartite contract, which basically I was not party to. We did talk about the Swissport contract, which basically does not have anything to do with me.
Yes, but this email says you are involved in the contract. Because if this email is authentic, you had a meeting with the BEE partner of Swissport representatives, at which the BEE partner was, and I'm quoting, concerned about the status of the contract. So here you're getting involved in the contract. Do you accept that if this is authentic?
If this is authentic,
You accept that?
yes, Chair.
Thank you. Right. I would then like to know, Ms. Kwinana. Oh, no, sorry, before we move on, I do want to put to you, in fairness, for your opportunity to respond, what we will likely submit in due course is the overwhelming impression created by your evidence thus far. The first is that AAR and JM Aviation were unfairly favoured in the tender processes that your board at SAA Technical decided. Do you accept that that is so?
Yes, Chair.
Do you accept that they had access to you and to Ms. Mamela when no other bidder had that access?
No.
You don't, and why not?
As I said, we went to AAR Chicago, and also other bidders had been visited by the SAAT team.
Apologies. I take that point. I should have been more precise.
She's talking about the bidders in this tender.
Yes.
In which tender?
The last tender that was awarded to AAR and JM Aviation, in that process, from December of 2015 to your decision on the 9th of May 2016, JM Aviation and AAR had access to you and Ms. Mamela when no other bidder did?
JM Aviation, because of this,
JM Aviation,
so
because of the conversations you
You
had?
are talking about Swissport now.
No, we're on AAR and
You are
JM
now
Aviation.
on AAR, so we are no
Correct.
longer talking about this.
Yes, remember I
Oh,
said we
okay.
went to that because of something that you'd said in the evidence, and I was reminded about the email. In fairness to you, Ms. Kwinana, let's put that aside.
Okay, so we're going back to AAR.
We're focusing on AAR and JM
Okay.
Aviation, right. I said to you, do you accept, because we will likely submit in due course, that AAR and JM Aviation had access to you and to Ms. Mamela when that final tender was open, in circumstances where no other bidder had that access to either of you?
I said, Chair, Ms. Nzeku, and I.
I'm
What?
sorry, just start afresh. I didn't hear a thing.
I said, Chair, Ms. Nzeku, Mr. Nzeku, and I had numerous things that we were talking about. And I said, Mr. Nzeku was not involved in operations. And I said,
Yes, hang on. Remember, the question is simply that he had access to you that no other bidders who were bidding for that tender had with you.
this policy, Chair, that we did read was saying communication in respect of this RFP.
Yeah, please don't, for now, don't think about the rule, because the question didn't make any reference to the rule. The proposition is simply this, or the question is, do you accept that JM Aviation and Swissport had access to you and
Sorry,
Ms.
and AAR, Chair.
Oh, I'm sorry, and AAR, I'm going to confuse you. And AAR had access to you and Ms. Mamela that no other bidder in that tender during that time had with you or Ms. Mamela. Factually.
I don't agree, Chair, in respect of me. The reason being that, as I said before, Mr. Nzeku and I, we have got many companies outside SAA. And
The question
therefore-
doesn't talk about companies. It simply says, do you agree, do you accept that during that time, JM Aviation and AAR had access to you that no other bidder who had put in a bid in regard to that tender had with you? Factually,
I don't agree, Chair.
they did not have access to you.
No, Chair.
They did not speak to you.
Mr. Nzeku spoke to me not in his capacity as JM Aviation.
Yes.
And as I was saying.
Yes, so in whatever capacity, he did speak to you, is that right? Whatever the capacity was.
Maybe, Chair, you may ask and say Vuyonzeku.
Sorry?
Maybe you may say Vuyonzeku instead of say JM Aviation, because in my interaction with Mr. Nzeku,
Oh, okay.
it definitely was not in regards to
Okay,
the
all right.
bid.
Okay, so your problem with regard to the access that happened between yourself and Mr. Nzeku is where we say JM Aviation. But if we say Mr. Nzeku had access to you, factually that you accept.
I accept.
Okay. Ms. Hofmeyr.
And that AAR wined and dined you and other members of the board and management while a tender was still open. Do you accept that?
I think we're going back, Chair, to what we discussed before.
We are, and in fairness to you, I have to put to you what we are likely to make submissions on in due course. It is going
You know,
back.
Chair, this dining and wining and the effect on tender, I really do not see any significance in respect of that. And in fact, as I said, this has been the tendency or the,
Yes,
the practice or the practice.
Ms. Kwinana, we discussed that earlier on. At this stage, it would help if you simply answer the question whether factually that is so. Namely, did AAR wine you and dine you while the tender was open? Is that factually true?
Chair, I don't like the term of being wined and dined as
Okay, all right. Just use another one. What term would
They
you
put-
use?
I mean, it seems as if ngoku I am a hungry person and then now I'm happy that I'm being dined. Oh, Chair, oh no.
Okay, how would you put it in terms of what happened?
Maybe if you can say, Chair, we visited AAR.
Yes.
That would be better.
Okay, all right.
Thank you.
Ms. Self-Mayor.
Now, I'd like to ask whether you accepted moments ago that they were unfairly favored in this process. And I want to know whether you received any benefit from either of them as a consequence of that unfair favoring.
No, I did not receive any benefit. And in fact, you said we were driven in limousines and private jets, and I don't consider that as a benefit.
Right. Would you consider receipt of money as a benefit?
Yes, Chair, depending what's the purpose of the money. If, for instance, the money is given to me for me to spoil myself,
Yes.
then that would be fine. I would take it as a benefit.
When would it not be a benefit?
But remember that the amounts that Zanospark received were not for my benefit. The amounts that Zanospark received are still for the benefit of Mr. Nzeku and his wife, whom we did not know that she was the wife at the time. But be that as it may, it wouldn't make any difference. But the monies that Zanospark received are for the forex trading.
Right.
So they are not for my benefit.
Okay, let's move to the forex trading and Zanospark then. Tell me a little bit about Zanospark. When was it established?
It was established in 2016.
What month?
Together with 3 other companies that I established in 2016.
Right. What month do you recall?
Maybe February.
It was February, according to the SIPC records. So you established it and you started with your daughter, Ms. Goniwe, is that correct?
Yes, Chair.
You were the 2 directors when it was established in February 2016, is that right?
Yes, Chair.
I understand she's no longer a director, you're now the sole director, is that correct?
Yes, Chair.
Why has Zanospark not responded to the summons that it received from this commission many weeks ago?
We responded to the summons.
No, when you respond to a summons, you either have to produce the documents or you have to provide an affidavit explaining why the documents cannot be produced. Why have you done neither of those 2 things?
We don't have the documents, Chair.
You would have been, and you've been told many times you needed to say that on affidavit. Is that now your evidence?
I said that on the email, Chair.
No, you did not. I could take you to it in a moment, but is your evidence now you confirm under oath none of the documents that were summoned do you have?
Yes, Chair.
Right, we can move on then. What was Zanospark going to be doing? You've mentioned forex trading. Was that its...
And other investments.
And other investments, but predominantly forex trading, correct?
Yes.
Because that's what Mr. Nzeku said your daughter conveyed to him when she approached him about investing in forex trading, correct?
Yes.
Right. Were you aware that she was contacting him to do that?
Who was conducting?
Your daughter, Ms. Goniwe, was contacting Mr. Nzeku about investing in forex trading.
Yes, she told me.
She told you. So that would have been 2016, sometime after February 2016, correct?
No, Chair. Before that. That was before that. They met. She said they met before that.
Before that, but the company was only established in February 2016, correct?
Yes.
It was established at the time that the bid is open for the components tender, because February 2016 is still before you decide it in May 2016, correct?
Zanospark has got nothing to do with the components tender.
We'll see if that is so in a bit of a while, Ms. Kwinana, but your evidence is that Zanospark was established to do forex trading predominantly and some other investments, is that right?
Yes, sir.
What other investments?
Any investment, basically. Sometimes property, sometimes venture capital.
Right. And that's investments for third parties, is that right? Not yourselves.
Also for ourselves.
For yourselves, but also for third parties, is that right?
Third parties, not the members of the public, but the people, like the people that we know.
The people that you know, like Mr. Nzeku,
Yes, sir.
with whom you had no personal relationship, correct? And you said previously you didn't know Ms. Hendricks was his wife, is that correct?
Yes, sir.
When did you first learn that she was?
When Mr. Nzeku was testifying here.
I want to spend a bit of time on forex trading because I have to confess I find it a little bit confusing. What does it mean to go long on a currency pair?
That means you are buying that.
What?
You're buying that pair.
Which pair?
Whatever, there are many forex currency pairs. There's USD JPY, USD ZAR, and there's NASDAQ, and the whole lot of other pairs. In fact, I think there are more than 400 pairs that you can trade.
But when you go long on a pair, what are you doing in respect of each part of the pair? Do you know? Because a pair is two currencies, right?
Yes,
Yes.
yes.
So how do you go long on a pair?
When you say you're going long on USD JPY, that means you are buying USD JPY. When you're going short, that means you are selling USD JPY.
Right. And that's the sort of work that Zanospark does, is that right?
Yes, through me.
Through you?
Yes.
Yes. Where do you do that trading?
On my computer.
But you need a platform for that. What platforms do you use?
IC Markets.
I beg your pardon?
IC Markets.
IC Markets. So let me just get it right. You would receive money in Zanospark, is that correct?
Yes, sir.
And then you would go onto this IC Markets platform, and then you yourself, Ms. Kwinana, then trades on the forex currency pairs. Is that correct?
Yes, sir.
Right, thank you. And what is a bid price?
It depends. It fluctuates all the time. It depends.
I'm drawing the distinction between bid and ask price. What's the difference between a bid price and an ask price?
It's like the buy and the sell.
Thank you. And tell me when Zanospark started operating, how big was its client base?
Much as that we registered Zanospark in 2016, I started to trade in 2014. Yes.
No, but I'm asking about Zanospark's client base. How big was it?
How big was it when?
When it started in February 2016.
Of course, when we started in 2016, the clients that we had, I think it was about maybe 8 clients.
8 clients in 2016.
Yes.
And so they would invest monies, correct? And then you would go onto this platform and trade for them, is that right?
Yes, Chair.
So you were receiving monies from third parties and you were trading on a platform for that purpose, is that right?
I also do not like this term of trade.
Sorry, I don't mean the public generally.
Because I don't go out and market and put it on advert.
No.
Yes,
You take the money of a select few
yes,
and you trade it for them, is that correct?
yes, Chair.
Are you aware that you need a license to do that?
No, Chair, I don't need a license.
You don't. Why don't you need a license?
It's because according to FSCA, there are specific companies which are mentioned there that require a license. For example, I may not mention all of them, but obviously the bank requires the license, the insurance companies and insurance brokers, and FSCA has stated those, and Zanospark is not one of them.
No, they've certainly stated that Zanospark doesn't have any license.
Yes,
But
because
is
we
it
don't
not a
need a
financial
license.
service? No, they don't say because it doesn't need a license. They say it doesn't have one, and then they tell us in the affidavit that you've seen, and we can now go to, which is in your bundle DD 33 at page 323.
Three, two, three.
Yes. Do you have that?
Yes, Chair.
This is an affidavit you've seen before, have you, Ms. Kwinana?
Yes, Chair.
And you've considered it.
Yes, Chair.
So what this is an affidavit provided by by Felicity Mbaso of the FSCA, the Financial Services Conduct Authority, in which, first of all, the authority was asked to confirm whether there is any license that's been issued either to Zanospark, to Ms. Goniwe, or to yourself.
Yes, Chair.
And they've confirmed that there is no license. You confirm that too, don't you?
I confirm that there is no license and I don't need a license to do forex trading, Chair.
They go on and they explain at page 324 the purpose of the affidavit, and that's to deal with the various ways in which licensing is required that might involve forex trading, right? So at 4.1, they say they're going to explain that persons who enter into financial services, who render financial services to clients in a foreign currency denominated investment instrument, including a foreign currency deposit, and in securities and instruments, including derivative instruments, are required to be authorized under the Financial Advisory and Intermediary Services Act. We'll call that the FASE Act for short. They also say that they're going to deal with the requirements for approval by the Conduct Authority of a clearing firm for a foreign forex service provider, and the requirements to be authorized as an over-the-counter derivative provider, which is summarized as ODP. And then, in quite a complex affidavit, they tell us the licensing regime for each of those. Is it your evidence that you are none of those?
I'm none of those.
Right, so you take money from clients, correct?
Yes,
You invest them in forex trading,
yes,
and your evidence is you don't need a license to do that.
not at all.
Why not?
It's because forex trading, Chair, does not fall under the FSCA Act. Yes.
Where does it fall under?
And as I said before, I said this terminology of the third parties, I do not like it because I do not advertise. I say to the people close to me, I say to them, or my colleagues, or my business partners, I say to them, this is what I do. And then if they want, they say, please invest for us. So basically, I don't need the license.
So as I understand your evidence, provided you don't advertise that you're going to be doing it, you don't require a license. Is that correct?
I don't go and solicit money from the people. The people come to me because they know that I do forex trading, and they say, I've got this money, can you do trading for me?
How do they know that you do this trading?
You also now know, Chair, that I'm doing forex trading, for instance.
Because you have
can-
conversations with them, is that
Yes,
right?
exactly.
Like Mr. Nzeku?
Yes.
Yes, so when your daughter approached him and said, we've started a new business and we're going to do forex trading, that wasn't soliciting his custom?
It's because Mr. Nzeku, when Lumka introduced herself, Mr. Nzeku got excited and said he was the friend of his late father. And therefore, he did not solicit money. They were together in Cape Town. She did not go there to solicit money. When they were talking, what are you doing? Lumka told him what he is doing. And then he got interested and said, when I have money, then maybe you can also trade for me.
And you put them in touch, did you? You put your daughter, Ms. Goniwe, in touch with Mr. Nzeku?
No.
No, that happened independently.
Yes, Chair.
Right. So how did you end up doing the trading for him yourself on the platform?
It's because when I am the one who is doing forex trading, Lumka doesn't, she does some limited forex trading. I would say I'm almost full-time in forex trading. So that's why the money would come to me, and then I put it in my credit card, and then I pay IC Markets, or I pay Altcoin Trader, or Skrill, or Altcoin, or Altcoin Trader, Skrill, or Luno, or IC Markets through my credit card.
So IC Markets is one, but altcoin and others are others. Is that correct?
Yes, Chair.
Where you trade the deposits that you've received from your clients, correct? Are there any limitations on those platforms that you can't be trading for other people?
You know, when I open an account there, I don't open an account using the names of other people. I open an account using my name. I open different accounts using my name. Yes. And then now, when there is time, then I would deposit the money in Zanospark or take the money from Zanospark, depending on which direction it is going.
Yes, but as I understand your evidence, clients, close clients, 8 of them, are putting money in Zanospark so that you can trade it for them on these platforms, correct?
Yes, yes.
Okay. Do you know if those platforms put limitations on you trading other people's money?
The limitations, Chair, when I have got this money in my account, that company takes it as my account. They do not know whose money it is because it goes into my account. Yes.
Yes, but aren't you limited by the terms and conditions of those platforms to only trade your own money, not a third party's money?
No, I've never seen that.
You've never seen that. So if I later show you the terms and conditions that place that limit, then would you be a bit concerned that you've been trading money on these platforms in circumstances where you're not permitted to do so?
Yes, Chair.
Great. Okay, right. So we established Zanospark in February of 2016, and you open bank accounts for Zanospark, as I have it, on the 15th of March 2016. Does that accord with your recollection? Yes, right. And the opening balance in there are a number of Zanospark accounts, so I have to remind myself, but I think it's in the business account, was 500 Rand. Do you remember that?
Yes, Chair.
Super. So let's see what happens. At that time, you told me you have about 8 clients, and now we're going to see in the bank account what happens with the money that you receive, correct?
Yes, Chair.
Okay, let's go to the bank account.
Ms. Hofmeyer,
Oh, we're close.
I think we must take a short
Certainly.
break. Are we all agreed that we can continue at least until 5:45? Ms. Mbanjwa, is that fine with you? Yes, Ms. Kwinana?
That's fine, Chair.
Okay, all right. It's about 4 minutes to 4. Let's take the break before Ms. Hofmeyer moves on to
Thank you.
something
Indeed,
else.
Chair. And until what time?
Let's say we'll come back at 4:10. Is that all right?
Certainly.
Yeah.
Thank
We'll
you.
adjourn.
Step up,
Ms. Kwinana, when Mr. Nzeku gave evidence at the Commission and in his affidavit that he provided to the Commission, he spoke about being approached by your daughter, Ms. Goniwe. He put that approach in 2016. I understood your evidence earlier to suggest it was earlier than that.
That was my impression, Chair. But if he says they met in 2016, I wouldn't object to that.
Thank you. He also said that when she told him that she had this company that did forex trading, he was attracted by that investment because it would enable him to hedge against the falling rand. Were you aware that that was his interest?
Yes, Chair.
So did she communicate that to you?
She communicated it to me.
Right. So as I understand him, he was interested in the forex trading, and he was going to now use ZanoSpark in order to do that forex trading. Is that right?
Yes, Chair.
Thank you. Now, you mentioned your 8 clients or thereabouts when ZanoSpark was established. For privacy reasons, I'm not going to ask you now to identify those 8 people, but I would like to ask that after today, you just provide an affidavit to the Commission identifying who those clients were, so that we can be in touch with them about their understanding of the arrangement. Are you comfortable doing that?
I'm not comfortable, Chair.
See, the reason why I need to ask that is because when we summoned you, Ms. Mbanjwa, the summons was for really any scrap of paper that existed that could show us the investment statements that went to your clients, the contracts that you concluded with them, updates on their investments. And you've told us today not a single document exists. So there's no record that we can summons to legitimize and give credence to what you're telling us the arrangement was today. So our only option then is just to contact the people who you say are your clients and on behalf of whom you do forex trading. So that's the reason for it. You can consult with your lawyer afterwards and come back to us with your attitude to that. Thank you. We also asked Mr. Nzeku for a single scrap of paper related to this forex investment that he did with you. Chair, you might recall, he initially in his response to the summons said they didn't exist. In evidence, he changed. He said they did exist. He needed 10 days. I said, wouldn't it be quicker?
Yes.
He said 10 days. Well, he gave evidence on the 26th of August. It's now the 3rd of November. Despite repeated engagements with Mr. Nzeku, he seems to have released his former lawyers. They're no longer a point of contact for us. He's not yet notified us of the lawyers he's replaced them with, but there has been no document produced.
He has not finished any document.
Not a document, no.
Yes.
No. Despite repeated
Well, when he
requests.
gave evidence, he was, when he gave his oral evidence, I think he was adamant that there
He
was
was.
some documents.
Indeed.
Receipts, I think.
Yes,
Yeah.
yes. No, actually, as I recall it, he said there were annual investment statements that he
Yes, okay.
received.
Yes.
And there was a little debate about how we'd get them off the emails. I remember thinking it would be quite quick and him resisting that and saying he needed at least 10 days. So you initially gave him 10 days.
Yes.
There have been repeated engagements. So that's strange. Mr. Nzeku thought that he had got annual investment statements out of your company who has no such statements. Do you agree that that's strange?
No, that's not strange.
Oh.
I have been giving him the annual statements.
Yes, so why didn't you produce those when you were summoned to produce them?
Who was summoned? Me.
No, ZanoSpark. ZanoSpark's the entity with which
Yes.
he's doing the trading.
The reason being that the server, as I think I said in my affidavit, was confiscated. However,
I'm sorry, in December, what happened?
I have been sending him the statements. He has got the statements for December 2016, statements for December 2017, for December 2018, I think also December 2019. Yes.
I
So the
just still
question
don't-
was, why didn't you provide those to the commission in response to the summons?
I no longer have them, Chair, because the server, my server, the Kwinana and Associates server, which basically we were also using for Zanospark, was confiscated by the service provider for non-payment. I said that in the affidavit. However, when it was confiscated, we already had printed the statements to Mr. Nzeko.
How long ago was it when it was confiscated?
That was, I think, in February this year, Chair.
February
More or
this
less.
year?
Yes.
Okay.
And
Ms.
that was
Hofmeyr.
because Kwinana and Associates went under, is that right?
Yes, Chair.
So Kwinana and Associates went under in February of this year.
No, I think before that, but the computer was still there until it was confiscated.
Who's your service provider?
Onero,
Could you spell that for me?
Onero.
So Onero is your service provider, and it confiscated. What exactly did it confiscate?
Our server, they were the service provider for the server.
For the server for Kwinana and Associates.
Yes, Chair.
That went under before that.
Yes.
So why would they continue to maintain a server for a company that's gone under?
I don't know, but they went to physically take it in February. So why did they remain not taking it? I don't know.
No, I don't understand. You see, if Kwinana and Associates went under, how did they continue to pay for the services?
That's why they had to take it for non-payment.
No, I don't understand. If I can just be clearer, maybe I'm not being clear. Kwinana and Associates went under some appreciable time back, correct?
Yes, Chair.
I think
Maybe
it
let's
was
give
about-
an estimate
Yeah,
of
when was
when
that?
that might be, more or less, which month would that be, 2019?
I think, Chair, there is a document somewhere here in the bundle, to be exact.
Oh, but what's your recollection so that we can see whether there is a need to go to
I
the,
think maybe 2018.
maybe 2018?
Yes,
Okay,
sure.
all right. I think that might be good enough.
So I think it was about August 2018. Does that jog your memory?
Yeah. Yes.
Okay, so Kwinana and Associates goes under in August of 2018, and it has a service provider, Onero, correct?
Yes, Chair.
Okay, so it stopped operating in August of 2018, is that right?
Yes, Chair.
So how did the service continue to be provided after that?
It continued to be provided on a credit basis, hence they only took it with such a huge liability in February.
So you went on credit from August of 2018.
Yes, Chair.
Who went on credit? Because I understand that Kwinana and Associates went under.
They continued, Chair. They did not physically close off the server.
Right.
They continued.
And you were using it for Zanospark's business, correct?
Yes.
Is that right?
Yes.
Zanospark has not gone under, correct?
Yes, Chair.
So why didn't Zanospark keep paying?
It's because the contract was with Kwinana and Associates.
No, that, with respect, Ms. Kwinana, this is a server critical to your business, right?
Yes.
Okay, so Kwinana and Associates is out of the picture in August of 2018. You need the server to operate your business as Zanospark.
Yes.
Why doesn't Zanospark pay for the service?
Because they had to pay for the huge arrears which they could not afford.
Zanospark couldn't afford.
Yes, to pay for the arrears for Kwinana and Associates.
And you were the director of Kwinana and Associates, and you and your daughter are the directors of Zanospark.
Yes, Chair.
So you decided in your Zanospark directorships not to make good the bill that Kwinana and Associates owed to your service provider, correct?
Not because we did not want to make good, but there was a huge liability in respect of the server, which basically Zanospark could not carry.
Right. Why could Zanospark not carry it?
It's because Zanospark has not made money.
Yes, hasn't made money. We'll come back to that. So you need a server to operate your business at Zanospark. You're using the Kwinana and Associates business server since August of 2018. You don't pay for it at all, and then it gets taken away from you.
Remember to face this side, Ms. Kwinana.
It gets taken away from you in February of this year, correct, for non-payment.
Yes, Chair.
So that just scraps any electronic records of all of these annual statements you provided to Mr. Nzeku, correct?
Not really, Chair. I would still, in December 2020, I will still be in a position to create another statement.
No, I wouldn't like anything to be created now. I'd like to go back to the ones that you say you have in hard copy. Why have those not been furnished to the Commission?
When I printed them, Chair, I gave them to Mr. Nzeku. I didn't know that the ones that I have kept in my server, one day I would not have access to them.
Oh, sorry, so they're not in your possession?
No, Chair.
Oh, I understand. So why would you give him hard copies? When did you give him these hard copies?
On an annual basis, every January.
You would go and take him a hard copy.
Yes, Chair.
Why didn't you email it?
It's because I felt that because of the confidentiality. I do not know if the email is safe enough.
You see, Ms. Kwinana, Mr. Nzeku's evidence before this commission is he received those on email.
Then that is his evidence. I send them, I print them, and send them.
No, you don't send them, you take them, right,
Yes.
as I understand your evidence, because you're afraid that confidentiality of those documents requires you to hand deliver them to Mr. Nzeku. Is that correct?
Yes, Chair.
So you've been to his home, is that correct?
Closer to the mic.
Where do you deliver them in January every year?
I would call and find out where he is, and then go and drop them, maybe in a meeting, maybe at airport, or, yeah, basically.
Is that what you did with all the other clients? You said when Zanospark started, it had about 8 clients.
Yes, Chair, that's what I
Is
do
that
with-
what you did with all of them?
Yes, Chair.
Okay.
Did you hand deliver all the confidential documents relating to SAA and SAA Technical when you were a board member?
Hand deliver them where?
To whoever you were communicating with?
No, SAA has got a company secretariat that does that. And
So-
Zanospark does not have company secretariat.
No. So when you were at SAA and you were communicating with people, co-board members, management, about confidential matters, you were happy to do so on email, correct?
That's their policy, Chair.
Right. But when you are investing some money in Forex trading for your associates, I want to call them associates because you're resisting saying it's members of the public, your associates, you won't email them. Is that right?
Yes, Chair.
How is it different?
It depends.
Why are considerations of confidentiality such that you feel you need to deliver these statements personally to your clients, but when it's confidential matters relating to SAA, you find no problem in emailing people with whom you must be in touch about such information?
It depends, Chair, on the company policy. if
Yes.
SAA required that the documents must be hand-delivered based on the policy.
SAA.
Yes, oh, yes, Chair. So I'm saying it depends on the company policy. At Zanospark, we decided that we are not going to email because the emails do get hacked left, right, and center. And therefore, our policy was that we are not going to email. So SAA, I never received something that says things must not be emailed. So basically, SAA policy would be different in terms of delivering of confidential information from Zanospark.
So you communicated to Mr. Nzeku these confidentiality concerns, did you?
Yes, Chair.
Can you provide us with this policy of Zanospark?
Yeah, can do that.
You
Chair.
can do that. That would be useful. I wonder if you could email it to us. Would you do that?
No, I would have to hand deliver it, Chair, because that's our policy.
Could you make an exception on this occasion?
But there can't be anything confidential about your policy.
No, but
You share it with your clients.
But Chair, even the fact that we do not email the statements, but we hand deliver it to them, basically it's confidentiality itself. So if you want the policy, Ms. Hofmeyer, I will not email it to you. I will print and deliver it to you.
No, we'd
But-
like it on email.
But you have told us publicly what the policy says, so there's nothing confidential about it.
But at least, Chair, I will not be willing to put it down and email it.
No, Ms. Kwinana, can I explain why we want it on email? We would like it on email because if you email it to us, we can do a metadata analysis on it and we can determine when that document was created. Because I need to put it to you that your evidence thus far, will likely argue in due course, is dishonest. Mr. Nzeku came here. He initially said he had no documents, but then when he's finally pushed, he says he gets them annually on email. You have come here today and you tell us that some server related to an old company whose debts you didn't want to take over has been confiscated in February of this year, and so you don't have any record of anything with your clients. But rest assured, you printed out hand-delivered documents of annual statements to hand-deliver them. Ms. Kwinana, I put to you that is nothing short of preposterous. What is your comment?
I'm saying, Chair, I will not be in a position to email it to you. Anyway, the policy that you are looking for, I would have to create it because it has gone with the server.
Yes.
But I know what it entails because I am the one who put it in.
Yeah.
But anyway, I am not going to email it to you because that will be breach of our policy.
Sure. Okay, Ms. Kwinana. Right.
Yeah.
Let's then move to Mr. Nzeku and your understanding of his investment, right? Because he was approached by your daughter in 2016. He's told he can hedge against the rand and he can do so through her company, Zanospark, in respect of which she is doing forex trading, correct?
Yes, Chair.
Right. So then, there's no contract, I assume, that gets drawn up for that, is there?
There is no contract, Chair, but in the investment statement itself,
The one you hand-delivered?
yes.
Yes.
There is some form of, I would say, the contract, so to say.
What does it say?
It's talking about the return on investments and it calculates the illustrative returns on an annual basis. And it also has got the capital amount invested, the illustrative returns, and the total amount. And it also has the terms and conditions.
I'm going to come back to the terms and conditions. Just tell me, how was Mr. Nzeku's investment doing? He starts investing in 2016. How's it done?
You know, with forex trading, Chair, today you're doing well. Today you make 10%. The following day you make 1%. The other day you lose 2%, you lose 5%. So basically it's fluctuation.
Fluctuation. So you've kept trading that money since you received it in the account. Is that right?
Yes, Chair.
So on an annual basis, let's talk about the one you hand-delivered in January 2017. How was he looking at that point with his investment? Overall, I understand their daily fluctuations, but overall, was he up or was he down?
I would say it's a little bit up. It's not that good, but it's a little bit up. It's not as my projection.
What's your mandate from Mr. Nzeku?
The mandate is to invest the money and give it to him with a profit after 5 years.
No. My question is, you get different types of mandates. Are you aware of that? Full discretionary, non-full discretionary mandates. Do you know that?
Yes, Chair.
Yes, because that's what financial service providers are required to be very clear about, so that they don't just do their own thing with other people's money, correct?
Yes, Chair.
So did you have a full discretionary mandate or something less than that?
Yes, Chair, full discretionary
Full
mandate.
discretionary mandate. So you just went onto your platforms whenever you saw fit and you traded his money, correct?
Yes, Chair.
Why did he place that level of trust in you?
He is not the only one who's putting a level of trust in me.
I understand that. That's why we're going to get the names of the other 8 clients. But just tell me about him. Why did he put that level of trust in you?
I don't know. Maybe he would be the one to answer that.
So you never communicated, because as I understood your evidence previously, all you had was a professional relationship with him in which you discussed on occasion transformation issues and BEE initiatives, right? How does he then have the confidence in you, not a financial service provider because you've got no license, right, to put millions of rands with you with a full discretionary mandate?
Why he is trusting me, Chair, I wouldn't know. Maybe he would be the best person to answer that.
Right. So
Is there something you said to him that you think may have given him that level of confidence that made him give you that wide discretion as to what to do with his money?
I don't know, Chair, but what I can confirm is that for him to give me that level of confidence, that means he has seen something in me that maybe he trusted me.
Yes. Okay, Ms. Hoffman.
So I understood you to say that the arrangement was full discretionary mandate for a period of 5 years. Is that right?
Yes, Chair.
We're close to the end of that 5 years. How's his investment looking at the moment?
We are not close to the end of 5 years, Chair. He did not put the money 5 years ago. He has been putting money as and when he feels that he's got some bit of money to invest. So which means, therefore, each investment has got each lifespan.
Oh, I see. So there's a new 5 years for each deposit that he makes,
Yes.
correct? So it would be important to know the date on which the first deposit is made, correct?
Yes, Chair.
Yes, because then you track the 5 years. So let's take the first one, which occurred in June of 2016. That's the one I was thinking of when I said it's quite soon. It'll be June of next year. Tell me how his investment's doing on that.
The first one for Mr. Nzeku is August, Chair.
August next year.
No, it's not. It's June.
I have got August, Chair.
You've got August. Okay, let's
Yes.
take August. Just tell me how that investment's doing.
As I said, Chair, it's not performing as well as I wanted to, but it's doing fairly well.
No, I want some greater clarity there. What was the August investment amount?
I think that was 600,000.
It's 605 to be exact. Right. How much has been lost on that?
No money has been lost.
No money has been lost. Has he made a bit?
Yes, Chair.
Has he always made something?
No.
No. Which ones did he lose on?
No, Chair, you know how forex trading works. If, like for instance, as we are sitting here, there is trading that is going on. And therefore, I wouldn't with confidence to say, now we are sitting at this much. So because forex trading happens 24 hours per day, as I am sitting here.
But you
There
have
are
to decide
trades.
when to buy and sell, don't you?
Yes, Chair. I am, yes, but what happens as I am sitting here, there are pending orders, there are running orders. So basically, as I am sitting here, I have put in the pending orders. That means when the price is at this, then the trade must sell. When the price is like this, the trade must buy. That is one. And then two, then you put the stop losses and take profits. So basically, I may be sitting here with that investment, and I would say maybe the last time I checked, it was about 700,000. 700,000, for instance. I can go back to the platform and find out that it is 1 million, or I can go back and find out that after all it is 400,000. So basically, in forex trading, unlike when you are putting money in the bank, when you are putting money in the bank, you say it is going to earn 5% per annum. Then you know that if you have put in 500, 5% is, if you have put in 100, 5% is 5 rand. And therefore you know that at the end of the year you have 105. But it doesn't work like that with forex trading.
Much more volatile, is that
Yes.
right?
Yes.
Yes.
So basically, it's difficult to say how has it performed or not. How you look at it is when you say, this is the end of 5 years now. And at the end of 5 years, this investment is this much. Then that's when you withdraw it and you close that account. Then that's when you decide whether you have made profit or loss, because it depends on like a second basis, basically, because it changes.
Yes.
Yes.
I can understand that. So it's a highly volatile market to be investing in, correct?
Yes, Chair.
It can move. So as you say, as you sit here today, things might have dropped considerably or raised considerably, correct?
Yes, Chair.
And so you're really only in a position to assess the investment at the end of the 5 years. Is that correct?
Yes, Chair.
What were you putting in your investment statements that you'd hand-delivered to Mr. Nzeku every year then?
I'm putting in the illustrative figures.
Yeah, so give me those now.
Sorry, you're putting in, face
Illustrative.
this side, please. Yeah, you're putting in?
Illustrative figures.
Oh, okay.
And what are those?
I don't remember them now as I am sitting here, Chair.
But what I asked you to do was just tell me now, like you told him each January, how his investment was doing, how his investment is doing. And I understood you to say you can't do that because it's too volatile and you can only estimate it, well, you can only determine it at the end of the 5 years. So can't you do for me now? You said that the 605,000 that was invested in August made a little bit. I wanted to know which of them he'd lost on as you sit here today.
When I checked, Chair, it had made a little bit. I do not know now how much it is, and therefore I will not be able to tell you. And I will also not be able to tell you the illustrative ones until I have a look at the statement. Yes.
And that's because his money is invested in platforms in respect of which there's a lot of movement at any point. Is that right?
Yes, Chair.
So you need to stop it at a point to get a proper sense of whether he's up or down, correct?
Yes, Chair.
And that happens at the 5 years, correct?
Yes, Chair.
Right. Let me just go back one step, which is that this volatility suggests to me it's a very risky investment, correct?
It is, Chair. It's high risk, it's high rewards.
Do you remember what the FSCA said in its affidavit about the concerns it had about parties engaging in these platforms and not being told about the levels of risk?
Of course, Chair, you cannot not tell the person about the level of risk.
It's
And
also,
in fact,
Sorry, you cannot?
you cannot not tell the person about the level of risk.
Yes.
Because it is high risk. And in fact, I would tell my clients, most of my clients are the members of my family. I would tell them that you need to put the money there, that you will not commit suicide when
If you lost it
yes,
all.
if you lose it. And in fact, that is exactly how I put it. And in fact, that's also what I said to Mr. Nzeku and Ms. Hendricks, to say this is volatile, it's high risk, it's high returns. And what Mr. Nzeku said, he said both of them, they are prepared to take the risk. The reason why they are prepared to take the risk is that, and they know that I do not need a license to do that. They said the reason why they are prepared to take the risk is because even with formalized businesses which would have the license, like for instance, he made an example of Steinhoff, where people had invested in it thinking that it's a good investment and their monies were wiped off. He made an example of the Enron, who went under, and it was a listed company. So basically, he knew exactly what he was going through. We are not saying his money is lost. We are saying if they can lose that money, they know exactly, because we told them the risks of volatility, including my own money. I have lost money in Forex trading. I have gained money in Forex trading, but I never lost my mind, because that is the risk I know, and that is the risk I was prepared to take.
And so this was what, 2016, when you had this discussion with Mr. Nzeku?
Yes.
And he was referring to Steinhoff.
He was referring to, I think that was 2016, Chair.
Okay, all right.
and
Hoffmeyer.
thank you, Chair. Just, the server is interesting me. You said it was confiscated in February this year, is that right?
Yes, Chair.
Have you taken steps to get a new server for your business?
No, not yet.
No, not yet. Why not?
It's because basically with the platform that we are using, a very reliable platform, there has not been that much need for a server, unlike with the audit firm, where basically you need to keep the files for a period of 5 years, others for a period of 7 years. And therefore, the server basically is not that important for the type of the business that you are in.
So you just left the confiscation when it happened in February of 2020, correct?
Yes, Chair.
And if Onero had just contacted the Commission and told us that it didn't confiscate your server in February of 2020, would you say that Onero is giving us a false piece of information now?
It may not necessarily be February, but if they say they confiscated the server on this date, I would agree with them. But if they said they never confiscated the server, then I would not agree with them.
But why
So
do you say
basically,
February
I would-
2020?
That's what I think.
Oh, okay. But you accept you might be wrong about that?
I might be wrong about that.
Okay, let's then go to what actually happens in the Zanospark bank account. Right, you open it with 500 Rand. Okay, then you get a first payment into it, and we need to go to DD 26 at page 189 for that. DD 26 is Mr. Nzeku's bundle.
Will somebody, oh, yeah, okay.
Oh, apologies, A. And it's page, I said 189. Oh, sorry, no, it's not 189. Let me get that right. No, we need to go to the JM Aviation, sorry, the Zanospark bank account. I do apologize. Let's start there. That is 104. Apologies. Okay, so you had about 8 clients, as I understand it, when the business starts in February 2016. Is that correct?
Yes, Chair.
Okay. So we start with the opening bank statement, which is dated 15 March 2016 to 15 April 2016. Do you see that?
Yes, Chair.
At page 104. And if you turn over the page, you'll see there's the credit of 500 Rand. That's what you've confirmed was deposited initially in the account, correct?
Yes,
okay. Then if we track it forward, we will see the receipts from your other clients. Is that right? Because you said to us we don't have Mr. Nzeku investing until August. Is that right?
Chair, there won't be the receipts from other clients here. How the Forex trading platform operates. You put the money into the platform.
Closer to the mic, come closer to the
You
mic.
put the money in the platform. You don't put it in the bank, Chair. You put the money in the trading platform. And therefore, you won't see the money here. And therefore, you will not see the clients here. So basically, that's how it works.
Oh, I see. So, sorry, so I misunderstood. So, you don't see the client's money in this bank account, right?
Yes, Chair.
You just put it onto the platform. Is that
Yes.
correct? That's you. You do that.
Yes, Chair.
Right. How do you get the money from the client to put on the platform?
It depends, Chair, on the arrangements. As I said, some of them would be put through my credit card, and then I pay IC Markets directly. Some of them would be put in my personal account, and then I put it in IC Markets, or I put it in Alcon Trader, or I put it in Luno.
Yes.
Some of them would directly put it in Luno and Alcon Trader. others would open the platform accounts and then give me the login details to trade for them. So basically, it depends on the level of the involvement that the investor wants.
So they wouldn't be depositing it in Zanospark's account. They'd either, as I understand your evidence, I don't know, pay you somehow into your personal account so you can put it through your credit card. Is that right?
That's one of them.
That's one way. The other way is that they do it directly onto the platform, but give you login details so you can trade for them. Is that correct?
Yes, sure.
Is there any other way than those two? Because I've heard you reference credit card and I've heard you've referenced directly onto the platform.
There's also direct payment into Alcon Trader or Skrill or Luno.
Right, but what's clear, and you must forgive me for misunderstanding this, I thought we would see the deposits into the Zanospark account, but that's not how it happens, correct?
No, okay.
Right. Happens.
And in fact, even their profits, you will not see them here.
Right, right. They live somewhere else,
Yes,
correct?
yes.
So the money doesn't come in here, you don't see the profits here because there's another arrangement, correct?
Yes, sure.
And it's going to be your personal account or your credit card or them directly onto the platform, correct?
Yes, sure.
Right.
Well,
And also into Alcon Trader, which basically is like the Bitcoin bank account.
Yes, exactly.
Yes.
We'll come to Altcoin shortly, don't worry.
well, I wanted to say, I think I must give up, Ms. Hofmeyer. Ms. Kwinana likes looking at you
Oh,
more than
sorry,
looking at me.
Chair.
Sorry, Chair.
Since yesterday, I've been saying she must
No.
look this side. She's
We're
much more
terribly
interested-
engaged.
she's
We're
much
very
more
engaged.
interested in
I
you.
do. I'll try and remind Ms.
She's
Kwinana.
giving me her back.
Yeah,
Sorry,
it's
Chair.
terrible.
Sorry, apologies.
It's terrible. I always say to witnesses, try and, as you've done, turn the chair so that it reminds you actually to whom your evidence is given. But nonetheless, okay, so we won't see it in Zanospark. That's not how it's done. It comes directly to you, credit card or your personal account, correct?
Yes, Chair.
Okay, so that's why I shouldn't be surprised that this bank account starts on the 15th of March and there's just nothing coming into it, despite the fact that you have your clients. Is that right?
Yes, Chair.
And it goes from March to April and I still see no movement, correct?
Yes, Chair.
Yeah. And then we get from March to, April to May, still no movement. There is literally 501 Rand and 37 cents in this account. No movement, but you're doing a lot of Forex trading for your other clients. And then we do, however, see 2.5 million come into the account at page 111. Why is 2.5 million suddenly coming into the account if that's not the way your Forex trading is done?
I said, Chair, that is one of them.
I'm
No,
sorry.
you did not.
I'm sorry, Ms. Hofmeyer. You said 111, eh?
Yes,
And the amount, did you say?
2.5 million.
Okay, there I can see it. Okay, all right, thank you.
You see, Ms. Kwinana has just said it was one of the ways, and I was just going to stop her and say, no, that wasn't your evidence a moment ago. You see, I was so careful about that evidence. I repeated it about 3 times. I have to confess, I bored myself in doing so. But it was so important for me to get absolutely clear from you, Ms. Kwinana, as you give evidence under oath in this commission, how this Forex trading happens for your clients. So 3 times I said to you, we won't see it in the Zanospark account. We will see it in your personal account through your credit card or directly onto the platform. But now you've been presented with a page that shows a 2.5 million Rand coming into the account, and you are now about to change your version. So tell us what your version has now become, please.
I'm not changing my version, Chair. I am saying I counted the ways in which to fund the platform.
No, I asked you how the Forex
sorry,
trading took place.
Just repeat.
I counted the ways in which to fund the platform. I said, firstly, you fund it through your credit card, and then the credit card, what would happen? I would get money from my personal account and put it in the credit card and fund. That is
This is business money
yes, Chair.
that you put into your personal credit
Yes,
card.
Chair. It happens like that. Yes. And then I put it in my personal account, and then I put it in my credit card account, and then it goes to IC Markets. That basically, so that is when you fund it directly into IC Markets. And then I said, you can also take this money from the account and pay it into Alcon Trader
From which
No.
account?
from Zanospark, or from any account, even my personal account, I do that.
Sorry, Ms. Kwinana, if I can say, the record will show you were absolutely clear that you didn't take the money from the Zanospark account, but please continue.
No, Chair. I have been saying I have calculated the ways in which the money reaches the platform.
No, my question to you is, how does Forex trading take place? And I specifically emphasize, how do you get the money with which to trade? And the record will show that too. But let's not detain ourselves. Let's have your version.
I'm sorry, let her finish how she was explaining. Just finish how you were explaining, Ms. Kwinana.
Thank you, Chair. I was telling the evidence leader how the money gets into the platform. This is how it happens. There are many ways in which the money gets into the platform. It's not one way. I counted Skrill. I counted Alcon Trader. I counted Luno. So basically those ones, and in fact also them, I can get money from wherever. I can get money from my credit card. I can get money from my personal account. I can get money from the business account. The main aim is for the money to be in the platform.
Yes. I wonder how quickly they could rewind to your questions and the answers, how quick that would be.
I'm not sure, Chair. You know what might be useful
Yeah.
is we could possibly continue a bit. And we could actually do that tomorrow morning because
yeah.
would that be convenient?
That's
Because
fine,
then we
yeah.
can certainly,
Yeah,
thank you, Chair.
That's fine, yeah.
So let's leave that for a moment. Let's now focus at page
I'm sorry.
Yes.
Ms. Mbanjwa?
Thank you.
Oh, you're
The
not
way I
available
understand
tomorrow.
it, yes, I don't want to mislead the commission.
Okay,
The way
okay.
I understand it, we were set down, we were scheduled for 2 days.
Yes.
Yes, that was just the reminder. Thank you, Chair.
Okay. Yeah, I think the contemplation was that we would finish today. But certainly I was also thinking, obviously, depending on your availability tomorrow morning, that maybe before we start with the next witness, if we don't finish this evening, we could continue for hopefully finish before lunch. But if you are not available, I think other arrangements will have to be made.
No, thank you, Chair. I regret, Chair, but I've already scheduled appointments.
No,
and I
that's
think
fine.
I also have a trial, not
Yes.
tomorrow, but the other day. Thank you, Chair.
No, that's fine. I think it should be easy to schedule for an evening session one of the days.
Thank you, Chair. We'll no doubt communicate with Ms.
Yes.
Mbanjwa after today. Thank you for
Yes,
that.
okay.
So if we're at page 111, tell us about this 2.5 million.
I'm sorry, maybe in the light of that, we might have to
Revisit.
play it this sometime before we leave while
Well, can I ask that?
while everything is fresh with everybody's.
Maybe what we do is we just find out whether it's feasible at all, and I
Yes.
can be just given a note if somebody will look into
Yes.
that, and
Yeah.
then I can judge it as
That's
we're
right.
moving through, just to
At
not
some
lose
stage, yeah.
time at this point.
Yeah, okay, all right.
So we're at page 111, and there's this deposit of 2.5 million. So what is that?
That is the forex trading investment from Ms. Hendricks.
And who's Miss Hendricks?
Ms. Hendricks, at the time, I knew her to be Mr. Nzeku's colleague.
His colleague.
Sorry?
I knew her to be Mr. Nzeku's colleague.
Okay.
And so was this an investment for Mr. Nzeku?
She didn't say so. That's why also the statement, the investment statement, is saying it's for her.
For her?
Yes.
Right. It's not for Mr. Nzeku?
Yes, Chair.
No. So you have a separate arrangement with her, correct?
Yes, Chair.
And what is the mandate there?
It's the same because she wanted to invest in forex trading.
So how did she come to learn of this available trading?
I was thinking that she got it from Mr. Nzeku because that is Mr. Nzeku who knows what we are doing. So when Lumka told me that Ms. Hendricks has put in the money and Ms. Hendricks is Mr. Nzeku's colleague, it came to my mind that she had it from him.
Yes. So did you have communications with her about what the investment involved?
The communication between Ms. Hendricks and Zanospark is through Lumka.
Your daughter, Ms. Goniwe, is that
Yes,
right?
yes.
So she told her all about the risks, correct?
Yes, she knows.
And she communicated to Ms. Goniwe, that's Ms. Hendricks communicated to Ms. Goniwe that it was her money that she was investing, correct?
Yes, sir.
So she needed a separate contract and arrangement, correct?
Yes, sir.
Do you know that Mr. Nzeku's evidence was that she was investing for him?
That should be their arrangement.
No, it's not their arrangement because it's very important that you know who your client is. You see, and that's why this is such a regulated field. You are going onto highly volatile platforms on your own evidence. You've got a full discretionary mandate, and this is 2.5 million from her. So it's absolutely critical that you know who the client is, who you're receiving instructions from, who you're contracting with. Did you do any know your client investigations that are required under FICA before these arrangements were set up?
Yes, Chair.
You did.
Yes.
So you've got FICA documents for Ms. Hendricks.
I've got FICA documents, Chair.
And so she was your client. Did you understand that? Yes. And there's some other arrangement that happened between her and Mr. Nzeku.
That I am not party to.
Yes. But she came to you because of Mr. Nzeku, correct?
Yes, I think so.
No, you've just given evidence that said you inferred that when Ms. Goniwe said she'd been in touch and indicated that she got that from Mr. Nzeku. Did I have your evidence correct?
That's what Lumka said.
Yes.
Yeah, I think she was not stating it as a fact. She was
Yes.
saying she was thinking so. Is that right?
Yes.
Is that what you're saying, Ms. Kwinana? Or were you stating it as a fact that she heard from Mr. Nzeku about your services?
Who, Lumka?
Ms. Hendricks.
Oh, Ms. Hendricks? Yes.
She told you that she heard from him, or you
No,
just inferred?
Lumka told me that Ms. Hendricks, who is a colleague of Mr. Nzeku, has deposited the money that she wants to be invested in forex trading.
Yes, but the question is, how did she know about your services? Did you think that she had heard about you from Mr. Nzeku, or did she tell you or your daughter that she heard about your services from Mr. Nzeku?
My daughter told me that Ms. Hendricks, that's why she knew that it was Mr. Nzeku's colleague, because Ms. Hendricks said she heard from Mr. Nzeku.
Okay, all right.
understood from your evidence earlier, you quite keen to emphasize that you don't provide these services to the public generally, correct?
Yes, Chair.
It's people with whom you have a particular association, is that correct?
Yes.
So, Ms. Hendricks, have you ever met her?
If she is a colleague of Vuyo, and she called my daughter, and my daughter told me, and we did do the know your client, I really do not take her as the member of the public.
I see.
The question was, have you ever met her?
Me, I never met her,
Okay.
Who met her?
Lumka.
And it was then her association with Mr. Nzeku that made you comfortable to take her on as a client, is that right?
Yes, Chair.
Okay. So she deposits 2.5 million, that's on the 1st of July. We saw that at page 111.
Yes, Chair.
And the next, so nothing else is happening in the bank account. The next thing that happens is, if you go to page 113, she deposits another amount of 600,000, correct?
Yes, Chair.
And that's now taking the balance up to 3.1, is that right?
Yes, Chair.
And now what trading are you doing for her pursuant to your contract?
It's the same thing, Chair.
So you need to now invest on the platforms in order to do the trading, correct?
Yes, Chair.
And how do you do that if no money is being taken from the account?
You will notice that somewhere in subsequent months, the money is taken from here. The reason being that when the money comes in, I just would not put it in the platform because also, as I said, the trading is volatile. And sometimes, like for instance, with US diesel, in 2017, December 2017, $1 was 11 rand 47 cents. And about a few, 2 or 3 months ago, the $1 was 19 rand 40, or even 1990 something. So basically, when you get money for forex trading, you do not just put it in the for trading, because you need to wait for the right moment to strike. So basically, that is the reason why you will find that sometimes the money sits for months or weeks, and then sometimes the money is put in the platform or something.
So when was the right moment to strike for Ms. Hendricks?
I would have to check it in the platform, Chair. I would not say I put the money on this date. I definitely would not say that.
No, but just whereabouts. She starts investing because she's interested in forex trading on the 1st of July 2016. When was it the right time to invest?
Chair, I need to check when did I start to invest that in forex trading.
But you were investing for other clients at the time, were you not?
Yes.
Yes. So why was it the time for them but not the time for her?
When you enter the trade, Chair, it depends on the market at the time. So the fact that in other clients I had put in, maybe, let's say for example, I use the simple pair like USD-JPY, for instance, and USD, which is well known in South Africa. So if I decide that I will put your money in USD, I will put somebody else's money in gold. I will put somebody else's money in NASDAQ. I will put somebody else's money in AUD-JPY, for instance. And therefore, it depends when the market is right for that particular pair. And in fact, I would not put everybody's money in one pair, for instance. So basically, when you say, when was it the right time for Ms. Hendricks to put it there, it's difficult for me to say this is when I put it, because another thing, I don't have Ms. Hendricks as the client only, so it would be difficult. I would say, for instance, I put it in October, and only to find out that I am not telling the truth, because the money that I put it in October is for another client. So I do not know when did I put Ms. Hendricks' money. I would have to check the platform.
So is your evidence that at any point in time you're not aware of whose client's money you're dealing with?
I am aware of whose monies I'm dealing with, but I do not know when did I enter the market for that particular client until I check the platform.
Why would that be so? Ms. Hendricks gives you 3.1 million by the end of July. How do you not know when you started investing her money in Forex trading?
I'm not saying, Chair, I do not know. I'm saying, as I am sitting here, I do not know. And I am not going to tell you when did I invest the money.
So at some point, how will you earmark what's been invested for Ms. Hendricks?
How would I earmark?
Yes, how do you know which is Ms. Hendricks' money and not Mr. Nzeku's money?
The platform has got account numbers. Yes. So I know that this account number belongs to this client.
Right. So
Would it be correct, I'm sorry, Ms. Hoffman, would it be correct that to say you would work on the principle that once a client has given you his or her money, you need to invest it at the earliest opportunity, so as soon as possible? You should avoid delays.
Not with Forex trading, Chair,
Yeah,
but with the bank, because you would be losing some interest.
yes.
That is definite. But with
Yes.
Forex trading,
Yes,
you need to wait for the right moment.
or you have to watch how the markets
Yes, Chair.
are doing.
Yes, Chair.
Oh, okay. Ms. Hoffman?
So at some point, the money comes out of this account and goes into a platform for Ms. Hendricks, correct?
Yes, Chair.
Okay, and she'll have her own account number, is that right?
Yes, Chair.
And I understand you to say, what you can't do today is tell me when that is, correct?
Yes, Chair.
Could you tell me approximately, like a year, you've only got 8 clients. Ms. Hendricks, you held it for a year or 2 or 3. Can you give me any indication like that?
No, Chair. No, I wouldn't.
Okay.
Just talking about saying that you wouldn't necessarily have to invest it as soon as possible after the client has given you the money. I wonder to what extent that's important or that's a valid point, because as I understand it, if you are talking about 5 years, during that 5 years, that money is going to be subject to the volatility of the markets. It can go down, it can go up. So why does it matter whether if you get the money now today from the client, whether you deposit it tomorrow or next week? Because in the end, during that 5-year period, anything can happen. So why shouldn't you deposit immediately?
Chair, how the Forex trading analysis happens, as I made an example of USD ZAR, when I said in December 2017, $1 was 11 Rand 47 cents. And I think in September, October this year, $1 was 19 Rand 47 or 90 Rand 80 cents. So basically, what I would do, depending on the strategy that I am taking, and in 5 years I take a long-term strategy, then I would say, let me wait in this example of USGSA. I would say, I knew that the rand, the dollar at some stage was 19 Rand 80 cents. And then now, as it is, the dollar is 16 Rand 40 cents, somewhere there these days. And then I knew that in 2017, it was 11 Rand 47 cents. So I can decide to say, I will only invest, I will only put the trading when the rand is sitting. Now I know that it's going down because it's coming from 19. But I know that it's still going to go up and test the market. And therefore, I can decide that I put a pending order where the dollar is 19 Rand 50 cents. And then maybe put also the pending order to buy when when $1 is 11 Rand 47 cents, because I know even if it is after 3 years, it's going to go down to 11 Rand and test the trough, and it will also test the highest. So basically, if it is now sitting at 16, I can decide that I will not do anything until it is there where I know that I will earn the biggest money. So basically, that's why I'm saying, unlike when you put money in the bank, when you put money in the bank, you know that you will earn 10% per annum.
Yeah.
So the sooner you get that money and put it in the bank, the better. But
Yeah.
it doesn't happen like that with forex trading. So that's
Yes.
why they say forex trading requires a lot of patience. You cannot just come in
Yes,
otherwise.
no, that's fine. Ms. Hofmeyer?
Thank you, Chair. So you received the 2.5 million from Ms. Hendricks, and you received the 600 first.
Yes, Chair.
And you can't tell us now when you invested it first on the platform, correct?
Yes, Chair.
But it would, just help me with the mechanics, it would need to be taken out of the account to facilitate it being invested on the platform, is that right?
Yes, Chair.
So if we could see when it was taken out of the account, it would then go onto the platform, correct?
Yes, Chair.
Okay, so maybe the bank account will help us with that, because she puts in 2.5, she puts in 605, we then have a total, if you go to page 117, of about 3.7. Then there's another credit. And Ms. Kwinana, just confirm, nothing else is happening in this account, correct?
Yes, Chair.
Yes. There's Ms. Hendricks, 2 payments. Sorry, then there is another, there's one with a description, JM Aviation. So now what happens? Why is JM Aviation suddenly depositing money?
JM Aviation, that was when Mr. Nzeku started to do the investment. And he required exactly the same, because he said, he promised Lumka that as and when he has money, he is going to invest. So now, that is when he started to do his first investment.
Right. Despite his evidence that he was investing earlier. Is that right?
Pardon?
His evidence was that he was investing earlier just through Ms. Hendricks.
Oh, okay.
But you don't know that.
I don't know that. And as a result, I have been sending statements to Ms. Hendricks.
Right. Hand delivering.
Yes.
Yes. Okay, so then JM Aviation puts 605,000. Why was JM Aviation depositing it if the agreement was with Mr. Nzeku?
He said to me, JM Aviation is paying him. for his directorship.
And then JM Aviation pays another amount at page 117 of 600,000. And then there is, that money is taken out of the account, right?
Yes.
So that would then be, as I understood your evidence earlier, when it is invested. Is that correct?
Yes, Chair.
Yes. So by that stage, you've got just Ms. Hendricks and Mr. Nzeku's money in this account, and then you take it out and you invest it on the platforms, correct?
No, I did not take it out and invested it in the platform. I took it out and invested it elsewhere whilst I was waiting for the market. Because now I'm thinking that if the money is sitting here and there is an opportunity, I also do like maybe property speculation. Like for instance, I go to auctions, and then if there is a property that...
You don't mean you took their money which they wanted you to invest in A and you took it and invested in B? You don't mean that, do you?
No, remember, Chair, that they gave me the confidence to say I can invest it in forex trading. And in
Yes,
fact,
but
yes, Chair.
they didn't say you can invest it.
No, Chair, they said I can invest it in forex trading and in any investment that I deem necessary, as long...
Oh, is that what they said? They added that as well?
Yes, Chair.
You didn't say that before,
That is also there in their statements, Chair.
but you didn't say that before.
No.
Oh, then let's add that, Chair, because that's what...
But also that you were talking about Ms. Nzegu. You never said you had that discussion with Ms. Hendricks, did you?
I had that discussion, Chair, and in fact
With
with
Ms.
all my
Hendricks?
clients, and in fact, Chair, with all my clients.
With Ms. Hendricks?
Yeah, I never met with Ms. Hendricks, but they know because the statements that we have is that we can invest in forex trading and in any other thing that we deem fit. And in fact,
Ms. Kwinana, you said you had a discussion with them. This is what they said. And you never said that about Ms. Nzegu before. It's new. If you are including Ms. Nzegu in terms of such a discussion, that's new. You didn't say it before. Whatever you said in regard to Mr. Nzegu, with whom you had a discussion, with whom you had a lot of interactions, but not with Ms. Hendricks, as far as I remember.
yes, not with Hendricks. I never met with Ms. Hendricks.
Yes, and you never had such a discussion with her.
I never had such a discussion with Ms. Hendricks.
Yes.
However, Lumka knows that we invest in forex trading, we invest in property speculation, we invest in venture capital. Like for instance, if a person has got a tender that he is unable to finance, if we have money, we do that. And then, so basically, we invest it in anything. And in fact,
But
our
Ms.
clients-
Hendricks never gave you that mandate in terms of your own evidence.
okay, the evidence, therefore, Chair, should include the fact that with all our clients, they gave us, they are confident in us, and then they gave us the leeway to say, invest in whatever you feel like investing in. But our main aim is the investment in forex trading, followed by the investment in properties.
Right.
Oh.
Sorry.
Yes, Ms. Hofmeyr?
No, it's just the problem with that is that Mr. Nzeku's evidence under oath before this commission is that he wanted to hedge against the falling rand, and that is why he wanted investment in forex. You don't hedge against the falling rand by buying properties. Ms. Kwinana, the only basis that Mr. Nzeku, a supplier to SAA Technical at the time that he starts paying money into your account, his reason for doing so is that he wanted to trade in Forex so he could hedge against the falling rand. You are now telling me that he entered into a contract with you that said you could invest in whatever you wanted, including property, that would stay in rands. Is that your version?
Let me repeat, Chair. My clients give me money.
I'm sorry, is your hand up or have you been
Yeah.
covered?
It is still up, Chair.
Yeah, yes.
Yes, thank you, Chair. I just wanted to refer to a question that Ms. Hofmeyer. I agree with you, Chair, when that question was asked, it was not concerning Ms. Hendricks. But I just want to remind, there was a question that Ms. Hofmeyer asked the witness. He said, what was the nature of your mandate? And then she said she had a full discretionary mandate, which according to my instructions mean that because before.
No, don't say what it means.
Thank you.
Because you'll now be
Assisting the client.
assisting the witness.
And before that question, the witness had said that she was investing in a number of things, and then Ms. Hofmeyer had said, but the main thing was Forex. I'm just putting a reminder to that.
Okay,
Thank you, Chair.
let's continue, Ms. Hoffman.
Indeed, the record will show precisely the evidence that Ms. Kwinana has given earlier today. And what I'm putting to you now is your own description of what you were entitled to do with Mr. Nzeku's money is inconsistent with Mr. Nzeku's evidence to this commission of why he gave you money. Do you have a response to that?
Chair, I will stick to my evidence. I will let Mr. Nzeku stick to his evidence.
So what did you do with that 4.3 million that was taken out of the account that we just saw?
Not with the 4.3, Chair. I added some money, I think maybe $1 million, and paid it over to the lawyers to buy the property that was, I think that was on auction.
Well, let's just stop. Remember, 4.3 only comes from Ms. Hendricks and JM Aviation.
Yes, Chair.
Correct. You said you added it to some money. Is that correct?
I added some money, yes.
Where did that other money come from?
I think maybe it came from Kwinana and Associates. Yeah, most probably from Kwinana and Associates.
It didn't come from a supplier to SAA Technical.
No,
You're certain about that?
100%.
Okay. So you take 4.3 out, then you add some money, right?
Yes.
Which didn't come from a supplier to SAA Technical.
No.
It came from Kwinana and Associates. Is
Yes,
that
I
right?
think so.
Okay. This is 2016, about September, and then you take those two amounts and you buy a property. Is that what happens?
Yes, Chair.
And that was consistent with your mandate with Mr. Nzeku and Ms. Hendricks. Is that your version?
Yes, Chair.
What happened with that property that you bought?
I sold it and put back the money into Zanospark.
In whose name was the property registered once it had been purchased?
I wouldn't remember, Chair, but what we do to manage the risk, if, for instance, you buy a property in another entity, and then another property in another entity. So basically, the reason being that you want to, that's part of the risk management. And therefore, the property will not be, and another thing, these properties are for speculation purposes. So the property is not gonna stay long anyway. So the registration of that property basically would be would not be that material in terms of what you want to do. But I understand maybe with you who is not speculating in properties, you would want your property to be registered in your name. But because we do not keep these properties for a long time, and most of the time, you even tender for this property on auction, and then before it gets even registered, you have already sold it to the other person. So which means that the ownership has not even taken hands between you who have invested, because it has moved from one old owner to the new old owner. So basically that is how property speculation goes.
So you bought property on auction? Is that what you said?
Yes.
With the money?
Yes, it's either, Chair, on auction, or basically that would either be on auction or would be on dilapidated properties, or maybe I would be phoned by the agent to say, here is a person who is selling her property because he needs money now, so the person is selling it at a good price because he wants to sell now. So basically it depends on when, how you get the property. So sometimes it would be on auction, sometimes it would be on distressed property, sometimes it would be...
So you can't remember which one it was with this particular property?
No, Chair.
Yes.
But I have since sold it and put back the money in Zanospark, and then from Zanospark, when the market was right, I had to take it into the forex trading.
That property was never registered in the name of Kwinana and Associates?
No, Chair, Kwinana and Associates never had any
Zanospark, Chair,
properties.
because that's the company we now
Oh,
dealing
yes.
with,
Well, yeah, but it was a combination of money from Kwinana and Associates, isn't it? And money from
Yes,
Zanospark?
and money from Zanospark.
Yes.
Yes.
But it was not registered in the name of either?
No, Chair.
Yes. Was it ever registered, and it was not registered in your name,
No, Chair.
and nor in your daughter's name?
No, Chair. I think
There was no change in the ownership. There was no transfer of ownership.
there
after-
was the transfer of ownership, but what I know, what I can still remember is that it was not in the name of the two companies.
Was it in the name of another entity of your choice?
Yes, Chair, it could be in another entity of my choice, because I also manage many properties, Chair.
So you used money that you took from the account of Zanospark and money from Kwinana and Associates,
Yeah,
and then bought this property.
and speculate in property.
Yeah, and then the property was registered in the name of some other entity
Yes,
that you chose.
yes.
Was it an entity in
Yes,
which
I
you
think
had an interest?
Yes, that would be an entity that I
In
had
which you
an
had an interest?
Yes.
Would you have been the sole director or shareholder or member if it was a CC, or would there have been other?
I think, Chair, it was registered in the name of a trust, but I do not know what's the name of a trust. I would have to check that.
Have you got many trusts in which you serve?
Yes, Chair.
Oh,
And if it was, just to follow up, if it was a trust, there would be beneficiaries of that trust, correct?
Yes, Chair.
And the beneficiaries, because this is not your money, as I understand it, the
Yes, Chair.
beneficiaries of the trust would then appropriately be Ms. Hendricks,
Entitled.
Mr. Nzeku, and maybe Kwinana and Associates, correct?
No, Chair, because this is for speculative purposes. That's why I am saying I can register it in any name. Sometimes I do not even have to register it because it will exchange hands.
Yes,
from
but a trust has to be registered, isn't it? And a trust it is a requirement that there should be beneficiaries, isn't it? It's a legal requirement.
Yes, Chair.
And
The trust that in whose name this property was registered, who were the beneficiaries?
I would have to check there, Chair, which trust was that? But definitely, for speculation.
Was it a family trust?
Yes, Chair. But Chair, for the purposes of speculation, it does not have to be registered. And I can even buy a shelf company.
The trust that you are talking about, you say was not registered?
No, the trust would be registered.
Yes, and you said the property was registered in the name of that trust.
Yes, and then was also when we sold it, when the time was right,
Yes,
it was registered in somebody else.
yes. Well, if it was registered in the trust in the name of a trust, and then it was later taken out, it would be interesting to know whether it was now a donation by the trust to somebody or whether it was sold. It might be quite a complicated thing. How did it?
It's not complicated.
How did it get removed from the trust? Did the trust sell it? Because once it was in the name of the trust, it was owned by the trust.
Yes.
So how did it
well,
get out? Was it sold to somebody or donated to somebody?
It's a simple accounting transaction, Chair. When the trust.
Well, before there is an accounting, there is a legal requirement.
Yes.
If you register a property in the name of a trust,
Yes.
the trust owns that property.
Yes, Chair.
If now the trust is going to cease to be the owner of that property,
Then the trust
there's
sells.
a legal transaction. Either you sell the property or you donate the property. I don't know if there's something else. There is counsel who can advise me.
I'm stuck with sell and donate at this point.
So
do you know whether it was sold or donated?
Sold.
Sold.
Chair, when the trust, that's why I'm saying it's simple when you put it in accounting terms, because when the property is bought by the trust, the property gets registered in the name of a trust. And then when the property is sold, the property is deregistered. So basically, the accounting transaction there would be when the property gets into the trust, then you debit that property, then you credit a creditor. In this case, a creditor would be Zanospark and Kwinana and Associates. And then, yes, and then now when the property is sold, then you credit the property, you debit bank, and then with the bank, you pay Zanospark, you pay Kwinana and Associates, and
You pay VAT, you pay all the taxes,
you pay transfers. Yes, all of that.
Ms. Hofmeyer, please
If
continue.
this was Mr.
I'm sure there'll be a purchase and sale agreement
Indeed.
Yes,
that can be, yeah, okay.
Yes, you see, none of this you provided to the Commission before today, did you, Ms. Kwinana?
Didn't you get it from Banjo Incorporated?
No, certainly not.
Didn't your investigators get it from Banjo? I think they did get it from Banjo Incorporated.
The purchase of this property with the 4.3 million, no, we have never until this moment in your evidence been told by you that you took the 4.3 million that Ms. Hendricks and Mr. Nzeku invested with Zanospark to buy a property. You have never told us that.
But I thought your investigation was following money, and that's exactly where you were supposed to land.
No. You were required to tell this commission everything you know about the payments made. I'll read you the directive from the chairperson of this commission. The payments made by JM Aviation, Ms. Hendricks and Mr. Nzeku to you in your personal capacity or to Zanospark Limited during the time that you served as a board member of SAA and SAA Technical and since then. That is a directive from the chairperson of this commission that asks you to tell him everything you know about that. You gave us 4 paragraphs, right? One of those paragraphs, I will tell you now, is inconsistent with your evidence today. And, well, your revised evidence. One of those paragraphs in your affidavit to this commission in response to the chairperson's directive is, quote, the payments made by Ms. Hendricks to Zanospark was for investment purposes through Forex trading.
Yes.
Yes,
exactly.
that is how you started. Then your evidence moved to include property investment, other investments. But here you say it's investment through Forex trading. So on your own version, you could not take any of her 3.1 million and put it in property, correct?
But the money is in Forex trading as we speak. That's why I'm saying.
No,
that the chair-
Ms. Kwinana, don't run away from the question. Ms. Hofmeyer is saying to you, you have now told me that the money that Ms. Hendricks gave you, you could use by investing it in property. It was not just Forex trading only, but she says in your affidavit, you only talked about Forex trading. You didn't mention property, investment in property. And she is therefore saying what you said in the affidavit is inconsistent with what you are saying now. What do you say about that?
Or maybe, Chair, what I should have said, therefore, is to say the money received from Ms. Hendricks was ultimately invested in Forex trading.
Ms. Hofmeyer?
Chair, we are very close to the end. I wonder if I can indicate why the balance of the 4.3 million that made up the additional million came from a supplier from SAA Technical, and then we can, it'll be fairly quick.
Yeah.
Okay. The way that we need to do that, Ms. Kwinana, is, remember we saw in the Zanospark account that 4.3 or thereabouts went out. Do you remember seeing that?
Yes, Chair.
Okay. So that, let me just get this right, actually doesn't go to you. It goes to another account of Zanospark. Were you aware of that?
I can't remember, Chair. Maybe it's fine.
Okay. Why did it have to go? It went to the business account. So it went from the main Zanospark account to a gold business account and then to you. Why did it need to go through those accounts?
I would have to check that, Chair. Why would it have to go from one account to another?
Doesn't make sense, does it?
And in fact, for me, if it goes from Zanospark account to another Zanospark account, really to me it's immaterial because it's 2 Zanospark accounts.
Right. But on the same day it went to you. I'm just querying, why do you need to route it through 2 accounts?
I'm sure there was some reason for
Some
that,
good reason.
but considering that they were both Zanospark accounts, for me it's really immaterial.
Right. Then let's just go to your bundle, which is DD 33. And there, at page 67,
Which bundle is that?
DD 33, Chair. It's Ms. Kwinana's main bundle.
Okay.
Page?
67. That's a copy of, oh, sorry, Ms. Kwinana, do you have it?
Yes, Chair.
That's a copy of your own personal bank account, correct?
Yes, Chair.
And you see at the bottom of page 67, you get a total of 5,234,400. Is that right?
Yes, Chair.
That's the one that comes from the Zanospark business account.
Yes, Chair.
Okay. So then we need, because remember, we only had 4.3 from Mr. Nzeko and Ms. Hendricks, but there's more here.
Yes.
And I understood your evidence to be that is what makes up the balance is something that came from Kwinana and Associates, correct?
Yes.
Yes. Okay, but let's see actually where it came from. So for that, we need to go to page 78. Okay, so what happens is now, there are so many bank accounts, it's very confusing. Now we're in, let's start at 77, the Zanospark savings account. Okay, business account, current account, savings account. We're in the savings account, again, not much movement. It seems it has a zero opening balance. Do you see at page 78?
Yes, Chair.
Yes. And then do you see there's a payment on the 15th of July that says loan and 29th of July that says loan. Do you see that?
Yes, Chair.
So it's 700,000 Rand loan and a 119,000 Rand loan. What were those loans for?
I would have to check, Chair, what were these loans for? And where do they come from?
So you don't know about a loan of 819,000 Rand that came into the company of which you and your daughter were the sole directors in July of 2016?
As I am sitting here, Chair, I don't remember it, but definitely I would have to check the bank statements and see where it came from.
Did you ever receive a loan from a supplier to SAA Technical?
A loan from a supplier from SAA Technical.
Yeah.
No, Chair.
No, you couldn't really, could you? I mean, you were the chair of the board of SAA Technical. Imagine a supplier is giving you a loan. That would be highly irregular, wouldn't it?
Yes, Chair.
It would be even more irregular, I put to you, if a supplier was paying you money with no strings attached, correct?
Yes, Chair.
So those two amounts came into the savings account from an entity called Janipath. Do you know what Janipath is?
Janipath belongs to Miss Ndileka Nobaka. Okay. What Miss Nobaka did, she was also one of the...
Do you just want to give the spelling for the name and the surname?
Ndileka, Ndileka. The surname is Nobaxa.
Okay, all right.
Yes. Yes, I remember, Chair. Ndileka got an RFQ. She told me that she got an RFQ from SAA Technical, and she wanted
An
money.
RFQ, request for quotations.
Quotation.
Yeah.
Yes. And then now she was awarded this RFQ. And then she did not have money to finance this RFQ. And I also did not have money. She came to me. We go together at church. And then she came to me to borrow the money. She said she wanted 700,000. there was an urgent supply. I did not have the money, but what I said to her, I said, there is a potential investor who indicated to me that he is also interested in forex trading. And then I can she must speak to him. And then if she needs my recommendation, I will do that. And she spoke to Mr. Kolisi of BMK. And then Mr. Kolisi, of course,
BMK, are those attorneys?
BMK.
Is
or
it a firm of
BKM,
attorneys?
BMK. I think it's BMK.
Yes, it's a firm of attorneys.
Yes.
Yes.
Okay.
Yes. So Ms. Nobaka called the CEO or MD of BMK, Mbuleli Kolisi, because it is Kolisi who indicated that he will have money to invest. And then Ms. Nobaka called and said she is referred to me, she has got this tender that she needed to service. And therefore, and then Mr. Kolisi called me and said, do I know this person? And then I said, yes, I know. And then he said, can I trust her? And then because she seemed to be desperate, because now when you got a tender and you are unable to service it, you will not get that opportunity. So Mr. Kolisi gave her the 700. And then now, when it was due for payment, and in fact, Ms. Nobaka, I think when she called, it was maybe, I think, beginning of July, when she called me and said, I do not have money, then she can go there. And then I said to Mr. Kolisi, if you can please assist, I trust her. She's, we go together in church, and therefore she is not going to run away. I also know where she lives, and therefore she's not going to run away. And then I said, why don't you say, you said to me, you are interested in investing, and there is some money that you can invest, so you can give him that money. And then Ms. Kolisi gave her the money. And then when the money was due for payment, and in fact, this money was paid on the 15th of July. I think it did not even take 10 days or 15 days. Then Mr. Kolisi said, you need to pay that money for the investment. And therefore that is, and then now that is the 700. This 700, basically, that is the money that Mr. Kolisi also invested. And then now the 119, Mr. Kolisi said, I will give you the money plus interest. So basically, when Ms. Nobaka paid this money to me, it was on the instructions of Mr. Kolisi, because Ms. Nobaka had borrowed the money from him.
And the 119,000? You were saying something about it?
The 119 is interest, because he said, I cannot just give out the money without an interest. So I am going to, in fact, he also told me that he is going to charge, he said he wanted to charge 30%. And then I said, oh, Shem, she is an emerging person. Why don't you charge, say, 10%? And then they reached a compromise of 17%. So basically, the 19,119 is the 17%.
So who actually paid the money into this account? Who paid 700,000 into this account?
That is Ndileka,
You say on the instructions of Mr. Kolisi.
on the instruction of Mr. Kolisi.
And who paid 119,000 rand?
That's also Ndileka, paying interest on the 700.
Yes, Ms. of Mayor.
Chair, we are at 5 to 6. This is new to me, so it's probably an appropriate time for us to take the adjournment.
Yes.
We can investigate further, and Ms. Kwinana will be returning at some point.
Yes. Subject to whatever further investigation may need to be done, I had in mind that I was going to check with all concerned whether there is a chance that we could have Ms. Kwinana return for an evening session sometime this week. But I say that fully aware that, Ms. of Mayor, you will have been standing the whole day. So if you say no, it would be difficult, it's fine. But I also say that knowing that Ms. Mbanjwa said tomorrow she's busy, so but it would be on the basis that it would be after 4, maybe 5. But we could look at next week, but I wouldn't like us to go too far, if possible. What do you think, Ms. Hofmeyer?
Chair.
Maybe this week might be difficult.
It may be difficult, but I'm just wondering if we could get a sense of Ms. Mbanjwa and Ms. Kwinana's availability for the remainder of the week, even maybe in the days. I'm not certain how long the evidence of the next witness would take. So
Yes.
it may be possible that we could slot them in on Friday or even Thursday. My challenge is availability after this week is extremely
it's
limited.
difficult,
So it would be
So you
helpful.
prefer this week as well?
I do think so, yes. Indeed.
Yes, Ms. Mbanjwa, how is your situation for the rest of the week?
Chair, please, I don't want to be taken as being a bad person here. I've got a matter in court, and then I'm also drafting an application for leave to appeal, and my days are running out. So this week, during the day, it is totally out for me, but I know that I need to accommodate the commission. So I can maybe look, I don't know, on a Friday, is Friday evening bad for the commission?
I can sit, we can have, from my side, we can have an evening session on Friday.
I think then that evening would help. And I really don't, I'm not prepared, of course, subject to the chairperson, I'm not being rude, but I don't want to be told that we should come here and then after the other witness, because I believe that the witness is Dudumye. And then I wait for her to be finished, because I must put it on record, Chair. I was very bitter about the last time I was asked to come here when Ms. Memela was testifying.
Yes.
Because what happened is we were told, even when we were on the way, that we must rush, we must be here at 9. And we rushed, we were here at 9. Then when we were on our way, we were told that please don't miss 9 o'clock. We arrive here. Then the first thing I say to Ms. Hofmeyer, because I see there's a witness there, I said, but why were we being pressurized when it is known that there's another witness?
Yeah.
Because this is not correct. And then all that Ms. Hofmeyer said, I said, I will complain to the chair. She said, go make your complaints. Not even an apology. And then, as you know, Chair, we sat here the whole day, and I didn't receive an apology. And that is not the way we normally get treated, even by judges of the High Court. If there's a problem with time, and I'm just an attendant, I'm not an important person, but there's always an apology to say, sorry about the issue of time, I can't accommodate you. Those who can't be accommodated must leave. So during Ms. Myenis, I'm really not prepared. In the evening, because I know it's my duty to cooperate with the commission, I'm prepared to avail myself.
Yeah, no, that's fine. I think that it's important that if at all possible, we should do it in the evening. How is Friday evening for you, Ms. Hofmeyer?
That should be fine, Chair.
That should be fine. Okay, should we, Ms. Kwinana, is that fine with you?
Can we do it on weekend, Chair?
Sorry?
Can we do it on weekend, Chair? On weekend?
You're not available on Friday evening,
No, Chair.
but you would be available on Saturday if we were to sit on Saturday.
Yes, Chair.
I would also be available. Chair,
Would
on
also be
Saturday.
available.
Yes, Chair.
Ms. Mayor, I don't know about my own situation, but I'm just checking.
I don't actually either. I am going to have to possibly just make an inquiry. The weekend will be difficult for me. I can see if I can move certain things.
What about Thursday evening this week, Ms. Mbandra? Is that difficult for you?
It's difficult, Chair, because what I intended to do, I need to file the application for leave to attend.
Oh, so you wanted to work on
So I was
that.
hoping I will draft.
Yes.
It's a pity because I just had 2 agenda applications.
No,
this
no,
week.
that's fine.
That was my
That's
fault.
fine. Ms. Kwinana, if Saturday is going to be difficult, I said I'm not sure about my own situation about Saturday, but I appreciate that everybody is trying to see how we can accommodate one another. Is your Friday evening, would there be any chance that you might be able to move things on Friday evening?
It's not possible, Chair, on Friday. I can also avail myself on Sunday.
You can avail yourself anytime during the weekend.
Yes, Chair.
Yes, no, that's appreciated.
And what we can also just say, Chair, because I think there's a lady, I think she's Miss Shannon. Though I don't normally look at WhatsApp, but if they send me a message, we can arrange anything next week in the evening. We will really try because we know we need to finish.
I know you were saying, Ms. Hofmeyer, you know that beyond this week, it's going to be difficult for you. Is it completely impossible, or you
it's
could work on something?
a bit more impossible than the weekend. So I think I'd be better placed to move things around on the weekend if your position was such, Chair, that we could take a Saturday morning slot.
Yeah.
But I will make plans. So
Yes.
if the weekend is not convenient for you, Chair, then I
Yes.
will see what I can do next week.
Yes. Well, I think that because I'm also keen that we try and finalize, I think that I will try and make a plan about Saturday. Maybe let's work on the basis that let's continue on Saturday morning.
And at what time, Chair, would be convenient?
Is it fine if we start at 9:30?
Certainly from
Would
my
that be
side.
fine?
It's fine with me,
So,
Chair.
Ms. Kwinana?
It's fine, Chair.
Do it fine. Okay, let's say we'll continue in this venue on Saturday, this coming Saturday at 9:30.
Thank you, Chair.
Okay, all right. So we are going to adjourn for the day, but otherwise we are adjourning Ms. Kwinana's evidence to Saturday at 9:30.
We're
We
indebted.
adjourn.
Thank you, Chair.
Thank you.
All rise.
Sorry, guys. You are young for us. We're too old for weekends. It makes no difference.